Tabling of documents. The Honourable Parliamentary Secretary to the Minister of Foreign Affairs.
Thank you, Mr. Speaker. Mr. Speaker, pursuant to Standing Order 32.2 and consistent with the current policy on the tabling of treaties in Parliament, I have the honour to table in both official languages the treaty entitled Agreement between the Government of Canada and the Government of the United Kingdom of Great Britain and Northern Ireland concerning air services, done at Leipzig on May 18th, 2022. Thank you, Mr. Speaker.
Dépôt de projet de loi émanant du...
Introduction of government bills.
Statements by ministers. Rapport.
Reports from interparliamentary delegations.
Presenting reports from committees. Dépôt de...
Introduction of private members' bills.
First reading of Senate public bills. Motion. Presenting petitions. Présentation de pétition. The Honourable Member for Peace River Westlock.
Well, thank you, Mr. Chair, and good morning. I have the honour to present a number of petitions this morning. The first one is coming from Canadians from across the country who are concerned about the ease of access of sexually explicit material to young persons. They're concerned about the significant proportion of sexually explicit material available online is extremely degrading and not suitable for young people. They're also very concerned about porn companies are not doing anything to ensure that young people are not getting access to this material. So they call on, they also note that Parliament recognized the harm of the increased of accessibility to sexually explicit material online for young persons in a report back in 2017. They say that online age verification technology is increasingly getting sophisticated and less intrusive, that can be done without invading privacy rights, and so they're calling on the Government of Canada to and this Parliament to adopt Bill S. 210 due with haste. The next petition I have, Mr. Chair, is from Canadians from across the country who are concerned about the continued COVID-19 restrictions and mandates continuing to be in place. They note that they are at this point suspended. They're calling for an abolition to the vaccine passport requirements for all Canadian citizens and permanent residents taking domestic flights. They note comments from the WestJet Chief Medical Officer who noted that particularly on aircraft there had not been any known cases of COVID-19 transmission, and they've noted that Canada was of one of the last countries to remove these or to suspend these restrictions, and they're calling for a full removal of these restrictions and mandates. The next petition I have, Mr. Chair, is from Canadians from across the country who are concerned about the damaging noise levels that come from the repeated use of firearms. They note that in Canada, Canada is the only G6 nation in the world that bans health and safety products, particularly sound moderators. They're the only health and safety mechanism that is illegal in Canada. They also confirm that the Bedford versus Canada case says that Canada should be able to take, or Canadians should be able to take reasonable steps to improve personal safety in hazardous situations. They note that most of Europe, it's mandatory to use sound moderators on your firearms. They note that sound moderators also facilitate increased or less friction between animal husbandry and sports shooters. It is also better for your hunting companions, your pets, those kind of things. And they also note that hearing damage is significantly reduces your quality of life and public health, costing taxpayers millions of dollars annually. Therefore, the folks that have signed this petition are calling the Canadian government to take a stand and to remove the prohibition of sound moderators from the criminal code and allow legal acquisition and possession and use of sound moderators on firearms by all legal licensed firearms owners in Canada. And they call on the provinces and territories to amend their legislation around this as well. The final petition I'll present today, Mr. Chair, is from Canadians from across the country who are concerned about coercion, intimidation, and other forms of pressure used to force physicians and healthcare workers and health care institutions to become parties to assisted suicide or euthanasia, either directly or through effective referral. This is a violation of people's fundamental rights, freedom of conscience. They note that the Canadian Medical Association confirms that there's over 24,000 physicians across the country who are willing to perform MAID, and therefore there would be no need to force physicians who are not interested in performing MAID to comply with that. So they also note that the Section 2 of the Charter of Rights and Freedoms protects freedom of conscience. Therefore, they call on the Government of Canada and this Parliament to enshrine in the Criminal Code the protection of conscience rights for physicians and healthcare workers to ensure that they are not coerced or intimidated into performing euthanasia or assisted suicide. Thank you, Mr. Chair.
Presenting petitions, the Honourable Member for Winnipeg North.
Thank you, Mr. Speaker. Today I'm tabling a petition in regards to health care. Many of the constituents of Winnipeg North want the House of Commons, in particular Prime Minister, and in fact all members from different political parties, to realize and recognize the importance of Canada's Health Act. They emphasize the 5 basic principles of public administration: comprehensiveness, universality, portability, and accessibility. And they're emphasizing that there is a role for the national government to play on issues such as mental health, cancer care, long-term care, and just recognizing how important there is for national health standards, Mr. Speaker. And so it's with pleasure that I table this petition. Thank you.
Presenting petitions, the Honourable Member for New Westminster Burnaby.
Well, thank you very much, Mr. Speaker. I'm pleased to present a petition on behalf of 74 British Columbians who add their names to the thousands upon thousands of Canadians who have already petitioned the House of Commons and the government, Mr. Speaker. And what those Canadians are asking for is a Green New Deal for Canada. These petitioners are saying that Canadians are living through unprecedented, catastrophic climate events, and we've certainly seen this in British Columbia with the heat dome, with the atmospheric rivers. And they're saying that our society is also suffering from worsening socioeconomic inequalities. These petitioners are talking about Indigenous peoples, frontline and vulnerable communities who are being disproportionately affected, resulting in increased risks to their health and well-being. And so these petitioners are calling on the Government of Canada to support motion M1, a Made in Canada Green New Deal, which is a motion that I brought forward in Parliament on behalf of the NDP, Mr. Speaker. It's an initiative that calls on Canada to take bold action to confront the challenge that is represented by climate change, and ending fossil fuel subsidies, closing offshore tax havens, and supporting workers impacted by the transition, creating well-paying, unionized jobs in the shift to a clean and renewable energy economy. Thank you, Mr. Speaker.
Presenting petitions, présentation de pétitions. Questions on the order paper, the Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. I would ask that all questions be allowed to stand at this time, please.
Agreed and so ordered. Orders of the day.
Government orders, Government Bills Senate, resuming debate at second reading of Bill S4, an act to amend the Criminal Code and the Identification of Criminals Act, and to make related amendments to other acts, COVID-19 response, and other measures.
Resuming debate, the Honourable Member, or the Honourable Parliamentary Secretary to the Government House Leader has 9 minutes remaining, and then questions after that. The Honourable Parliamentary Secretary.
Wonderful. Thank you very much, Mr. Speaker. It's such a pleasure to be able to speak on legislation. Once again, the government's providing very progressive legislation that will make a real difference in our judicial system. I very much would like to emphasize just how important it is when you take a look in terms of Canada as a society and how we're envied around the world. And one of the reasons for that, Mr. Speaker, is because we understand the importance of judicial independence. You have the political realm, and you have our judicial, the rule of law. And these are the types of things in which I believe around the world Canada is actually recognized for and held in fairly high esteem. In fact, you'll find many jurisdictions around the world will come and look at the system that Canada has. So whether it is our Constitution, Charter of Rights, how our judicial system is so successful in terms of providing that insurance, that public confidence, that the system that we have is really second to no other. If I was to use a personal example, Mr. Speaker, I would make reference to my father. many years ago when, after he had went on to personal disabilities and was unable to go to work, he took a great deal of time and made it a hobby in terms of going to our courts and listening to the proceedings. And what I found is that over the months in which he was there virtually on a full-time basis, Mr. Speaker, is that his confidence in the system grew, where to the point in which he had a wonderful relationship with a number of judges and attorneys, both on the Crown side and on the defense side. I think he had a very good understanding. And I use that as an example because I believe that ultimately, if people had a good assessment in terms of what takes place in our judicial system, that it would add to the public confidence. Personally, myself, as a chair of a justice committee for many years, as a youth justice committee, I had the privilege of being able to work with the balance, the community needs and the community desires, and the need for some form of a consequence or a disposition that was fair to all sides, including victims and, of course, the perpetrator, Madam Speaker. Again, through that experience, you gain a deeper respect for our judicial system and why it is so important that we recognize that the judicial system needs to be independent of politics. Fast forward, let's go to the pandemic. And we have heard, whether it's the Prime Minister or many of my Liberal colleagues here on the floor of the House, or even members from all sides, recognizing that there are things that occurred during the pandemic that I believe that we can all learn from. A good example of that is Zoom. You know, 3 years ago, 3.5 years ago, I didn't even know Zoom existed. Madam Speaker, now it's a major part of my life. And I can tell you, Madam Speaker, even if you look at the House of Commons and the bringing in of the hybrid system, where now we can have a member of Parliament from British Columbia, as an example, that is serving his constituents, his or her constituents, in their riding, and at the same time appear on the floor of the House of Commons. So why is that relevant to this particular piece of legislation? Because that's what this legislation, in essence, is about. We're taking a look at ways in which we can improve our judicial system. We're saying that during the pandemic, that there were certain aspects of our judicial system that incorporated a more virtual contribution to the delivery of justice, Madam Speaker. And that is the essence of what it is that this bill is actually doing. It's important to recognize whether it's accessibility, efficient, and effective. Three fundamental pillars I would suggest to you when we talk about justice. We need to strive for that, Madam Speaker, and that is something in which we as government have been doing virtually from day one with a number of substantial pieces of legislation to look at ways in which we can make our judicial system even that much better, that much stronger, Madam Speaker. So if we take a look at S4, and what we have seen over the last couple of years, we have seen the courts have a desire, and when I say the courts, I mean it in the very broader sense of the word, all the different stakeholders that are at play. Whether, as I say, it's victims, perpetrators, lawyers, the court clerks, to sheriffs, everyone that would be involved, Madam Speaker. I suspect that you would find universal acceptance to the need for changing, for modernization. And that's the essence of S4. If I was to describe it, by saying S4 proposes a range of reforms that will make court proceedings more flexible while protecting the rights of all participants, Madam Speaker. So what it does is it enables presentations of different forms to come in the form of a video conference, Madam Speaker. And I think, you know, as we look at the whole issue of modernization and how things change through time, I would suggest to you that there is an obligation on all of us to look at ways in which we can support our court system, our courts or our judicial system. And it is not unique. In fact, you know, members will recall Rona Ambrose's piece of legislation is a private member's bill, where there was recommendations that were going that as legislators we felt would be of the best interest of our judicial system. And what we found, Madam Speaker, is in changing those rules or changing the law that ensured that there was an educational component in terms of sexual violence. What quickly happened is after the former member and leader of the Conservative Party brought forward the legislation, ultimately we couldn't get it passed through the private members system, that the government actually then took the initiative and made it happen, Madam Speaker. And there was unanimous support for it. Now, yesterday, during the debate on S4, we started to see the same thing. Members of the Conservative Party, the Bloc Party, and the NDP, and when I posed it to the members of the Green Party, at least the leader of the Green Party, indicated support, Madam Speaker. So it seems to me that once again, we've achieved, what I can see, unanimous support for progressive legislation that's going to help us in modernizing our court system. Now, I would encourage all members that this has been around for a while. There's no reason why we couldn't see it go to committee and listen to the stakeholders. I know there's a great number of stakeholders that are waiting to see this legislation advance, and hopefully we will do that, Madam Speaker. I see you're telling me my time has expired. Hopefully there might be a question or two. Thank you, Madam Speaker.
Questions and comments? The Honourable Member Courtney Alberni.
Well, thank you, Madam Speaker. And we agree that we don't know why the government's taken so long to retable this bill that was first introduced in the last Parliament, especially given the circumstances that we know there's a huge backlog in Canada's justice system. It's not a new issue. So my question, Madam Speaker, is a means of addressing court backlogs, why did the government oppose Recommendation 1 of the House of Commons Standing Committee on Justice and Human Rights 2017 report on access to justice, legal aid, which called on the federal government to remove the legal aid funds currently included in the Canada Social Transfer in favor of a specific earmarked civil legal aid fund for provinces administered under the Department of Justice Canada Legal Aid Program?
Honourable Parliamentary Secretary.
Two questions, and let me provide some detail on both. In regards to the issue of legal aid and the financing of legal aid, we need to recognize that you have jurisdictional responsibilities both at the federal and the provincial level. And when you think in terms of legal aid, that there is an obligation with the federal government to work with the different provincial jurisdictions. So I don't know if that will satisfy the member in terms of is the answer, but that's the reality, that there is a sense of obligation that's there to work with the different provincial entities, and I just don't know the more detailed background work that has been done on that with that, Madam Speaker. In regards to S4 and its previous as a government piece of legislation, I already see you give me the wind up, Madam Speaker, very quickly. The original legislation came out through the House of Commons. One of the ways in which we can ensure that we can get it passed is to have the support, and the Senate has been fantastic in ensuring that we could have the legislation before us today, and hopefully we'll be able to get it through even quicker. Thank you, Madam Speaker.
L'honorable député de Beauport-Limoilou.
The Honourable Member for Beauport-Limoilou. Thank you, Madam Speaker. My colleague across the way can't say that I'm never in agreement with him because, in general, when it comes to S4, I agree with him. That said, there are some issues that S4 does not address. It does address some issues. For example, if there's a connection issue, then we can revert to traditional standard mode. That said, there are many unoccupied vacant judge positions at the Conditional Release Commission, and I'm wondering when that will be fixed. When will it be ensured that judges appointed are not appointed for partisan reasons? Thank you.
Parliamentary Secretary.
Well, first of all, Madam Speaker, I can assure the member that judges today that are appointed are not appointed on political basis. There is a process that's been in place, and the government is very careful in terms of the manner in which judicial judges are in fact appointed. And I believe that was one of the changes that was put into place back in 2015 when the Prime Minister was actually elected as Prime Minister and instructed with the Minister of Justice at the time. And I see that as a very strong positive. In fact, if you were to take a look at the judicial appointments, judges that have been appointed to the different chambers, you will find that there's a better cross-selection of a reflection of what our society actually looks like. I would suggest to you, Madam Speaker, that the government of the day has done a first-class job in terms of judicial appointments, and I'm anticipating that we will continue to see that, as we're very much aware of the importance of ensuring that as much as possible we're getting justice as quickly as possible.
The Honourable Parliamentary Secretary to the Minister for Rural Economic Development. Thank you, Madam Speaker. Here's my question for my colleague. Our government has worked on internet networks since 2015, more so than any group before. So today we have technological advancements that are possible, which weren't possible in 2015. We have also made a commitment to have 98% of the population connected to the internet by 2026. Which is very soon. So how does the colleague feel this relates to S4?
Well, I can tell you, Madam Speaker, my colleague and friend has been a very strong advocate for rural connections with the internet, and just talking with him prior to standing up and addressing the legislation, how he talked about how the province of Quebec was able to utilize what it is that we're actually suggesting, and we know that in many ways Quebec does lead the country on many different progressive issues, and it's one of the reasons why I think, at least as us as a national caucus, always keep a close eye in terms of what our Quebec members of Parliament are saying. Madam Speaker, we recognize that through time things change. Technology, internet has played such a profound impact on society, second probably to very few others, if any, in terms of just the way in which society evolves, has seen internet interplayed with everyone in Canada. Today it's an essential service, and it would be wrong for us not to look at ways in which we can use that technology to modernize, whether it's our judicial system, the House of Commons, or anything else. Thank you, Madam Speaker.
Comments? The Honourable Member for Fundy Royal.
Well, thank you, Madam Speaker. And I listened to the member's speech, and he mentioned the need for an urgency to pass this particular piece of legislation. Now, there was a previous version of this legislation, Bill C-23, that was introduced back in 2021. And as the member knows, because he knows about the procedures and how this place works, when there's an election, it wipes clean the slate of all the bills that are currently on the order paper. So I guess my question to him, he's concerned about urgency. Did he express his concern to the Prime Minister before he called the snap election in 2021 and wiped this bill completely off the radar?
Parliamentary Secretary.
Yes, thank you, Madam Speaker. There's a number of factors that have to be calculated into a call of a federal election, whether it was the opposition's behavior in terms of playing obstruction and not allowing anything to pass. Canadians should not be fooled to believe that the Conservative Party was even going to be prepared to allow that legislation to pass. We'll have to wait and see in terms of what takes place with the S4. What I'm suggesting, Madam Speaker, in my comments earlier, is that we once again have unanimous support. It would appear that every member of the House of Commons is going to be supporting the legislation, but typically, and hopefully it won't happen on this legislation, fingers crossed, let's put in a prayer, hopefully the Conservatives will allow this legislation to pass without time allocation, but only time will prevail, and we'll find out at that time. Thank you, Madam Speaker.
Time for another question. Questions et commentaires. The honourable member Leeds, Grenville, Thousand Islands and Rideau Lakes.
Well, thanks very much, Madam Speaker. And though the intervention by the Parliamentary Secretary was very interesting, and that member does take the occasion to speak to a lot of legislation, and he speaks at length. And so, well, I hear that he's concerned that members of the opposition want to speak to the legislation. That member just offered a 20-minute stream of consciousness experiment for Canadians to follow. And so I'm just wondering if he's so eager to have this legislation pass, why he wouldn't have maybe shortened his remarks for the benefit of all concerned.
The Honourable Parliamentary Secretary, the Government House Leader.
Well, Madam Speaker, in order to be able to facilitate additional debate time so that the member opposite would be able to speak, the government has offered the opposition the opportunity to sit till midnight. And if the opposition does feel that they would like to have more debate on this legislation, I would invite them to approach the Government House Leader and say, look, we have X number of members that would like to speak. Maybe we can sit till midnight. Many Canadians from coast to coast to coast actually work past 6:30. I would suggest that the Conservative Party acknowledge that fact and be prepared to debate late into the evening, Madam Speaker, where if there is more people that would like to be able to speak to legislation in which it's virtually unanimous, you will find that I am exceptionally and can be exceptionally accommodating to ensure that some form of discussion, whether it's here at second reading or at the committee stage or ultimately third reading, there's plenty of opportunities for members to be able to speak, but there's a good number of stakeholders that are out there that are anxious to see the legislation ultimately pass. And if everyone's supporting it, Madam Speaker, I would suggest to you, why not allow the legislation to go forward so at the very least we can have Canadians provide their direct input during a committee stage. I appreciate the question. Thank you, Madam Speaker.
Resuming debate, the Honourable Member Fundy Royal.
Thank you, Madam Speaker, and it's a privilege to be able to rise today to join in the debate on Bill S4, an act to amend the Criminal Code and the Identification of Criminals Act and to make related amendments to other acts. As has been mentioned during the course of this debate, we've heard the government speak about the urgency of the passage of this legislation. But some of the measures in here certainly were required long before the COVID pandemic. And there's others that raise some concerns about justice, particularly when it comes to respect for victims of crime. And I'll include in that victims and their families, Madam Speaker. 10 times in S4, it's mentioned the consent of the offender. 10 times. So let's contrast that. How many times in S4 does it mention the consent of a victim, the consent of a victim's family in proceeding by way other than an in-person meeting? The answer, not surprisingly, Madam Speaker, is 0. Not once does this bill mention the consent of the victim or their family, all the while speaking to the consent of an offender. And I'd love to say, I'm surprised, or maybe there's something we're missing here, but the fact is, this is in line with the overall agenda of this government when it comes to our criminal justice system. We only have to look at the bills that have come before this House. We only have to look at the response, selective response, to certain Supreme Court of Canada decisions to realize that this is a government that does not put the rights of victims first. Use an example, Madam Speaker. Right now we saw yesterday in the Public Safety Committee grand expansion of the law when it comes to going after law-abiding citizens, duck hunters, our constituents, all of our collective constituents who are law-abiding firearms owners. They do this in the name of combating crime. So we're targeting non-criminals in an effort to combat crime. But Madam Speaker, if you speak to the experts, if you speak to police, if you speak to big city mayors, they will tell us the source of illegal firearms, the source of firearms that are being used by gangs is our border, our porous border, and the illegal importation of firearms. So knowing that the illegal trafficking and importation of firearms is the cause of the firearms being on the street and not law-abiding citizens, it would lead you to a logical conclusion that we should target that illegal importation. But in direct contrast to what the government's doing on Bill C-22, which is targeting duck hunters, targeting farmers, targeting sport shooters, people who are not criminals, people who are not a threat. What are we doing about the real threat? What are we doing about the importers, the traffickers? Well, there's another bill that was just passed through the Senate, Bill C-5. What that bill does is it says if you have trafficked in a firearm, if you used a firearm in the commission of offense, if you used a firearm in extortion, if you've fired a firearm with intent, that you no longer, as the case has been for years, you no longer have to serve time in jail. You can go back onto the street. You can go back into the community where you committed the offense. Now, where did this law come from that said you have to serve time in jail if you commit these offenses? Did it come from the previous Conservative government? The government would love for you to believe that that tough on crime measure came from the previous Conservative government. But if you bother to look at the facts, the evidence says all of those mandatory penalties were in place since the 70s, since the time of the Prime Minister's father being Prime Minister. Some of them were introduced when the Prime Minister's father was both Prime Minister and Justice Minister. And the Supreme Court recently, Madam Speaker, ruled, because the government loves to say, the Liberals love to say, oh, these are unconstitutional mandatory penalties. Well, what does the Supreme Court have to say about this? There's a recent case just a couple weeks ago involving a mandatory penalty for drug trafficking. And the Supreme Court considered that. It considered the seriousness of in our communities, of the crisis, whether it's fentanyl or cocaine or heroin. The government of the day, it was a Conservative government. And I'm proud to say, in an effort to combat those crimes, we said if you're going to traffic or produce or import these serious drugs, that you're going to have to serve actual time in jail. And the government has said in Bill C-5, no, we don't believe that. We believe these people should be able to be back on the street. What did the Supreme Court of Canada say? The Supreme Court of Canada upheld those provisions. They said they are constitutional, that the seriousness of these offenses, when weighed with Parliament's legislative prerogative, is that Parliament was entitled, and it was indeed constitutional for us to have brought in that measure that says if you import, traffic, or produce cocaine or fentanyl or heroin, then you're gonna go to jail. You're gonna be taken off the street. Now, does soft on crime work? Does, I've heard it called hug a thug, soft on crime, a revolving door justice system where you commit a crime, there's no consequences, you go back on the street. Does that work? Does that approach work? Well, again, why don't we look at the evidence? The evidence, as was just released this week, not by us, not by the Conservative Party, by Statistics Canada. The evidence says that the homicide rate in Canada has increased for 3 consecutive years. The homicide rate in Canada is at the highest rate it's been since 2005. Now, why is 2005 significant? Well, 2005 was the last year of the previous Liberal government. The Conservative government came in 2006, and yes, we had an agenda to straighten out our justice system, to respect victims, to put victims at the forefront, to say to serious offenders, recidivist. What's a recidivist? A recidivist is someone who commits a crime, gets caught, gets tried in a court of law, gets sentenced, whether to jail time or house arrest, back on the street, and does the same thing again and again and again. That's recidivism. And you know, the courts have said, and we've said, that we have to focus on criminals. And we did that. Now, if over the last 7 years, we've seen of Liberal government. Madam Speaker, the number I'm about to say, the percentage I'm about to say, should shock all of us in this room and should shock all Canadians. The violent crime rate in Canada since 2015 has increased 32%. That is not acceptable. That is in our rural communities. That is, I should remind members that 2015 is the year that the Liberal government was elected. Soft on crime doesn't work in our rural communities, in our suburbs, in our big cities, across this country. We are seeing people who are victimizing, whether it's property crime, whether it's serious violent crime, whether it's sexual offenses. We are seeing people who should be approached in a tougher manner, being let back out on the street to commit the same offenses, and it has resulted in a 32% increase in violent crime. Is that me saying that? No. That's Statistics Canada. They produce statistics on these things, and that's evidence. And we should take evidence into account when we look at what works and what doesn't. Because I feel, and I know my Conservative colleagues feel, that one of our top priorities as members of Parliament should be the protection of innocent Canadians, the protection of families in our communities, the protection of our communities. And does that mean that we don't think that offenders should get the help they need, that those struggling with addiction should get the help that they need? Of course they should. But we're not doing our communities any favors, and we're not doing offenders any favors by having zero consequence for serious offenses. Now, in Bill S4, as I mentioned, Madam Speaker, 10 times it mentions the consent of the offender. In my own riding, we have a serious story from years ago. A young woman, 16 years old, working in her father's grocery store, was murdered by an offender. That offender received a life sentence. Her father became an advocate for victims of crime. And I met with him many times. He was a counselor in one of our communities. And he spoke passionately about ways governments could support victims of crime. And when we were in government, we acted on some of his recommendations and other victims of crime's recommendations. When his family would travel to Quebec for parole hearings, because to support that loved one who had lost her life all those years ago in the 80s, they would go every 2 years to these parole hearings. And you know, there was times that they would have traveled to Quebec, they would have driven 10 hours, and the offender would cancel the parole hearing. And they would have to go back home not having had the parole hearing. They recommended many ways. And in this same case was just in the news in the last month when Corrections Canada said, by the way, without notifying the family, I should say, by the way, that individual that every 2 years you've been there in person trying to keep them behind bars where they belong, he's on the loose and we don't know where he is. And obviously, that caused great concern for this family. And the offender is now back in custody, but still eligible for parole hearings every other year. And those parole hearings, Madam Speaker, whether in person or virtual, they continue to re-victimize families. And that is one of the principal reasons why one of the proudest pieces of legislation in my career as a parliamentarian that we brought forward as a conservative government was respect for each individual victim's life in the case of mass murderers. And we brought in legislation that said, you know, in Canada, when someone gets a life sentence, some people mistakenly think that a mass murderer or someone who commits first-degree murder is going to be behind bars for the rest of their life. You hear life sentence, you think they're going to be in for life. But that's not how it works. After 25 years begins a parole eligibility. So that individual will be released or is eligible to be released after 25 years. What that means in the case of a mass murderer, like the individual that took the life of Tim Bosma, and his widow, Charlene, appeared at our Justice Committee recently to speak about victims of crime, and she eloquently spoke about how, and this is someone who's been through unimaginable pain, but about how her efforts, the one solace she took, was that the mass murderer, because this individual was convicted of killing not only her husband, Tim, but also 2 other people. So he had taken 3 lives. The only solace she took in this whole process was knowing that her daughter would never have to attend a parole hearing because the individual, the offender, received a 75-year parole ineligibility period, thanks to conservative legislation that said we will allow consecutive periods of parole ineligibility, meaning not just 25, but you take 3 lives, it's 25 plus 25 plus 25, 75 years. Before, a family would have to go through the very difficult process of ripping off that Band-Aid and having to relive the worst events of their life. So that was the one solace she took. Well, as you know, Madam Speaker, and as members know in this House, the Supreme Court of Canada struck down those provisions, meaning that the individual that took the life of Tim Bosma, the individual that took the lives of 3 RCMP officers in Moncton, New Brunswick. I remember that day very well. We were gathered here we were in the lobby and watching this unfold. 3 lives taken, 75-year parole ineligibility period. Because of the Supreme Court of Canada's decision just a couple weeks ago, all of those individuals are now eligible for parole after 25 years. Does this mean they're going to be on the streets in under 25 years because they've already been serving their sentences? Not necessarily. Maybe they will be. Maybe they won't be. But what it definitely means is that all of these families, including Charlene Bosma's young daughter, all of these families are someday going to have to attend a parole hearing, look at the offender, and argue why that individual who took the life of their loved one would have to stay behind bars. So, Madam Speaker, we talk about why am I speaking about these things? It's because victims have to be at the center of all legislation, including Bill S4. And when I see a bill that mentions the consent of the offender 10 times and mentions the consent of the victim 0 times, it raises concern for me. So some of what's in Bill S4 is necessary. It allows for virtual measures where appropriate. For example, for police officers to apply and obtain warrants. Ability to conduct fingerprinting of the accused at a later date should fingerprints not previously have been taken. expanding the power of courts to make case management rules, expanding the ability of the accused and offenders to appear remotely by audio conference and video conference in certain circumstances, allowing the participation of prospective jurors in the jury selection process by video conference if deemed appropriate, using electronic or automated means to select jurors rather than the current practice of having the clerk of the court draw names from a box. Some of these measures indeed make sense, and that is why overall Conservatives are supporting S4. But there's a couple things, Madam Speaker, we're looking for, and one is a recognition of the role of the victims. The Justice Committee is completing a study on victims of crime. It was a Conservative motion that we study the impact of the justice system and how we can better serve victims of crime. And I spoke already of some of the testimony that we heard about how the justice system is stacked towards the offender. Victims' families are in the dark. Victims are in the dark. Victims of all kinds of crime, whether it be property crime, violent crime, individuals who've had a loved one taken from them, they're in the dark about the system. The supports are not there as they should. So when they see a bill that mentions the consent of the accused 10 times and mentions victims 0 times, it leads victims to conclude, once again, here's a piece of legislation and we're the afterthought. And that perpetuates a justice system that is out of balance and not victim first. And these are some of the things that we're going to be looking for is a refocus in this legislation on victims, their rights, and making sure that nothing is done in this process that undermines the ability for a victim to feel a sense of engagement and justice to the extent that they wish to in the process. Now, we have heard from other speakers about the urgency of this legislation. Well, number one, the Liberals have been in power for 7 years. This legislation, if you listen to them, they say these are measures that were called for and needed pre-COVID. Then with COVID, delays in justice system, the justice system, Madam Speaker, to be very clear, was already severely delayed before COVID. And of course, COVID made it worse. But I mentioned this in a question to a previous speaker. The Prime Minister reset the clock on this bill when he called an unnecessary, ironically COVID-related election, and here we are today debating this bill. So we're going to, as Conservatives, continue to focus on the rights of victims and making sure we have a justice system that takes serious crime seriously and protects the interests of victims every step of the way.
Questions and comments? The Honourable Parliamentary Secretary of the Government House Leader.
Yes, thank you, Madam Speaker. And by the sounds of it, the member continues to add to the whole unanimous sense that the legislation will, in fact, be supported by everyone inside the chamber. And I would guess my question to him would be related to the idea that through time things change, the need for modernization, and I made reference to victims consistently, I thought, through many of my comments. I've spoken about the importance of allowing and enabling victims to be able to present in different formats. My question to the member is that would he not, at the very least, concur that in supporting the legislation, we are recognizing the importance of having technology, a modernization of that within our judicial system.
The Honourable Member for Fundy Royal.
Well, thank you, Madam Speaker. And of course, we recognize that we must continually be looking for improvements to our system. But we also have to be steadfast in our concern in our justice system about victims. And I will continue to bring that forward both in this bill, in other government legislation, in private members' bills that we move forward, as well as the response to the Supreme Court decisions that I made. reference to, we need to make sure victims are a focus, and that's what we're looking at in this particular legislation, is reference to victims and ensuring we want to hear from victims to make sure that their interests are looked after.
Questions and comments? L'honorable député de Repentigny.
The honourable member for Repentigny. Thank you, Madam Speaker. I heard my colleague talk about solutions for victims and an imbalance in the system. The Quebec Bar is recommending a full overhaul of the system rather than piecemeal reforms. And why not start a predictable, realistic, consistent review now? What does my colleague think about that? Would it be good to launch a full, comprehensive overhaul to rebalance the system now? Thank you.
Well, the honourable member is quite correct. I mentioned in my remarks, the evidence is coming in. You know, sometimes we don't know what we don't know, but now we do know. We know that violent crime is up 32%. We know that the homicide rate in Canada has increased every year for the last 3 years and is at the highest level it's been since 2005. That would lead any logical person to conclude that what is happening right now is not working, which is why I made reference that we do need to refocus our justice system, realign it to protecting communities, protecting victims, and supporting their families. And we need to end this practice of a revolving door that puts offenders without treatment, without any acknowledgement that they've improved, right back onto the street to reoffend. That system is not working, Madam Speaker.
And comments? The honourable member for Nunavut.
The member for Fundy Royal spent much of his time not actually talking about S4. So I'd like to, I'm not sure if he read the whole thing, but when he talks about consent and how it's mentioned in numbers, it does actually provide availabilities for the legal counsel and the consent of the prosecutor and the consent of the accused so that proceedings can appear through the lawyer so that there's not only reliance on the accused being in court. Having said that, though, I know that the member represents a riding that is rural, and I do want to ask him if he agrees that Canadians living in rural and remote communities, especially given the size of Nunavut, should they not have the same access to availability of serving jury summons and the technology that is needed so that these victims whose justice is delayed, these will actually get the justice they deserve through this bill?
Honourable member for Fundy Royal.
I thank the honourable member for her question. She raises a great point. I know in her own riding, as well as in my riding of Fundy Royal, internet connectivity is an issue. We've all seen that over the last couple of years on Zoom, where someone's images froze up or they're unable to participate from where they are. And that is a concern with this bill as well. We're putting in place a tool, but there is not the resources for victims or their families in some cases to participate and to use that tool. And I have examples of that in my own riding where an individual attempting to participate in a parole hearing remotely, they do not have the equipment to do that, and that is a resource issue. So this is something we're raising with the government to make sure that the tools they've provided, that all Canadians have access to them, not just those in urban centres, but also those in rural areas as well.
Questions and comments? The honourable member for Saskatoon West.
Thank you, Madam Speaker. Yes, Saskatoon University, Madam Speaker. I was listening to the great speech here, and my question is around the timing. And we have Canadians that have been waiting to access justice for too long. And now the Liberals, after so many years in government, has moved on it. And it's unfair to expect families waiting for justice to wait until 2022 or the late stages of 2022 to access justice. I'd like him to expand a little bit on the view of these individuals and what it's like to be waiting that long to get justice.
Member for Fundy Royal.
I thank the honourable member for his question. He's hit on a great point. We've all heard the expression, justice delayed is justice denied. And in our country currently, under the Jordan principle, justice delayed can result in a case being completely thrown out. The Supreme Court has ruled if it's taking too long, that charges have to be dropped against an offender, which is why I call into question the government's narrative that the urgency of this, when this bill, as I mentioned in my speech, was introduced originally as a C-23 a couple of years ago. And what happened in the intervening time? An unnecessary election that reset the clock, and here we are today studying Bill S-4. So conservative support Bill S-4. There's some necessary improvements in there, but we need to maintain our focus on supporting victims and their families.
Questions and comments? The honourable member for Saanich Gulf Islands.
Thank you, Madam Speaker, and an honourable colleague from Fundy Royal. Much of his speech related to some other legislation that we've dealt with lately, but I fail to see anything in this bill that would meet the general narrative of his speech related to tough on crime or soft on crime. This is, as I read it, and please inform me if I've mistaken the bill, this is entirely about how to use modern technology, including video conferencing and telecommunications methods that has come up in the criminal justice system as a result of the pandemic. I totally agree with him that there was an unnecessary election. I totally agree with him that this could have been passed earlier, but I fail to see anything controversial here. Perhaps he can find something in this bill that actually relates to the rights of victims.
The honourable member for Fundy Royal.
Yes, I thank the honourable member for her question. As I mentioned, we're supporting Bill S-4, but there are concerns about access. The honourable member mentions access to virtual opportunities for victims and for offenders. Well, as was just mentioned in the previous question, not all Canadians have that access right now. Not all Canadians would have the ability to connect from where they are in their community to a virtual parole hearing or a virtual jury selection procedure. So we need to maintain a focus on improving our justice system. Technology can play an important role in that, but we also have to always have at the forefront victims. And I mentioned to the honourable member the lack of an acknowledgement of the place of victims in other government legislation, liberal government legislation, and we continue to see that here, where I mentioned even in my own riding, individuals who are unable to access virtual opportunities because they do not have the capability to do that from a rural community.
Reprise de débat, l'honorable.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of Economic Development, Rural Economic Development. Thank you, Madam Speaker. I'd like to inform you, Madam Speaker, that I'll be sharing my time with my colleague from Avalon. I'm pleased to be here today to take part in the debate on S4, an act to amend the Criminal Code and the Identification of Criminals Act, and to make related amendments to other acts. As you know, this is in connection with what we all experienced with the changes we made during the COVID-19 pandemic. This bill would make changes to the Criminal Code and other acts to solve procedural problems that we encountered during the pandemic. There were some good examples mentioned today, and I'd like to begin with the contribution from members of the Standing Senate Committee on Legal and Constitutional Affairs when they did an in-depth study of Bill S-4 last spring. After hearing from over 20 witnesses and examining a significant volume of documents, in a very short time, this bill reached third reading in the Senate on June 21st, 2022.
The Senate adopted two amendments. I would like to mention these two amendments, Madam Speaker. The first of which states that the Minister for Justice has to carry out an independent study about remote proceedings when it comes to criminal proceedings, minimum 3 years after royal assent, and that a report be made to each Chamber of Parliament at the latest 5 years after the beginning of the study. The Second Amendment, Madam Speaker, requires a parliamentary overview 5 years after the royal assent. These amendments are valid and will contribute to make sure that there is good oversight in the matter. The reforms provided for in Bill S4 that I would like to talk today have to do with the following proposals. That is, to clarify and broaden the use of appearances for criminal proceedings, allowing potential jury members to appear by video conference in certain situations, an increase in court capacity to try someone, and also improve the digital fingerprint process. I would like to focus on the way that these proposals have been made to improve the efficiency of our criminal court system, whilst mitigating some intense pressures to deal with delays and backlogs in the criminal court system. One of the main ways in which this bill will improve the effectiveness of this bill to make it clearer with regards to discretionary powers. It allows the use of technology. And that's what we were talking about in S4, in all criminal procedures, in preliminary investigations, in trials, and in the sentencing phase. In the bill, there should be the consentment of factors that tribunals need to take into account when they exert their discretionary power, which is essential. Essential in order to understand how the bill will be clarified by strengthening. Their objective is to help courts state that technology should be used when it is germane to do so, given the rights and freedoms of the accused. The reforms expected in Bill S4 will also allow technology to be better used in the jury selections process with the consent of parties. The tribunal will be able to make sure that jury will be able to present themselves by video rather than having to go to a courthouse. A potential jury member is someone who is summoned to a court in order to be potentially part of a jury. All of this will improve access to the judicial system to the average Canadian who must also take part in the jury selection process, but who may have issues physically being present at a court. This could be because of the incapacity to take an entire day off. This often is linked to transport, Madam Speaker, or the commodities we have with transport. Sometimes it's just a question of finding a parking spot downtown. Many of these mobility and accessibility issues could be helped with this bill. It can also be because of health, or lack of childcare, or even sometimes with bad weather. Better flexibility in the jury selection process will also contribute to make sure that there is a better participation and better diversity in amongst our jury members. What is essential for the good functioning of our criminal court system, given that the jury selection process will often involve hundreds of people that have to be physically present at the same time. The use of technology can also guarantee that procedures won't have to be adjourned because of healthcare issues or other issues even before a trial begins. This could allow a process to move forward rather than to be delayed, as was often the case during the pandemic, given the necessity of physical distancing. We're slightly benefiting from what happened during the pandemic to learn from it and to improve the system, without forgetting that when we came to power in 2015, internet was less stable than today. We have massively invested in the internet. We can allow remote regions, well, by 2026, 98% of the population will have access to internet. So today, we could improve the judicial system in order to better meet the needs of remote areas. As Parliamentary Secretary for Rural Affairs, for Rural Economic Development, what I can say is that I have visited many different regions, and there is a crying need to offer more and better service to remote areas. Amendments in this bill goes beyond jury selection and goes to protection. Both parties will have to sign an order agreeing that jury members could be able to appear by video conference. The court will have to determine that such an order is appropriate, taking into account the challenges of participating in person and the private life and privacy of jury members, whilst taking into account the right to a fair trial. What we have to remember, Madam Speaker, is that the use of technology will be optional and will be at the discretion of the judge or justice. It will not be mandatory. It will help courts in order to make justice efficient. The reforms will give better tools to courts in order to make things move forward more rapidly in these difficult times. It could be because of a pandemic or flooding, as was the case twice in my riding since 2015, or if it has to do with any situation that means that getting to the courthouse is difficult. These reforms can be used, and could be used more significantly in managing exceptional circumstances. It will not be limited to such circumstances. It will be permanently applicable so that our courts can continue to offer options of using technology in the years to come. On top of improving the system, the use of technology will be joined by other reforms in this bill that will improve access to justice and will improve the efficiency and effectiveness of our courts. For example, S4 will broaden the scope of courts when it comes to managing cases so that court staff can deal with administrative matters in extrajudicial matters. We must act, Madam Speaker, and support this bill. Thank you. Questions and comments? The Honourable Member for Thérèse de Blainville. Thank you, Madam Speaker. I'd like to ask a question that is important for the Quebec Bar Association that made recommendations. Recommendations with regards to S4, some of which were listened to and retained. In the House, we studied C75, that sought to amend the criminal code and the criminal justice system for adolescents. There was C5. And now we have S4. There's a recommendation that seemed to be very judicious. Instead of doing this on an ad hoc basis, is it not time to have a global, a more comprehensive reform of the justice system with these changes so that everything is coherent? Does my colleague agree with this proposal? The Honourable Parliamentary Secretary. Thank you. That's an excellent question from my colleague across the way. There are bills in the pipeline There's also C23 that was tabled last year, which continues S4 today. So there have already been changes made since the last legislature, largest piece of legislation last year. Thanks to what, Madam Speaker? Thanks to consultations that we've had with important stakeholders, including provinces and territories that took part in the decision-making process that helped us amend the former bill. And this is a good step in the right direction, Madam Speaker.
Elmwood Transcona.
Thank you, Madam Speaker. We know that one of the reasons for which there are delays in the judicial system is because of the delays in the government in appointing judges. Does the MP have any idea as to how we could legislate here in order to allow the Minister for Justice to more rapidly appoint judges? Thank you, Madam Speaker. I'd like to thank my colleague for his question. The criminal system that we have is a complex one. Appointing judges is important, as is appointing juries and prosecutors, so that everything moves forward. Today, we are taking a step in the right direction to improve the system. Technology that already exists is being used via internet, via video conferencing. And this bill will improve the system, will make the work of justices and judges more easy. Many times judges turn up to a hearing that had to be delayed because there were issues that I already mentioned in my speech. That means that everything was pushed back again and again and again. Today it's important to facilitate the work of judges. Then we will evaluate as to how much it helped them out. And then we will make the lives easier for judges.
The honourable for Leeds, Grenville, Thousand Islands and Rideau Lakes.
Well, thanks, Madam Speaker. So the parliamentary secretary spoke to the importance of the bill, but this is a COVID-related bill, and it was born out of the need for remote access and digital means and delaying processing times because of COVID. But the passage of this bill was itself delayed because of an unnecessary election call during COVID. So I'm just wondering if the parliamentary secretary raised those concerns with his prime minister when delaying this bill that he's identified as being very important.
The Honourable Parliamentary Secretary, a quick answer, please. Yes, thank you, Madam Speaker. Well, listen, there's never a good time or a bad time for a bill. If we take the bill that was tabled last year, there were already amendments made. We worked with the Senate committee. We worked with provinces and territories. We worked with legal experts, those who made recommendations to us. And from last year to this year, improvements have been made to the bill to make sure that today's S4 is up to date and is ready to be tabled.
Resuming debate, the honourable member for Avalon.
Thank you, Madam Speaker. It's always a pleasure to stand in this place and represent the constituents of Avalon. I'm pleased to have the opportunity to provide an overview of some of the key areas of reform proposed in Bill S4, an act to amend the criminal code and the identification of criminal acts and to make related amendments to other acts. Bill S4 increases the efficiency and effectiveness of criminal proceedings by giving courts more flexibility and clarity in response to the particular challenges that arose in the pandemic. When COVID-19 pandemic began, the remote appearance provisions in the criminal code had just been reformed through former Bill C-75 in 2019. Those amendments had been informed by the 2013 report of the Steering Committee on Justice Efficiencies and Access to the Criminal Justice System, titled Report on the Use of Technology in the Criminal Justice System, as well as consultations with provincial and territorial governments. Bill S4 continues to build on those reforms, taking into account new calls for reform by those working in the criminal justice system during the pandemic and courts' experiences with the increased use of technology that occurred as a result. My remarks today will focus on the necessity of the proposed amendments relating to remote proceedings, which represent a continuation of existing legal practices here in Canada. Prior to the COVID-19 pandemic, criminal court proceedings were presumptively held in person. Remote appearances were permitted under the Criminal Code, but were very much the exception. There were provisions in the Criminal Code to allow people to attend some proceedings by way of audio or visual connection, but since they were not routinely used, little clarification or guidance was needed. The pandemic had an abrupt and immediate effect on the operation of courts, as courts across Canada shut down for periods of time and had to figure out how to operate without having in-person attendance or very limited in-person attendance. To cope with the pandemic and maintain the administration of justice, including maintaining access to the courts, courts around the country pivoted away from in-person appearances and held numerous hearings and matters in a virtual space. The COVID-19 pandemic forced changes to how courts operate. Unrestricted in-person appearances were no longer permitted, and initially, courts were forced to adjourn the majority of appearances, ranging from pleas to trials. This created a backlog of cases in the court system that still needed to be heard, regardless of the circumstances of the pandemic. In many cases, participants appearing by video conference when possible allowed court operations to resume. However, even with courts adapting and modernising to address the challenges they faced during the pandemic, many remain unable to operate at their pre-pandemic capacity. Indeed, the median length of time for an adult case to resolve in criminal court increased when compared with pre-pandemic levels. Further complicating matters was the number of adult criminal court cases that exceeded the presumptive time limits set out by the Supreme Court of Canada in Jordan had increased significantly since the onset of the pandemic. Bill S4 targets challenges to the criminal code that will give courts increased flexibility in how they hold criminal proceedings and how they issue orders, such as search warrants and production orders in the context of an investigation. These changes are needed to address the ongoing pressures on the criminal court system brought to light by the COVID-19 pandemic and enhance access to justice for all Canadians now and in the future. A key impact of these provisions will be more efficient justice system that is equipped to serve Canadians and address the backlog of cases caused by the pandemic. Allowing and continuing remote appearances is not just about responding to the COVID-19 pandemic. Remote appearances will provide greater flexibility for courts to continue proceedings when it is not possible to do so in person for other reasons, such as natural disasters. During its study of the bill, the Standing Senate Committee on Legal and Constitutional Affairs heard witness testimony about the closure of the Calgary courthouse during the floods of 2013. Due to the natural disaster, the court was forced to close proceedings for a period of time, and matters could not be heard and were adjourned. The changes proposed in Bill S4 make clear that certain proceedings can move ahead by audio or visual conference, even when in-person attendance is not possible or safe, allowing courts to operate as efficiently as possible in the interest of all participants in the criminal justice system. While there has been acceptance of proceedings occurring by way of audio or video conference, the reforms included in Bill S4 do not seek to make this the norm or default. Indeed, as before, the principles set out in the Criminal Code will continue to be that, except as otherwise provided. A person who appears at, participates in, or presides at a proceeding shall do so in person. This principle will not change. Rather than upending the legal system, this bill will continue to allow the flexibility of proceedings in a manner that makes sense in the circumstances with appropriate safeguards built in. When considering whether to authorise remote proceedings, courts will be obligated to consider the impact on the safety of the participants while supporting greater access to justice moving forward, including for those living in remote communities. Courts will also be required to ensure that decisions to authorise remote appearances are exercised in accordance with the Charter, including the right of an accused person to make full answer and defence and to have a fair and public hearing. While Bill S4 clarifies and expands when remote appearances are possible, it will not be the first to introduce these concepts into the criminal code. At committee, there were some concerns expressed over a judge's ability to assess credibility of witnesses and accused persons during remote proceedings, as well as the importance of protecting an accused person's ability to face their accuser. While these are not important considerations, the court must turn its mind to, in each case, they are not unique to the provisions Bill S4 amends. Indeed, courts have found that seeing a complainant or a witness face-to-face is not fundamental to our system of justice, and the criminal code has permitted remote attendance by witnesses for more than 20 years. Subsection 802.1 has authorised summary conviction trials by video for in-custody accused since 1997. Section 714.1 and 714.2 have permitted appearances by witnesses by video conference since 1999. Bill C-75, which was passed by this House in 2019, modernised and facilitated some appearances by audio and video conference of all persons involved in criminal cases, including judges under certain circumstances. Rather than overhauling criminal procedure, Bill S4 continues to permit proceedings by remote appearance. This bill picks up where Bill C-75 left off, in light of the experience that was gained and the questions that arose with use of technology in the criminal courts during the pandemic. Bill S4 makes practical and necessary amendments to the criminal code. These amendments will facilitate efficient operation of the criminal courts and have direct impact on people who need or want to access the criminal justice system. This bill is not intended to make remote trials and hearings the norm, but rather gives courts the flexibility to proceed in this manner when it is appropriate under the circumstances and where the technology exists. These are limited but necessary reforms that have been developed in consultation with the provinces and territories and take into consideration the views of stakeholders. I am confident that this bill and the proposed reforms will improve efficiencies in our criminal justice system while still providing careful oversight by the courts to ensure that the rights of accused persons and offenders are protected with the use of technology. For these reasons, I urge all members to support Bill S4. Thank you, Madam Speaker.
Questions and comments? The honourable member for Chatham-Kent-Limington.
Thank you, Madam Speaker, and I want to thank my honourable colleague across the way for his intervention this morning. Much of his speech dealt with aspects of the bill that, as has been earlier indicated, that Conservatives will support. I wonder, though, what he did not address really was the balance, or more properly, the imbalance between attention to victims and to perpetrators. I believe he comes from a riding similar to mine, more rural in aspect, or large rural areas. And certainly my phone is blowing up this morning with what's gone on with the most recent attempt of this government to further inhibit the rights of legal firearms owners. So I'm wondering if he could comment as to why this government seems to err on the side of perpetrators and target law-abiding firearms owners as opposed to really going after the criminals in our society. Thank you, Madam Speaker.
I do want to remind members to make sure that their questions are pertinent to the matter that's before the House. And so I will see if the honourable member sees a pertinence in that if he chooses to answer. The honourable member for Avalon.
Okay, thank you, Madam Speaker, and I thank the member opposite for the question. I don't think we're playing favouritism to one side or the other, but I will say from my perspective, I think the victims should have every opportunity to appear by video conference or in person if they want to face the perpetrator in any particular case. And I would hope that everybody would support that going forward. And I think when this goes to committee, maybe some amendments can be made to enhance that and make sure it is the case for anyone that has a problem with the courts or the decision we're doing today.
Séance des commentaires. L'honorable député de Lac-Saint-Jean.
Questions and comments. The Honourable Member for Lac-Saint-Jean. Thank you, Madam Speaker. We feel that this is a good bill. It doesn't fix all the problems, but the Bloc Québécois supports it. We will vote for it. That won't come as a surprise to anyone. It doesn't fix all the issues with the criminal code. There's something that's not working right now in the criminal codes. If NGOs want to work in Pakistan to help people, they won't be able to because there's a list. So they can't do business with them because they can be prosecuted under the criminal code. This government had the opportunity to change the situation and didn't do so. I'd like to know whether my colleague supports amending the criminal code so that Canadian NGOs could work in Afghanistan. Thank you.
To the Avalon.
The Honourable Member for Avalon.
Certainly would support that amendment to make sure everybody can get their opportunity to appear and give witness or take part in any court proceedings. I don't think anybody should be limited from not being able to appear on their own behalf or on the behalf of others. Thank you.
The Honourable Member, questions and comments. The Honourable Member for Hamilton Centre.
Thank you, Madam Speaker. There's a fundamental principle that justice delayed is justice denied, and we've heard all the various ways in which our legal system is falling apart with these backlogs, and this particular bill addresses one administrative part. But I think about those who are awaiting trial who are held in custody on remand and the great delay in which this government brought this legislation back, and in particular as a means of addressing court backlogs. Why did the government oppose Recommendation 1 of the House of Commons Standing Committee on the Justice and Human Rights from the 2017 report on the access to justice, which Legal Aid called on the federal government to remove legal aid funding currently included in the Canadian social transfers in favor of a specific earmarked civil legal aid fund for provinces to be administered under the Department of Justice?
The Honourable Member for Avalon has 1 minute to respond.
Okay, and briefly I'll respond. I'm not quite familiar with that provision, and I'll certainly look at it and see exactly what it says, but I'm sure there was a valid reason for not removing it from one part of the judicial system when it comes to witnesses appearing or adjudicating and not going to some other section. Sometimes we can bog ourselves down in paperwork if we want to with moving things around. If it's not broken or if it's still working, why destroy it and bring in something that you don't know if it's going to work? Thank you, Madam Speaker.
Resuming debate, the Honourable Member Battle River Crowfoot.
Thank you very much, Madam Speaker. And as always, it is an honor to be able to join into the debate and discussions that take place, the important debates and discussions that take place within this House, and as well to be able to discuss the wide variety of issues, both directly and indirectly addressed through Bill S4. And Madam Speaker, I would note that I will be streaming this speech live on Facebook, where I will endeavor to not only address some of the very important aspects to Bill S4, but as well endeavor to take feedback and comments from those who are watching on Facebook. At DC Couric is my Facebook handle, and we'll look forward to being able to address some of the comments and concerns that constituents bring forward. You know, Madam Speaker, we have with Bill S4 that codifies some of the dynamics that existed during the course of COVID, things like video appearances, making it so that certain technical and administrative challenges associated with the circumstances about offices being closed, for example, the fact that fingerprinting could be delayed process, a whole host of administrative concerns. And Madam Speaker, I think that something that I'd like to highlight, and I'd encourage those watching live on Facebook to share their stories as well about some of the dynamics associated with rural crime. Because, Madam Speaker, access to justice is something that is not unique to rural Canadians. This didn't start in 2020 with COVID, and it certainly hasn't repaired itself as we have seen life get back to normal. Madam Speaker, often you have wide distances. My constituency, for example, Madam Speaker, as many of those watching from my constituency will know, that it's about 5 hours from corner to corner. You're talking hours to the nearest courthouse. And in many cases, you have the response time of law enforcement to very serious crimes is measured in hours or, Madam Speaker, even sometimes in days. And I think, Madam Speaker, it's important context that we see this soft on crime. It was referenced yesterday, and I happen to agree with the statement that was made the other day by one of my Conservative colleagues. It's this hug-a-thug approach. And, Madam Speaker, it's really unfortunate because we are seeing that my constituents are facing the consequences of that soft-on-crime approach by not seeing our justice system as a system that serves justice. In fact, Madam Speaker, one of the most common statements that I receive from constituents is that we do not have a justice system. It's simply a poor excuse for a legal system. And, Madam Speaker, I certainly see the Liberal record over the past 7 years as being one that just piles on failure after failure, whether it be C5 that eliminates a whole host of sentences for very, very serious crimes. And the Justice Minister, in an astounding level of ignorance and arrogance, simply says, well, we'll leave it up to the judges. Well, Madam Speaker, I have more examples than I could fit in days of debate about where the justice system does not actually bring about the punishments that should certainly fit the crime, and we are seeing a massive erosion of trust in the system. So, Madam Speaker, I I'm seeing specifically a member from the government that seems to be participating in my Facebook Live. I thank him for his viewership and amplification of the sound, common sense Conservative message that certainly resonates with Canadians. And, Madam Speaker, I would note something that I think is especially relevant. Because, Madam Speaker, you have an astounding level of ignorance displayed by the Liberals, and this was highlighted, actually, just the other day, that the rule of law to them seems to be this plaything. And I'd like to quote, actually, Madam Speaker, a text message sent from the Minister of Public Safety that was revealed at the Emergencies Inquiry Commission. So the parliamentary secretary that just commented on my feed should maybe pay attention to this. You need to get the police to move, and the CAF if necessary too. Too many people are being seriously adversely affected by what is an occupation. I'm getting out as soon as I can. The people are looking to you, us, for leadership, and certainly not stupid people like Carney, Kath, my team. Madam Speaker, the then reply goes on to how many tanks are you asking for? I just want to ask, and I can't say the name of the Minister of Defense, but her name is referenced there, how many we've got on hand. And the response from Canada's Minister of Public Safety is, I reckon one will do. Madam Speaker, that is astounding. Absolutely astounding. And I would suggest disgusting that those Liberals would suggest that pulling out tanks to bring to the streets of our capital city would in any universe be an acceptable practice, Madam Speaker, and that we see how...
Point of order, the Honourable Parliamentary Secretary.
Rising on a point of order, Madam Speaker, on a point of relevancy. I know the Conservatives love to defend the convoy, but we're not talking about the illegal occupation of Ottawa or the Emergencies Act. We're talking about S4, and I was wondering if the honourable member could get back to actually talking about the bill.
The honourable member for Battle River Crowfoot has a point of order as well.
Yes, Madam Speaker. You know, I think that it's interesting that the Liberals are intent on pivoting away from their many, many failures on not only access to justice.
Point of order. I just want to remind members that the debate is before Bill is about Bill S4. I also want to remind members that there is a little bit of latitude during members' speeches, but I do want to make sure that members are aware that their speeches should be relevant to the bill that is before the House. The honourable member for Battle River Crowfoot, and I'm sure he'll bring it back to the bill itself.
Absolutely, Madam Speaker, because we see how this Liberal government is refusing access to justice for Canadians. Now, S4 has some practical steps to ensure that my constituents will see a small step forward to be able to access the court system through things like video conference and whatnot. But, Madam Speaker, this is in the context of the larger trend where you have the Liberals more concerned about tanks on our streets than ensuring that Canadians have justice. Madam Speaker, somebody watching made the comment that we need a time that fits the crime. Madam Speaker, we have a justice system, as is being highlighted by some of those who are commenting, that is, instead of prioritizing the rights of victims, those who have seen, in some cases, the absolutely devastating crimes, things like sexual assault, things like a firearm being discharged with intent, the Liberals have eliminated sentences on that. Madam Speaker, my constituents have made it very, very clear. Now, the Liberals will like to say that somehow we don't support justice or whatever the case is. Well, Madam Speaker, there's one party in this House that stands up for victims, and that's the Conservative Party. And that is increasingly clear as you see those Liberals demand that somehow a soft-on-crime approach is a good way to stand up for victims of crime. Madam Speaker, that couldn't be further from the truth. We see a backlog within the court system that is leaving serious crimes not even seeing their day in court. Madam Speaker, imagine a victim, whether it's a senior in my constituency who came to me related to being held up at gunpoint, a legal gun, by the way, not a law-abiding firearms owner, that individual skipped bail. Less than 4 hours, they were back on the street. Madam Speaker, there was threats made against RCMP officers in my constituency, and we saw how there was, within less than a day, somebody who had threatened the life of an RCMP officer was back out on the street. And Madam Speaker, this has very, very significant correlation between the way that we have access justice in this country. And Madam Speaker, I would suggest that the Liberals pay close attention because there are many, many victims. And these are not traditional Conservative supporters. I'm not talking about just the folks that I represent in rural Alberta, but I'm talking about folks from Liberal ridings that in some cases have reached out to Conservatives and say we're frustrated with that Liberal approach. So, Madam Speaker, somebody on the comment asked that when the Prime Minister is going to resign, and certainly I'd have a whole host of constituents that would be very, very interested in finding the answer to that question. But, Madam Speaker, I think that, another example that that somebody on Facebook highlights, that this government spends more time persecuting law-abiding firearms owners than they do those who perpetrate serious crimes, including, Madam Speaker, serious gun crimes. And I think that the hypocrisy that is demonstrated in that on a daily basis has contributed to that erosion of trust that is taking place within our system. And Madam Speaker, something that I hope that the Liberals listen to very, very closely. When we see an erosion of trust, it is something that is very, very difficult to earn back. That's not something that's simply a platitude or a campaign platform promise or whatever the case is. It takes time, it takes effort, and takes a demonstration. And Madam Speaker, I've said this before in this place and I'll say it again. The Liberals, if they're good at one thing, it's politics. But when it comes to actually governing, they fail each and every time. In fact, Madam Speaker, I find it very, very interesting, whether it be on the issues directly related to S5, which has a lot to do with access to the justice system and that sort of thing, or whether it's the host of other concerns that MPs from this place hear from on a regular basis, we see that over the past 7 years,
Point of order, the honourable member for Don Valley North.
Thank you very much, Madam Chair. I think the member, during his remarks, he mentioned that he is live broadcasting the debate, and I wonder what's the rules around taking videos or live broadcasting through Facebook while we're debating. I don't know. I just want to ask them.
So the honourable member has a point of order, or it's not about responding to the point of order. So I just want to indicate that the honourable member is actually bringing a point of order of something that the honourable member may have said, but I don't know if that was done in the House. So if it's done in the House, then I would remind members that they're not to do any of that, those types of recordings while in the House. And so, on the point of order, the honourable member for Hamilton Centre.
Thank you, Madam Speaker. And I would, this is not something I do regularly, but I rise to actually support the honourable member from the Conservative caucus. I'm watching the live stream here. It's pretty clear that it's actually being restreamed from the CPAC. So I commend him on his innovation. I had wondered myself, perhaps, Madam Speaker, if he was doing it from his phone, if the live stream would be going up his nose or catching his chin or something of that nature, but that's not the case. It's well streamed, and I support the member for using technology to bring his residents into the chambers. Thank you.
Yes, so I just, again, I'll just go on that point, is the live stream from, I don't know, whatever platform he's using, whether it's Parlview or whatever, it's public, and so the honourable member is free to do that as long as he's not filming in the House here. Or while, should the member be virtual, he's not able to live stream what's happening virtually. So the honourable member for Battle River Crowfoot can continue his speech. So I have ruled on it. If it's anything different than what I have ruled, then the honourable member for Edmonton Manning can rise on the point of order. If it's a different point of order. Okay, I have ruled on it, but I'm just wondering if the honourable member had anything different to add than what my decision was.
It's a little bit, if that's okay.
The honourable member for Edmonton Manning.
Well, thanks for allowing this. I just want to point out one thing is this bill is not a controversial bill by any chance. We're all in agreement that the importance of putting this bill back. And
it has nothing to do with the point of order? So the honourable member can get right to the point of order?
On the point of order, the government member should be more receptive to what we're saying on this side. And
the point of debate. The honourable member for Battle River Crowfoot.
Thank you, Madam Speaker, and let me take this opportunity to highlight, I find it really ironic that the so-called progressives in this place would be opposed to, with the exception from the member from the Green Party, but from the NDP. Sorry, was thinking of your name there. My apologies. Madam Speaker, I find it interesting, as certainly I am endeavoring to make this place more accessible to the people, and using something like social media to ensure that that could in fact be the case. I find it very interesting that the members from the Liberal Party seem to be concerned that Canadians would know what's going on in this place. And certainly, Madam Speaker, I will do everything I can to expose the Liberal management of government, whether it's their legislative agenda or whatever the case is. So, Madam Speaker, I would like to highlight, and I happen to know this constituent because she works with victims of crime a lot, and her name is Michelle Hauser. And she just commented on this video, and she makes the comment that nobody feels safe. And Madam Speaker, I think that encompasses much of the concern that many of my constituents are facing when it comes to the status of justice here in Canada. When you have law enforcement response times in rural communities that are not only measured in hours, but sometimes in the cases of days, and I'm not talking about, a minor infraction, that somebody jaywalked across a gravel road. I'm talking about major crime, sometimes a robbery, assaults, things like that. And Madam Speaker, access to justice is fundamental to a modern functioning democracy. And Madam Speaker, we see that is being taken away. We saw with more than a year delay that the Liberals delayed for more than a year the appointment of the Victims Ombudsman. Madam Speaker, I'm pleased that there was an appointment made. That was absolutely necessary. But we see how, again, the soft on-crime approach, where you have the public safety minister more worried about bringing tanks to the streets of our capital city to shut down protesters that they disagree with, than ensuring that regular Canadians have access to the fundamental principles of justice, which I would hope every member of this place supports. Madam Speaker, we see that there is the necessity that law enforcement has the tools required to be able to gather the evidence, to make sure that there's the time within our court system so that people can actually be brought and have their day in court, both for those who have been accused of a crime, but also for the victims, to ensure that they have everything required so that they can see justice done. Because, Madam Speaker, if justice is not done, that erodes the confidence that Canadians need to be able to have, not just in the legal system proper, but, Madam Speaker, every facet of government. For if Canadians cannot feel safe in their own homes, Madam Speaker, that fundamentally erodes one of the very basic principles of what makes Western democracy. And I see how I speak with law enforcement often, whether it's Mounties in my constituency that are the ones that are driving up and down the many thousands of kilometers that I represent, when the Camrose Police Service in the city of Camrose that does great work, and many of these officers, Madam Speaker, do fantastic service to the community. And, Madam Speaker, in many cases, some of them have come to me confidentially and said it's overwhelming for them. It's overwhelming for them that they will, in some cases, spend late nights, burn the midnight oil, after a long day of patrols and after a long day of gathering information, investigations, and all of these sorts of things. Yet, when the case goes before a judge, it's simply tossed. Madam Speaker, imagine how somebody in law enforcement would feel if you spend days putting together a case only to have that tossed out, and then that criminal back on the streets, victimizing again. Madam Speaker, these are serious, serious, serious things. I cannot emphasize that enough. The revolving door of the justice system is a real concern. It's one thing for the system to ensure that those who are brought within it, who have been accused of a crime, to make sure that they're able to not be unnecessarily held up or anything like that. But, Madam Speaker, when you have somebody that has multiple arrest warrants out, and they're arrested again for something that may be unrelated, maybe in another jurisdiction, and then all of a sudden they're back out on the streets again, we're talking about access to justice. And for the many, many victims, the consequence is that their victimizers are once again out on the streets. And a comment from Lynn, she says, no one should be above the law. And I agree, no one should, including, that's maybe a message that our Prime Minister should take seriously, but no one should be above the law. Not one person, whether it's us in this place, each and every one of the 338 of us, or every single Canadian. For the rule of law, Madam Speaker, is at the very foundation of who we are as a democratic society. And to see an erosion of that is absolutely devastating. The question is asked from Shauna about how do we address parole issues? And it is a huge concern. Often we occasionally hear the stories that grab a headline about some horrific crime that's been committed, and that criminal that's been found guilty of that crime, and then there's a public outpouring that keeps that person behind bars. Yet you see continually from this government a pursuit of an agenda that would lessen the ability to keep some of those serious criminals behind bars. And, Madam Speaker, why that is relevant is because it is victims that ultimately suffer. Madam Speaker, we see how some recent Supreme Court decisions that have including most recently the fact that we need to figure out a path forward so that serious sexual predators in this country face the consequences due to their crime. Because, Madam Speaker, that's not only essential for the safety of our society in general, but, Madam Speaker, imagine, and although it didn't happen in my constituency, there's a very clear example of where a young woman and her baby were killed. Her partner is from my constituency, so it hits really close to home, because they were living next door to a sexual predator. They were murdered. Madam Speaker, a failure of the justice system. Access to justice is fundamental and key, and we are seeing that it is being denied increasingly to Canadians. Madam Speaker, a comment about losing faith in the RCMP institutions, and I take that point when we have the commissioner of the RCMP where there's been political interference. In the largest mass shooting in Canadian history, the commissioner of the RCMP was facing political pressure from a minister to further their political agenda. Madam Speaker, you talk about access to justice. When you have the top brass of Canada's national law enforcement organization that are facing political pressure.
Parliamentary Secretary to the Minister of Canadian Heritage.
Madam Chair, or Madam Speaker, we are once again, I know the honourable member is reading comments off Facebook, but we should be focused on the bill, which is S4. It doesn't deal with the RCMP and the brass and whatever his constituents are thinking. And it's nice that he's responding to that, but he needs to be relevant and he needs to speak about the bill before the House.
I want to remind the member, I've been listening as well, and I want to remind the member that he should be speaking to the bill itself, and I would remind him that again. So the honourable member for Battle River Crowfoot. Sorry, I have a point of order. The honourable member for Fundy Royal.
Madam Speaker, I notice some of the members across the way are repeatedly interrupting my honourable colleague's speech. And I want to remind them that there's an agreement, all-party agreement, to have this debate collapse. But if they continue with the interruptions, that's going to have to be revisited.
Again, I would just say that that's not really a point of order. I think that the honourable member has an issue with that, and he should take it to his House Leader and his whip. The honourable parliamentary secretary has another point of order.
On the same point, Madam Speaker, it's a little disappointing that the Conservative critic is suggesting that we don't follow the standing orders, and if the Conservatives are permitted not to follow the standing orders, the debate should collapse. But in the absence of that,
I would just remind members, that points of orders have to be used judiciously as well. And so I would just say that, again, I just ruled on the point of order that the honourable member for Fundy Royal has put forward. And I do want to remind members that they are to ensure that they are speaking about the bill that is before the House. I understand that there is some latitude, but the honourable member is actually going over that as well. So I just want to remind the honourable member to stick to the debate on S4. The honourable member.
Madam Speaker, how much time do I have left?
2 minutes.
About 2 minutes. So, Madam Speaker, I'm happy to respond to that, because when it comes to the administration of justice within my constituency, it is RCMP members, the hard-working men and women that wear the surge, that are those who are facing the consequences of liberal mismanagement. And the reason why it has such a close correlation to Bill S4 that is before this House is because, Madam Speaker, it is fundamentally associated with access to justice. So, Madam Speaker, as I talk about many of these things and made it very, very clear, both in the Facebook Live, which I've been happy to endeavour to expand the public's access, Canadians' access to this place, as is fundamental. And, Madam Speaker, for democracy is not simply about election day, but each and every day in between. And it's been certainly an interesting experiment, if you will, Madam Speaker, and I found it interesting, certainly very disappointing, that members specifically of the Liberal Party would hate any attempt to be progressive in the access, in Canadians' ability to access our democracy. And so I think that as we as we wrap up, as I wrap up this speech in the last few seconds, Madam Speaker, I would simply say this. The rule of law is fundamental to a modern, functioning democracy. And we are seeing an erosion of that. We need to prioritize access to justice in every way possible. In some ways, that has to do with ensuring that there's video conference options, that there's administrative details that can be sorted out so that there's not unnecessary delays based on in what in many cases our criminal code was written by Prime Minister John Sparrow back in the 1800s, although it's been updated significantly since then. Madam Speaker, over the course of our country's history, we have to ensure that it's updated to ultimately ensure that Canadians have access to justice, that victims are protected, and that those who commit crimes in this country face the time that is due them. Thank you very much, Madam Speaker, and I look forward to questions from others within this place.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Canadian Heritage.
Thank you so much, Madam Speaker. And I was watching on Facebook, and I guess I understand why the honourable member was dog whistling to the convoy crowd, because there were a number of comments on there he doesn't seem to be correcting, including that the Prime Minister should be arrested and so on and so forth. And it's disappointing to see the honourable member play to the lowest common denominator. But I did ask a question in that forum, and I'd like to give him an opportunity to answer, is that he talks about, and his colleagues talk about, U.S.-style laws. And can he give us example in the United States, especially in the southern United States, of the types of laws he wants where it's actually made those communities safer?
The honourable member for Battle River Crowfoot.
Madam Speaker, I think that it's interesting how that member seems to suggest that many Canadians, their opinions don't matter. I'll specifically address the question, however. Here's the reality. You see that that member and many members of the Liberal Party are attempting to paint Conservatives as somehow being something that very clearly we are not, when we are standing up for and with victims of serious crime. Madam Speaker, we believe as well, in fact, it was a Conservative bill brought forward from a Conservative MP from the Maritimes in the last Parliament that passed with to ensure that there's a strategy to address recidivism. Madam Speaker, the fact that those members would try to make somehow, what we're doing standing up for victims some comparator to Trump, when the biggest comparison to Trump, I think, in this place is we have a Prime Minister that has more ethical violations than he can count. Madam Speaker, the reality is this. Conservatives have and will continue to stand up for victims because that's what Canadians expect in this place.
Questions et commentaires. L'honorable député de Drummond.
The honourable member for Drummond. I'd like to thank the member for his speech and for his initiative, streaming this live on his Facebook page. I found this interesting too, that other colleagues were participating on my colleagues through his Facebook page. I heard the member talk about the stiffness of sentences and that they should be even stiffer for serious crimes. I visited a medium security facility in Drummond where there were systems in place to promote rehabilitation of offenders, even in the case of violent crimes. So I was wondering if it might be better to make more use of parole, and I'd also like to know what evidence my colleague is relying on to justify stiffer sentencing and less focus on rehabilitation. The honourable member for Battleford Crowfoot.
So, Madam Speaker, I appreciate the question, although it feeds into the false premise that somehow we're asking for stiffer penalties, because it's the Minister of Justice that often suggests that they should raise the maximum penalty that is allowable for serious crimes. Yet, I have yet to hear the Minister of Justice from the Liberal Party acknowledge the number of times on any offence that the maximum penalty is in fact brought forward. Madam Speaker, there's significant evidence, and I'm proud to represent many correctional officers in my constituency. There is an institution in Drumheller. In fact, I speak often with members of the Correctional Service of Canada who are incredibly frustrated about some of the ways that even within prison, the rights of serious criminals are prioritized over the rights of the well-being of correctional officers. So, Madam Speaker, I have to allow for other
questions, questions et commentaires. The honourable member Edmonton Strathcona.
I'd like to thank my colleague from Alberta for his intervention today. He didn't speak an awful lot about the bill at hand. There wasn't an awful lot there on S4. So I certainly hope later on today, as I do my speech, I am afforded the same leniency to expand upon thoughts. One thing he did talk about is the attack on an RCMP officer. And I think everyone in this House finds that incredibly appalling to hear that. Of course, from my perspective as an Albertan, I remember last year when the RCMP officers in Coots were threatened, when they were the ones that were being threatened with illegal guns, with crime. And I'm just wondering why the member has such a different perspective on what should have been done in that situation, why the Emergency Act should not have been enacted, why we should not have done everything we could to protect those RCMP officers, and a different perspective for what should be done to protect RCMP officers in his community.
The honourable member for Battle River Crowfoot.
Thank you very much, Madam Speaker. And, it's interesting because you have before us a member by the very premise of her question is suggesting that somehow the rights of Canadians should be something that the Prime Minister's office depends on whether or not they respect. Madam Speaker, if somebody breaks the law in this country, there should be a penalty for it. Whether that is somebody that I support in terms of their protest movement or not. Madam Speaker, the rights of Canadians should not be something that is negotiable at the whim of a Prime Minister who seems to have no concerns with anything other than his political fortune. So, Madam Speaker, I think that that member should consider very carefully when she talks so flippantly about how the rights of Canadians matter, because, Madam Speaker, those who break the law should face the penalty, full stop. And I don't know why that is something that is so controversial to that member from Edmonton. But further to that, I think that, Mr. Speaker, we need to ensure that when it comes to the administration of justice in this country, that it's done fairly, so that Canadians' very, very real concerns are not dismissed at the whim of ideologues that happen to sit in the front benches.
Questions and comments? Question et commentaire. I don't know where we were in the sequence. We're not, okay, there you go. I'll go to the Parliamentary Secretary to the Government House Leader, and then we still got time.
Thank you. Mr. Speaker, there should always be an appropriate consequence for a crime that is committed. But I want to shy away from that and just refer to the fact that S4, what it really is about is the modernization or a partial modernization in which our judicial system will be able to incorporate video conferencing or videotaping, which will assist in our judicial system. We learned that through the pandemic, and I'm wondering if the member could just reaffirm what I understand to be the case, that the Conservative Party will in fact be supporting the legislation and the importance of us getting feedback on the legislation once it goes to committee.
Honourable Member for Battle River Crowfoot.
Thank you very much, Mr. Speaker. And, as I very specifically highlighted within my speech, that there is absolutely the need to ensure that the administration of justice, specifically when it comes to things like video conferencing, teleconferencing, and including some of the what seem like small administrative matters, like fingerprinting. Mr. Speaker, I live in a rural constituency. Hours response times for RCMP. In some cases, I have constituents that live more than 100 kilometers from their nearest police detachment, in most cases RCMP, more than an hour. So, Madam Speaker, access to justice is something that is absolutely key and fundamental. And some of the small administrative changes that are being proposed in this bill is something that I think most Canadians would simply suggest are common sense. But I do want to highlight, the member said that serious crimes deserve the punishment. I would suggest that that member take that message to his Justice Minister, because that is the opposite of what that Liberal Party is bringing forward in terms of policy.
Questions and comments? Question commentaire. The Honourable Member for Hamilton Centre.
Thank you, Mr. Speaker, and welcome. I've heard the Honourable Member speak at length about the rights of Canadians, the fundamental rights of Canadians, and yet when it comes to people who are held on remand, who are charged but not yet convicted, would the Honourable Member not agree that improving the administration of justice to allow those people to have their day in court would also help protect their rights? And I would like the member to even go a bit further, perhaps, and reflect on this notion that even when convicted, people in this country still maintain their civil rights.
The Honourable Member for Battle River Crowfoot.
Mr. Speaker, again, rights should not be negotiable, certainly by the whim of a Prime Minister who seems to suggest they are. But the member makes an interesting point. And I think that although I certainly hear the frustrations that when somebody is arrested for a serious crime, they're simply back out on the street, and sometimes a few hours later, and in many cases, I'm not just talking about a handful of cases, but personal testimony, speaking with law enforcement officers are victimizing once again. Mr. Speaker, we need a system that works. We need a system that ensures, the presumption of innocence. Somebody who has been alleged to have committed a crime, that they have their day in court, to ensure that all barriers are removed so that can be done, and done in a timely manner, because, Mr. Speaker, as has been said, justice delayed is certainly not justice served.
Reprise du débat, continuing debate. The Honourable Parliamentary Secretary to the Minister of Employment, Workforce Development and Disability Inclusion.
Well, thank you, Mr. Speaker, and I'll be sharing my time today with the member for Outremont. Mr. Speaker, I am pleased to speak on Bill S4, an act to amend the Criminal Code and the Identification of Criminals Act, and to make related amendments to other acts. Bill S4 addresses issues that the COVID-19 pandemic has brought to light regarding the ways in which criminal trials are conducted in this country. It also builds on past government initiatives, including former Bill C-75, which came into force in 2019 and made significant progress in modernizing our criminal justice system, including by facilitating the appearance of accused persons, lawyers, and judges by audio or video conference throughout the criminal justice process. Former Bill C-75 also enacted criminal code amendments to improve the jury selection process. This bill's amendments support the increased use of technology in criminal courts across Canada, including in the following areas: remote appearances for accused persons and offenders, remote participation of prospective jurors, and the use of technology in the jury selection process. My remarks today will focus on the amendments relating to the use of technology during the jury selection process. And as many of you know, a jury is a group of randomly selected citizens who act as the fact finders in criminal trials, replacing the judge in this role when an accused person has exercised their Section 11F charter right to a jury trial after being charged with certain offenses. It is the civic duty of all Canadians over the age of 18 to serve on a jury if selected. Jurors make critical contributions to the criminal justice system in Canada, and the Supreme Court of Canada has held that a jury reflects the common sense, the values, and the conscience of the community. Section 11D of the Charter also guarantees an accused person an independent, impartial, and representative jury. The Criminal Code sets out the procedural rules regulating jury trials and jury selection, and includes safeguards that reflect this charter right. The jury selection process is a hearing that is held for the purposes of selecting qualified members to form the jury. Typically, persons referred to as prospective jurors are identified and summoned in accordance with provincial or territorial laws and directed to attend at a specified courthouse or other location at a specified date and time in order to partake in a jury selection process. Being summoned for jury duty does not necessarily mean that a person will be asked to serve on the jury. However, compliance with a summons is mandatory, and persons may only be excused from jury duty for certain reasons, including where it would cause personal hardship for them to serve. The COVID-19 pandemic and public health requirements for physical distancing posed significant challenges for the jury selection process, since it sometimes involves several hundred people being physically present in the same location and at the same time. Bill S4's amendments provide courts with the flexibility to hold jury selection processes with prospective jurors appearing by video conference rather than in person. These amendments not only aim to address the challenges caused by the pandemic, but also to optimize the jury selection process beyond the pandemic and moving forward. Importantly, a key aspect of S4 will be increased efficiency of the justice system facilitated by the use of technology. The amendments enable a court to allow or require prospective jurors to participate by video conference, so long as the court considers it appropriate and the accused person and Crown prosecutor consent to the jury selection process occurring this way. Where a court allows a prospective juror to participate by video conference, it will be that individual's choice whether they want to participate in person or remotely. Where the court requires prospective jurors to participate in the jury selection process by video conference, it will need to approve a location that is equipped with the technological infrastructure for them to participate by those means, such as a community center or a courtroom set up with the requisite equipment. If the court does not approve such a location, it will only be able to permit prospective jurors to participate by video conference from another location, such as from their home or office, if they choose to participate that way. However, in this case, the court will also need to provide the option for prospective jurors to participate in the jury selection process in person. These amendments aim to maintain the representativeness of the jury selection process in two ways. First, they facilitate the participation of persons in the jury selection process by reducing the burdens and barriers of attending in person. Although participating by video conference from home or the office will not eliminate the need to take time off work, it will likely lessen the time commitment required compared to commuting to the courthouse and waiting, sometimes several hours, for the process to commence. This can facilitate the participation of prospective jurors living in rural or remote areas by minimizing travel time and costs, and of those who need to find childcare or who hold precarious employment by reducing the time required for childcare or the time they need to take off of work. These changes will both reduce the burden for individual jurors and enhance efficiency of the overall system. Second, the changes will ensure that persons who do not have access to adequate video conferencing technology or who have a limited understanding of the technology will continue to be able to participate in the jury selection process and ultimately form part of the trial jury. The government recognizes that there is a digital divide in Canada and that many Canadians, particularly those in rural and remote areas, do not have adequate access to a high-speed and stable internet connection. Although the government is committed to closing the divide, the amendments will ensure that at least one of a properly equipped location or an option to appear in person will always be available to prospective jurors to ensure participation by as many Canadians as possible. This bill's amendments to the jury selection process also include important safeguards. As mentioned previously, prior to permitting or requiring prospective jurors to participate by video conference, both the accused person and the prosecutor will need to consent to such an order being made. As well, the court will need to determine that making such an order is appropriate by considering listed factors, including the challenges related to the in-person participation of prospective jurors, their privacy and security, and the accused person's right to a fair and public hearing. I would also like to take a moment to touch on the related proposals that will permit the use of electronic or automated means to randomly select prospective jurors during the jury selection process. The current process is both time and resource intensive, as it requires a large number of physical cards with juror identification information on them to be manually created for each prospective juror and then manually drawn as well. This amendment will provide courts with the option of a more efficient and less resource-draining process and, along with the amendments previously discussed, also aims to optimize the jury selection process beyond the COVID-19 pandemic. I believe, Mr. Speaker, that this bill helps transform and modernize our criminal justice system, while ensuring respect for all persons involved in the criminal court process, including accused persons and prospective jurors. A more efficient justice system will benefit all Canadians. And I ask that all members of this House support the passage of this bill as quickly as possible. Thank you, Mr. Speaker.
Questions and comments? Question et commentaire. The honourable member for Courtenay Alberni.
Well, thank you, Mr. Speaker, and I want to thank my colleague for his speech, who I sit on the Standing Committee for Government Operations and Estimates with. Now, Madam Speaker, my colleague knows that the backlog in Canada's justice system, it's not a new issue, and the government has known the system has been in need of an overhaul since before the Liberals first took office from the previous Harper government. So, I'm wondering why they took almost a full year before bringing this legislation back, which is essentially a carbon copy of a bill first introduced in the last Parliament before the House. And also, he knows I live in a remote rural community. It takes me 11 hours to get here. 31 communities, Mr. Speaker, in my riding. So I want to know what specific steps this government will take to ensure that those Canadians who live in remote and rural communities where internet connections are less stable receive equitable access to internet to participate in jury summons remotely, just like urban Canadians where he lives.
The honourable member for Windsor-Tecumseh.
Well, Mr. Speaker, well, first and foremost, I wanted to say I respect very much the work of the honourable colleague as we sit together in the OGO committee, and I really enjoy working together with him and collaborating on projects. Bill S4, this bill takes concrete steps to really make the Canadian justice system more participatory. And what it does is it actually removes many of the barriers. It allows more rural, northern, and remote communities to be able to access and participate in Canada's justice system. It also allows more Canadians with disabilities to participate, for example, in the jury selection process. And it also allows a lot of parents, a lot of moms and dads, for example, that face barriers in terms of childcare in being able to access and being able to participate in the Canadian justice system as well too. But I can tell you, Mr. Speaker, that our government's record and historic investments in expanding broadband to rural and remote communities across Canada, putting record amounts of funding through the Universal Broadband Fund is exactly the types of measures and concrete steps we're putting forward to make sure that, again, Canadians from coast to coast to coast in urban areas and rural and remote areas are able to fully participate in the life of our country, and that includes the Canadian justice system. Thank you, Mr. Speaker.
Questions et commentaires. L'honorable.
The Honourable Member for Lac-Saint-Jean. Thank you, Mr. Speaker. I very much appreciated the speech from my honourable colleague. As you know, we'll be voting for Bill S4, but I feel that it seems that the government is just going around dousing flames rather than actually fixing the criminal court system. The Canadian justice system needs a full, comprehensive review rather than a piecemeal approach. Society is evolving. We know more about mental health now. We know more about prevention. We know more about readaptation, rehabilitation, especially in Quebec. So, does my honourable colleague believe that we should not just have a piecemeal approach? Well, we're going to vote for S4, but next time, rather than having a piecemeal approach with regard to the criminal code, shouldn't we have a full review of the criminal code to modernise it once and for all for the well-being of Canadians? Thank you, Mr. Speaker.
L'honorable secrétaire parlementaire.
Well, thank you, Mr. Speaker, and I very much appreciate the question that my honourable colleague has posed, and I appreciate the stated support for this important bill. Certainly, this is about modernising Canada's justice system. This is one step, but it is a concrete step. And I know that my colleague would also appreciate the fact that S4 was really informed by dialogue between the federal government, between the provinces, and between the territories as well. And S4 is really the product of the Action Committee on Court Operations in response to COVID-19 that was chaired by the Justice Minister and also by the Chief Justice as well too. So collaboration, consultation is really at the heart of this, and really this is just one piece of that fuller modernization of the Canadian criminal justice system in Canada. Thank you.
We have time for a very short interaction. So the honourable member for South Shore St. Margaret's.
Thank you, Mr. Speaker. I'm wondering, since the honourable member was elected in 2019, whether or not this bill, I think, which was introduced then, whether he discussed with his leader at the time that he shouldn't call an unnecessary election at the time in order to get this bill passed if it was such a priority.
Honourable Parliamentary Secretary.
Well, thank you, Mr. Speaker. I thank the honourable colleague for the question. I mean, this is a concrete step that this government is taking in consultations with our partners, provincial, territorial partners, other stakeholders as well. This is a concrete, important step to modernize Canada's justice system, to make it more efficient, make it more participatory. And I certainly appreciate the fact that all members of this House, it looks like, will be supporting this critical, important bill. Thank you.
Reprise du débat, continuing debate. L'honorable secrétaire parlementaire.
The Honourable Parliamentary Secretary to the Minister for Tourism and the Associate Finance Minister.
Bon matin, Monsieur.
Good morning. Good afternoon, Mr. Speaker. I'm pleased to be speaking to Bill S4 today. an act to amend the Criminal Code and the Identification of Criminals Act and to make related amendments to other acts at second reading today.
Mr. Speaker, Bill S4 reforms the Criminal Code and related acts in order to modernize the criminal justice system here in Canada. The bill seeks to provide courts with greater flexibility in the manner in which they conduct their business while respecting the rights of all participants in our justice system. As a former litigator, I understand and I truly believe in the importance of doing this. And while I'll detail some of the specific measures included in this bill in my speech today, I would like to take a moment to speak more broadly about why modernizing our justice system is so critical and is so critical particularly at this time. Let's take, for example, gender-based violence, Mr. Speaker. Gender-based violence is on the rise. Frontline organizations saw increases in gender-based violence of about 20% during the pandemic. Domestic violence, in particular, is on the rise. We are at the beginning of our 16 days of activism against gender-based violence, Mr. Speaker. Access to justice is a critical piece of solving this puzzle. We have seen backlogs in the courts due to the pandemic. We've seen increases in the demand for our justice system and in particular for the time of our judges. And so freeing up resources, ensuring that judges are available in the courts in order to do the work that Canadians need of them is of fundamental importance in respect of gender-based violence and all forms of violence in this country. And Bill S4 goes a long way in order to ensure that our justice system is not only modernized, but is in fact streamlined and that additional resources are available for litigants that require it. I'll now speak more broadly, more specifically to the telewarrant-related amendments of Bill S4, which have been well received by many witnesses, Mr. Speaker. Witnesses noted that these new provisions simplify the warrant application process, they improve access to judicial services, and very importantly, they save police resources. À l'heure actuelle, les dispositions du
The current criminal code provisions for telewarrants permit peace officers to seek via telephone or other telecommunications methods some of the warrants in the criminal code. The criminal code telewarrant system was adopted in 1985, Mr. Speaker. So it's high time to reform the system. It's important to remember that the telewarrant system was established in order to give law enforcement better access to judges in applying for search warrants and also in order to make it more effective to deal with law enforcement challenges in such a large country as ours, because sometimes the nearest person can be 1,000 kilometers away. Since their enactment, our telewarrant provisions have only been updated occasionally, notably in 1994, when they were amended to allow for search warrants to be applied for by means of telecommunication in a written format to accommodate, at that time, new ways of communicating in writing, such as by fax. During the pandemic, courts were able to use new technology to decrease possible health risks of actors in the legal system. This, Mr. Speaker, showed the important role that technology can play in resolving some challenges in the criminal justice system. So, broadening the telewarrant system and its provisions would allow for more flexibility in the ways that courts and police services meet the requirements necessary to use investigative tools. It would not, though, have any effect on the legal protections related to granting of warrants. Peace officers would continue to make decisions in the most appropriate way. With this approach, Mr. Speaker, we are modernizing our legal system in order to make justice more effective and efficient. all while freeing up more resources for our judges and for law enforcement. Here's an example. Gender-based violence. Gender-based violence, we know that it is increasing at a very worrisome and alarming rate, and we know that access to justice is critical for women in these situations. We need to take action against gender-based violence. We need to make the necessary changes to our legal system in order to allow increased access to justice for all. It is absolutely crucial.
Amendments to the telewarrant process address the following issues. First, the current telewarrant regime is only available for some warrants and investigative orders under the Criminal Code, such as the general warrant or a warrant to obtain blood samples in impaired driving cases. However, the telewarrant regime cannot be used for many common judicial authorizations sought by law enforcement, such as warrants, for example, to seize firearms, warrants for trafficking devices, and orders to produce data. In addition, at the present time, telewarrants, as opposed to warrants obtained by personal attendance, may only be issued in respect of indictable offenses, and telewarrant applications may only be made to specially designated justices. Furthermore, while public officers responsible for enforcing federal statutes may apply for criminal code search warrants and other judicial authorizations, they can only do so by applying in person. Compte tenu de la
Given the limits of the telewarrant system and process, police officers spend countless hours on the road and waiting outside peace justice offices at the courts in order to get warrants when they can't request it, as it currently stands, through telecommunications. We want to streamline and standardize the process. It would thus apply to a wide array of warrants, orders, and inquiry authorizations.
Where the search warrant application is submitted by means of telecommunication that produces a writing, for example, an email, a peace officer will no longer be required to meet the existing precondition, Mr. Speaker, that it is in place right now, that it has to be impracticable to appear in person. The current in-person search warrant application process often involves hand delivery of applications by police officers at the courthouse without even an interaction with a judge. By removing the impractical to appear in person requirement, search warrants applications submitted in written form will be treated in the exact same way, whether they are submitted electronically or in person. However, the police officer's ability to make an oral application for a search warrant by phone, for example, will be maintained in situations where it is impracticable to present the application electronically. For example, where the officer is in a remote location with no internet access. These changes to the current law to accessing telewarrant regimes promote the use of written applications as a standard approach, Mr. Speaker, to be followed by law enforcement when applying for their authorizations. En conclusion, Monsieur le Président.
In conclusion, Mr. Speaker, allowing for more types of judicial authorizations and for more types of mandates through technology would lead to efficiency gains in the criminal justice system because it would decrease situations where law enforcement have to obtain these authorizations in person and physically apply for search warrants and other warrants. Thank you. Questions and comments? The Honourable Member for Pierre Boucher, Les Patriotes Verchères. Thank you, Mr. Speaker. I listened carefully to my colleague's speech. She spoke to the bill we're seized with, S5, if I'm not mistaken. S4, thank you for helping me out. Here's what I'm wondering about. She spoke a lot about the legal system, and yes, it's very important to have a strong legal system, but there's an issue in the legal system in Quebec, something that Quebec has been asking for years and years. I didn't hear my colleague mention it, and I don't see it in the bill either. The bill under study today, and that is the domination of judges. So Quebec's court judges are appointed by the federal government. I feel that we should choose our own judges. It would be natural and logical to choose our own judges to rule on cases which are of interest to Quebecers. So does the federal government have a response to this claim that Quebec has been making for a long time? Is there any hope for this to become a reality? The Honourable Parliamentary Secretary. Thank you, Mr. Speaker. I thank my colleague for his question. Now, he clearly is not an expert on S4 because his question is not part of the bill we're seized with today. Now, I do understand the issue he's raising. I understand it very well, but that's not what the House is debating today. It's not part of S4. Thus, I think that we should, in fact, concentrate on the debate at hand. Questions and comments?
Member for Hamilton Centre. The block. There you go.
Thank you very much, Mr. Speaker. I rise today because I've had the opportunity of working with the honourable member across the way, and I put this question to another member of the Liberal caucus in their response to this bill, but that member couldn't answer it. I know that this member is a learned lawyer with a lot of experience, spoke at length about how providing resources and materials to the justice system help alleviate and access to the process of justice. So I'm wondering, as a means to addressing the court backlogs, why did the government oppose recommendation number 1 of the House of Commons Standing Committee on Justice and Human Rights, that legal aid called on the federal government to remove legal aid funds currently included in the Canadian social transfer in favor of a specific earmarked civil legal aid fund for provinces administered under the Department of Justice Canada Legal Aid Program?
The honourable member for Outremont.
Well, I would like to thank my honourable colleague for his question. I do not sit on the committee in which that debate took place. I would be happy to take cognizance of the evidence that was before committee, but I think as any good lawyer, I will not opine on an issue without having all of the facts before me. I certainly appreciate his work on the Emergencies Act Committee and look forward to continuing the conversation with him.
Questions and comments? Questions et commentaires. L'honorable député de Beauport-Limoilou.
The Honourable Member for Beauport-Limoilou. Thank you, Mr. Speaker. Today, thanks to technology, we can accomplish things which used to be a lot more difficult. The colleague did address that. When it comes to timelines to get warrants, when it comes to timelines for people to be seen in court, I ask, through you, Mr. Speaker, a question of my colleague. The current bill, does it make enough improvements so that the Jordan are less frequent? The Honourable Parliamentary Secretary. Thank you, Mr. Speaker. I thank my colleague for her question. There is more to do. We do need to do more. We could do more. But, as was said earlier during debates, S4 was tabled during the previous legislature. It's from the Senate here. It does improve access to justice. It will lighten the workload of our judges. I think it's positive, but is this the last step in the process? No, Mr. Speaker, we will have to do more.
Well, we'll do a very short question. The Honourable Member South Shore St. Margaret's.
Short, I'll ask the same one that I asked the previous member from the government who didn't seem to be able to answer the question. This member was also a member of the government in the last Parliament when a similar bill was imposed, but the Prime Minister called an unnecessary and early election. So I'm wondering if the bill was such a priority for this government, if this member is a member of the government, then had raised the issue that they shouldn't call the election while we have this kind of pending legislation.
Parliamentary Secretary to the Minister of Tourism.
Thank you, Mr. Speaker, and I do appreciate the question, and I will answer it to the best of my ability. In my personal opinion, that election was important. It was a question that was put to Canadians, and Canadians went to the ballot. when Parliament is dissolved, there are always bills before this House that unfortunately, do not get passed due to the fact that an election is called. The fact that this bill has returned in this session and could potentially move quickly with the cooperation of all members of this House is certainly something that I feel is important. And if all members of this House agree on the importance of this legislation, I'm not sure why we cannot move swiftly in order to pass it. Thank you, Mr. Speaker.
Reprise du débat, continuing debate. The honourable member for Saskatoon, Grasswood.
Thank you very much, Mr. Speaker. Good day, everyone. It's my privilege to speak to Bill S4. Before we get underway here today, I want to share my time with the honourable member from Tobique-Mactaquac, and we're looking forward to hearing his comments as well as my comments. As you all know, Mr. Speaker, the goal of this bill is to increase the efficiency, the effectiveness, and accessibility of the criminal justice system in response to really the challenges that we had with COVID-19 pandemic, which really has contributed, as we all know, the enormous backlog that we have in the criminal justice system here today. Conservatives, though, on this side of the House have been raising concerns about delays and potential for criminals to simply walk free due to the Supreme Court's decision on Jordan. That decision said no more than 18 months can pass between laying a charge and the end of a trial case in provincial courts, or 30 months for cases in superior courts. We've seen a number of cases throughout Canada provincially, certainly exceeding the 18 months over the last couple of years. So in the interest of serving justice, why would we not implement all the modern tools and resources at our disposal today to maximize productivity? The resources are being considered are amending the process for peace officers to apply and obtain a warrant using telecommunications rather than appearing in person, expanding the ability to conduct fingerprinting of the accused at a later date. In exceptional circumstances, should fingerprinting not previously have been taken, the justice would have the discretion to determine what is considered necessary in the circumstances. And expanding the power of courts to make case management rules permitting court personnel to deal with administrative matters for accused who are not represented by counsel. We currently have a case in Saskatoon that this certainly applies to, and currently this only applies, as many know, to represented by counsel. Expanding the ability for the accused and offenders to appear remotely by audio conference or even video conference in certain circumstances. Allowing the participation of prospective jurors in the jury selection process by video conference by deemed appropriate if the prosecutor and the accused consent, and using electronic and automatic means to select jurors. As you can tell, some of these modernizations are beneficial from both a safety and a financial perspective. For an example, participating virtually, I think, would cut down on the transportation time and the cost, the resources needed to transport and protect the victim. The transportation costs, as you know, in this country are skyrocketing, it seems, every day, and we all know that, so it's not an insignificant consideration considering the price of diesel and the price of gas, especially in remote and northern communities. The federal ombudsman for victims of crime has raised also a number of concerns regarding the impact of COVID-19 on the justice system in this country, which must be carefully weighed in the consideration of this Bill S4. The Ombudsman pointed out that accessing justice in remote areas of the country where bandwidth and internet access remain an issue could actually have a negative impact on the delivery of justice, and we would not want to see that. She also flagged the issue of ensuring jurors remain anonymous and the potential to compromise their privacy with facial recognition software. For some victims and their families, it is an important part of their healing process to see the accused and the offenders in person or by video conference. In these situations, the use of telephone would certainly deprive them of this opportunity. The needs of the victim, Mr. Speaker, must, and I repeat, must always be weighed when considering an amendment to the Criminal Code. Access to the internet for rural Canadians, as I said, has been a long issue in this country. This current government has promised for years to improve access to the internet, and we know this is a big issue in rural Saskatchewan, where I live, and certainly in remote and northern spots in Canada, as it is blotchy to say the best. It cuts in and out, and it has been an issue for the last 7 years that this government has been in office. Not everyone has access to the internet. We saw this during COVID, where schools tried to participate in classrooms. Some didn't have access to even a computer. So you can see there are issues with the internet. That is a concern, though, to the prospective jurors to appear by video conference during the jury selection. I must say, a jury summons, as we all know, is a very serious responsibility. When you open that letter up, many Canadians simply, I think, can't take time off, particularly if they're a small business owner. It's near impossible for many to be compensated properly. As we all know, time is money, and for the majority in this country, the two are certainly hard to fit in when you do open that letter and you've been selected for jury duty. Our legal system, without question, I think we've talked about it for the last 2 days in this place, it needs to improve. Bill S4 aims to increase the efficiency, the effectiveness, the accessibility of the criminal justice system in response to the challenges that we occurred over the last 2 years with the pandemic. This bill also clarifies and somewhat broadens the circumstances under which accused individuals, the offenders, and others involved in criminal proceedings may appear by audio conference or video conference, as I have said. I just want to step back, and I want members think about the horrible incident that we had at the James Smith Reserve in my province of Saskatchewan, where unfortunately 11 people lost their lives over a warrant that was out for months on Miles Sanderson. Sanderson, if you recall, became one of the worst mass murderers in Canadian history. That day was September 4th. Sanderson murdered 11, injured 18 others during an early morning killing spree. In total, when Sanderson did die, he had been charged with 125 crimes. 125 crimes. Now, James Smith is a small community, roughly about 1,900 in northeast Saskatchewan. So when we see tragedies like this occur, we often have to ask ourselves, now, could we have prevented this? The warning signals were there for months, if not years. It's not a coincidence that since 2015, the violent crime rate in Canada has gone up 32%. This is a staggering statistic that this government must answer for. The community now is left in James Smith to pick up the pieces of this senseless act. The community has been victimized. Victims should be given at least as much consideration as offenders, but in S4, they're not even mentioned once. This soft-on-crime agenda by this Liberal government is not serving justice in this country. This bill follows other pre-pandemic efforts to modernize the criminal justice system and reduce the delays in court proceedings. Delays in the criminal justice system were already a serious issue before the pandemic. The measures contained in Bill S4 will both modernize and make it more efficient, hopefully, for certain aspects of the delivery of justice in this country. Before I leave, Mr. Speaker. Several family members have come forward in recent weeks with the traumatic stories from the James Smith Cree Nation tragedy. Their stories are a crucial part, I believe, in the healing process in the delivery of justice on that reserve. These are people we must be mindful of when crafting carefully this legislation. If we get the bill right, it will balance the need to improve efficiency with the rights of the people it serves, and always consider the victims and their families as a cornerstone of any justice legislation. Thank you very much.
Questions and comments? Question commentaire. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. The legislation S4, in essence, takes the idea of technology and the experiences we had during the pandemic, that the judicial system sees the benefits of having video conferencing, and it kind of incorporates that. It's legislation that has been here for quite a while now, even predates the last federal election. I understand the Conservatives are going to be supporting the legislation. So they've taken the opportunity to add additional comments. And the additional comments try to give the impression that the Conservative Party is tough on crime and they think of the victims. And they can say what they like, but I think it's important to recognize that I believe all parties inside the chamber understand and have a great deal of sympathy and empathy for victims. We have a judicial system that is there to protect the interests of all Canadians, Mr. Speaker, and I think it's something in which we can be proud of. And my question to the member is does he not feel, given the very nature of the support of the legislation itself, that this is a legislation in which we can all get behind, given that it's important to recognize the technology and the advancements of it?
The Honourable Member for Saskatoon-Grasswood.
Thank you, Mr. Speaker, and I'd like to thank the member from Winnipeg North. I brought up the victims because they weren't mentioned in S4. You know, James Smith Cree Nation in Saskatchewan, it happened September 4th. Now we're at the end of November. Those people for the last 3 months have been victimized more than ever. It's many of their families, many relatives, and we have not spoken to that. Every day in the Saskatoon Star Phoenix or other news organizations in Saskatchewan, they talk about this, the healing process. This could take months, if not years, if ever, that they forget what happened when Miles Sanderson took the lives of 11. We need to modernize the justice system. There's no question with that. I would even say we probably at times should modernize the House of Commons. But we get stuck in our ways over the years and over the decades. But this is one way I think that we can all agree that the justice system needs to end the backlog and get people up in front of the court sooner than later.
In comments, question et commentaire. L'honorable député de Beauport-Limoilou.
The Honourable Member for Beauport-Limoilou. Thank you, Mr. Speaker. About 80% of communication is nonverbal. So you can say something and your face says something else. And there's movement too. And although video conference allows us to see a person, part of the message is lost because of the lighting and the framing and so on. Or it could be amplified for other reasons. So that could lead to a misinterpretation of a person's body language or whatever when it comes to choosing a juror or the credibility of a suspect, for example. So I'm just wondering about, in cases like that, what kind of solutions could we have to avoid miscarriages of justice because of misinterpretations of nonverbal language? The Honourable Member for Saskatoon.
Very good point. You know, here we are today, we're in the screen. Sometimes we're on the screen, when they zoom in, you're fidgeting. You don't see that. I think of the court case and the jury selection in the Colton Boucher in North Battleford, a very controversial court case that happened in Saskatchewan a few years ago. and there was a lot of finger pointing who was on the jury, who was declined on the jury. This is something we'll have to work through. There is no perfect answer for this. You're right, sometimes you get, and we often see it here in the House of Commons, you know, the video isn't as good or the sound isn't as good. So there will be challenges certainly going forward when we do video conferencing or even audio conferencing in this.
Quick interaction. The Honourable Member for Edmonton Strathcona.
Thank you, Mr. Speaker. And I would like to thank my colleague for his intervention today and give him my sympathies for the horrific events that happened in Saskatchewan, in his province, in the James Smith Cree Nation. I think all Canadians are horrified by that, and so I want to express my sympathies to him. He spoke a lot during his speech about the failures of the Liberal government to deal with crime, to deal with policing adequately, and I probably don't agree on how that should happen, but I think we can both agree that the Liberals can do and must do much more to make our judicial system and our policing system strong. But I would wonder, you know, he was very critical of the Liberal government. I'm just wondering whether or not he sees his own Conservative government in Saskatchewan as also having some obligations with regards to that joint jurisdiction of policing and justice.
I hate to say we're out of time, but I'll let the member answer. The Honourable Member for Saskatoon-Grasswood.
Well, thank you very much, Mr. Speaker. Yeah, I think all provincial jurisdictions are looking at justice right now, whether you're in Saskatchewan or her province of Alberta. These are questions that are being spoken every day, whether you're in Regina or in Edmonton. There are changes that have to be made, and provincial governments are looking at it, as we are here in Ottawa. Thank you.
Reprise de débat, continuing debate. The Honourable Member for Tobique-Mactaquac.
Thank you, Mr. Speaker. It is an honor to rise here today and to be speaking in this House in regards to Bill S4. And obviously, we've been spending some time reviewing the attributes of the bill, the importance of making sure that we're addressing the backlog issue that's within the criminal justice system and ways that we can better expedite that. Obviously, in relation to the aftermath and the effects of COVID-19, the ever-increasing backlogs that are there. And one way of doing that and addressing that is making sure that, obviously, the technology that we have available and disposable to us is utilized effectively to help address those where possible. And that's why I think overall, in principle, we support this bill. There may be some friendly amendments that we want to see passed and accomplished and done through the process of this bill working its way through the House. But the need to address the challenges and the backlogs within the criminal justice system should be paramount. There is a rising frustration with that backlog issue and people who are facing delays in justice. And justice delayed, there's a term or expression that says, is ultimately justice denied. And we need to do whatever we can as parliamentarians to effectively address that backlog and to make sure that justice is delivered fairly, equitably, and expeditiously. I couldn't help in preparation for my remarks today but think of an old country song. I think it's a folk song. I won't sing it today, Mr. Speaker, but they'll all leave here very quickly. But it's an old song you may recognize. It says, "There's a hole in the bucket, dear Liza, dear Liza. There's a hole in the bucket, dear Liza, dear Liza." She says, then fix it, dear Henry, dear Henry, dear Henry. Then fix it, dear Henry, dear Henry. And then it goes through all the excuses of, well, I need straw, or no, I need an axe, and no, the axe won't work because it's dull, and no, well, then she said, use a rock and sharpen the axe. Well, I can't find the rock and it's not smooth enough. Well, we'll get you water and we'll fix that. And they go back and forth, and bottom line is, the excuses kept coming for not addressing the hole in the bucket. And they kept offering up reasons as to why it couldn't be fixed, and the hole never got addressed, but the excuses kept being offered. Well, I stand in this House today to say that there is a hole in the justice bucket, dear Speaker, and we need to address the hole in the justice bucket. And it's not just the backlogs, but today I want to address, I think, the bigger issue, which is stopping the revolving door in and out of our prison system. And I think we can't just address the backlog issue without discussing the bigger picture, which is how do we make sure those that have committed crimes and after they have served their time and paid the debt to society and are returning back into communities, how can we ensure that they don't re-enter the system, re-enter the judicial system, and clog up the system again or create more backlogs? The best way to do that is addressing the hole in the bucket, as it were, and making sure we are addressing the rates of recidivism and how we can collectively get those rates down. And the best way I feel that we can do that is through effective partnerships. Yes, government has a role. Yes, the judicial system has a role, but so do some tremendous organizations and groups within our country and across our nation that help make sure we address the root causes of the hole in the individual's bucket. And how do we do that? I think it's by reaching across not just the aisle here to get good legislation passed. That's important. That's one step. And making sure bills are improved upon and made the best that they can be to address things like backlogs, but also looking at what are the best practices around the world, not just here at home within our own country, and there are some great practices that are having great results that need to be looked at, but also look across the aisle and across the world for systems and programs that actually are having tremendous effect in reducing the overall rates of recidivism. You see, Mr. Speaker, this is an area of passion for me because in the last Parliament I had the privilege of seeing my private member's bill, Bill C-228, pass and become a law thanks to the overwhelming support of members on both sides of the aisle, and I'm very thankful for that, and had good input on that bill from various parties. And we saw it come out of the Senate unanimously, and it became a law in June of 2021. That bill was for the purpose of addressing recidivism and making sure we do what we can to bring those rates down and stop the revolving door in and out of our prison system. You see, what we're seeing is at that time, just a year and a half ago, when I proposed the bill and the bill went through, the rates of recidivism in this country, Mr. Speaker, were right around 25% or close to 25% recidivism. What that means is those who've served their time, got out of federal prison, up to 25% of them were ending up back in the criminal justice system within 2 years. That's a tragic statistic. But what's even more tragic, those stats have gotten worse in just the last 18 months. And I can tell you, right now, it's nearly a third, close to 33%, according to the latest StatsCan statistics on the Department of Justice website, that it's over 30% of those adult offenders are finding themselves reconvicted. Talk about a hole in the bucket. We've got a massive hole in the bucket in the criminal justice system of Canada that needs to be addressed. Now, some would say, we got to do this, and that's going to be the ultimate answer, or we can do that, and that's going to be the ultimate answer. I think somewhere it's going to take a bit of all different types of approaches to get the balance right to correct this problem. Yes, there's a role for the punitive role of criminal justice. There has to be adequate punishment for severity of crimes. Absolutely. If you do the crime, there has to be time that is served, and they must make sure that they pay their debt to society, especially heinous and violent crimes. And that is absolutely critical, and we advocate for that on this side of the House. But we also need to recognize that there is a role for restorative justice, a role for those who come alongside and are complementary on the back end to make sure that those who've committed the crime, once they've done their time, that they're getting the help, not only while they're serving their time, perhaps with new and innovative programs like what's being proposed by my honorable colleague from Kelowna Lake Country with her recent private member's bill to address addictions while people are incarcerated. That would be a great step in the right direction to start some of that good programming while they're on the inside. And then also make sure that when they get on the outside, we're partnering with effective organizations that are doing tremendous work to make sure that once people are released from the prison system, they are finding a place to go where they can get education completed, 12-step support, 12-step programming, life skill development, and job opportunities and placements. Because oftentimes when people come out of the criminal justice system, it's hard for them to find meaningful employment because they have a criminal record. So how can we effectively work together with other organizations to find solutions, not only on the front end or while they're incarcerated, but also once they've been released? This would go a long ways in addressing the backlogs in the criminal justice system, is to reduce crime overall. So you need to be a deterrent to crime with obviously the punitive approach to make sure that, hey, if you do this criminal activity, there's consequence. But there also needs to be a restorative approach that makes sure that, hey, if you've messed up and you made a mistake, we've got supports that can come in line and bring you the help that you need to make sure you don't go back into the life of crime. I think that two-pronged approach is going to help address that proverbial hole in the bucket that needs to be addressed. So, Mr. Speaker, I thank you for the opportunity to be able to address this today and to be in the House today. And I can't help but think of all those who are serving in the field and volunteering and helping to make a difference in keeping people from going back into criminal lifestyle. And I pay tribute to them today, and I thank the volunteer organizations and the nonprofit organizations and chaplains and others who are working and doing the hard work, the necessary work, the work of coming alongside the wounded in our society to make sure they're getting the help that they need so that we do help our communities as a whole and also help victims in making sure that those who perpetrated the crimes against them don't reoffend and that they help others who are in need. So, Mr. Speaker, with that, I conclude my remarks today, and I thank you for the opportunity to address this. And let's do all that we can to fix the hole in the justice bucket.
Questions et commentaires, questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice.
Thank you, Mr. Speaker, and I'd like to thank my friend for his comments. And I echo his final sentiments with respect to those who work in the system, and especially the chaplains, where I was able to meet with many of the prison chaplains this week. But I do want to get to the bill. The substance of the bill is to modernize our court system. If he can maybe highlight the top three things that are in this bill that can help make this system more efficient.
The Honourable Member for Tobique-Mactaquac.
Well, thank you, and I thank my honourable colleague, and I commend him for meeting with the chaplains this week. I think that's such an important, and the role the chaplains play in our system is critical. Oftentimes doesn't get near the appropriate acknowledgement that it should, and so thank you for doing that. In regards to this bill, what I do like about the bill is that it is, Mr. Speaker, addressing the backlog issue and using technology to try and make sure people in perhaps remote areas or rural areas that wouldn't have normal access or be able to get in easily are able to be part of the process and help streamline this. I think it's so important when we are considering any bill to do with criminal justice and justice reform that we are addressing the rural component of that. We have a rise of rural crime, and there seems to be a disproportionality in the level of response of those who live in urban centers and those who live in rural areas and small towns like where I come from. It's important that we get techniques and technology in place to help us address those kind of issues. Thank you.
Commentaires, questions and comments. L'Honorable.
The Honourable Member for Drummond. Thank you, Mr. Speaker, once again. The infamous tough on crime. We need to be tougher on crime, apparently. And, well, I agree with the principle. We need to stand up and we need to make sure that violent criminals serve their time for the crime that was committed. But there are many other factors that we have to take into account. The cost of a detainee is $110,000, $120,000 a year. We have to take that into account. We also have to take into account the fact that the longer one's sentence, the lower the chance of rehabilitation is. So when someone is sent to prison, we have to take into account the investment that one can make in rehabilitation, readaptation of that person. If the detainee wants nothing to do with this, then yes, they should serve their full sentence. But the issue goes beyond to tough on crime. It's more of a question of an issue in the parole system and the pressure on the parole board than on sentences that are handed out in the first place. The latter is not the issue. So what data is my colleague using to claim that it would be more effective and efficient when it comes to reinsertion, readaptation, rehabilitation, to have more severe sentences for the crimes you mentioned? The Honourable Member for Tobique-Mactaquac.
Mr. Speaker, I'm not sure if my honourable colleague heard my address, but I really felt like I spent quite a bit of time on talking about the absolute necessity of the two-pronged approach, that we certainly need to have what we call tough on crime measures, and that the punishment meets the type of crime for heinous crimes that have major consequences on the victims of those crimes, so that people out there understand we don't take crime lightly. and that there's consequences for violent, heinous crimes, and there has to be punishment for it. But at the same time, we need to be working very hard on the restorative side and putting in place effective partnerships with organizations that are having tremendous effects in dealing with the root causes of some of these crimes, whether it be addictions, whether it be other social ailments. We need effective partnerships that can work both on the inside while they're completing sentences and on the outside when they get out. Thank you, Mr. Speaker.
Questions and comments? Question commentaire. The honourable member for Haliburton, Kawartha Lakes, Brock.
Thank you very much, Speaker, and I appreciate the words from the member opposite. I think we're all enlightened and enthralled with what he had to say. It was certainly a topic that has captured the interest of many Canadians, and hopefully in order of that magnitude, I can take some lessons from him and one day live up to that bar. But he did speak about rural crime, and that's something that my communities are facing for quite some time now. A number of pieces of legislation passed by this government has created problems that police and prosecutors in my area are raising the flag about, and I'm wondering if that member can expand a bit more on that topic.
The honourable member for Tobik-Mactaquac.
Thank you, Mr. Speaker, and I'd like to thank my honourable esteemed colleague. He always has questions that are astute and astounding, and I'm forever thankful for that. But I will say this, when it comes to rising crime in rural communities, this is an issue that needs to become a priority, and a priority fast. The numbers are staggering, and what we're finding is in remote and rural areas, they're having a harder and harder time getting access to law enforcement, and our law enforcement resources in the rural and remote areas is stretched to their limits. We need greater investment in the area of law enforcement, and we also need to make sure that there is consequences for the actions and the crimes of those who live in rural areas, and make sure that the people in those rural areas know the government has their back. We're going to be at their side and do everything we can to empower them to defend their property and stand up for their rights.
Reprise du débat, continuing debate and staying in the beautiful province of New Brunswick. The honourable member for Fredericton.
Well, thank you, Mr. Speaker, and I agree it is a beautiful province. I'll be sharing my time with the member from Edmonton Strathcona. I am pleased today to have an opportunity to speak to Bill S4, an act to amend the Criminal Code and the Identification of Criminals Act, and to make related amendments to other acts, COVID-19 response and other measures. This bill will increase our justice system's efficiency and ensure that all Canadians have equal access. The COVID-19 pandemic altered our everyday lives, including necessitating new ways of accessing the criminal justice system. The solutions invented to accommodate our circumstances proved efficient and should be used going forward to optimize the ways in which criminal trials are conducted in Canada. This bill's amendments support the increased use of technology in criminal courts across Canada. This has a variety of applications, such as the use of technology in the jury selection process, remote participation of prospective jurors, and remote appearances for accused persons and offenders. I want to focus first on the amendments relating to the jury selection process. The amendments enable a court to allow or require prospective jurors to participate by video conference so long as the court considers it appropriate and the accused person and Crown prosecutor consent to the jury selection process occurring this way. Where a court allows a prospective juror to participate by video conference, it will be that the individual's choice whether they want to participate in person or remotely. Importantly, Bill S4 accompanies our government's efforts to increase remote internet access across our country and close the digital divide. However, while we work toward efficient Canada-wide internet access, there are measures in place to help individuals who may not have optimal connection. Where the court requires prospective jurors participate in the jury selection process by video conference, it will need to approve a location that is equipped with the technological infrastructure for them to participate by those means, such as a community center or courtroom set up with the requisite equipment. If the court does not approve such a location, it will only be able to permit prospective jurors to participate by video conference from another location, such as from their home or office, if they choose to participate that way. However, in this case, the court will also need to provide the option for prospective jurors to participate in the jury selection process in person. These amendments will help our jury system represent the face of Canada. Increased representativeness will be ensured by first reducing the barrier of attending in person. Prospective jurors living in rural or remote areas will enjoy minimized travel time and costs, and those who need to find childcare or who would hold precarious employment will experience reduced time required to find alternative childcare or time needed off work. It would also reduce emissions, I will add. Second, the changes will ensure that persons who do not have access to adequate video conferencing technology or who would have limited understanding of the technology itself will continue to be able to participate in the jury selection process and ultimately form part of the trial jury. These are critical measures to bridge discrepancies in internet access while we work to shore up connection across Canada, including in my home province of New Brunswick. In addition to improving the criminal code regime governing the use of technology, other reforms in this bill will improve access to justice and efficiencies in our criminal courts. For example, Bill S4 will expand the power of courts to make case management rules to allow court personnel to deal directly with unrepresented accused persons on administrative matters for out-of-court proceedings. Currently, this is only permitted if the accused person is represented by counsel. This may represent a relatively small change to the criminal code, but I believe it will go a long way to improving access to justice for unrepresented accused persons. It is very important to note these uses of technology are optional and subject to the judge's discretion as opposed to mandatory, and I want to stress this point. These measures will assist courts in continuing to deliver justice in an effective and efficient way. The proposed reforms will also better equip courts with the tools to keep things moving during challenging times, either because of a pandemic, a flood, or any other situation that could hinder physical access to the courts in the future. While these reforms may be relied on in a more significant way in managing exceptional and emergency circumstances, they will not be limited to such circumstances. They will apply only on a permanent basis to ensure that the options to use technology continue to be available to our courts for years to come. Another important element of increased efficiency in this bill pertains to digital fingerprinting. Bill S4 amends the criminal code to allow a court to issue a summons for fingerprinting where an accused was previously required to appear, but such identification was not completed for exceptional reasons. In addition, courts will be able to make an order for the fingerprinting of an accused person being released on bail. These reforms will facilitate the efficient collection of fingerprints, which is critical for the smooth functioning of our court system. When courts operate efficiently, more Canadians access justice and our country is better off. Mr. Chair, the expanded telewarrant system is also critical. Expanding the possibility of obtaining a wider number of search warrants and other judicial authorizations by means of telecommunication will contribute to efficiency gains in the criminal justice system by reducing the need for in-person attendance and physical delivery of search warrant applications by law enforcement. Indeed, courts have found that seeing a complainant or witness face-to-face is not fundamental to our system of justice, and the criminal code has permitted remote attendance by witnesses for more than 20 years. Subsection 800.2.1 has authorized summary conviction trials by video for in-custody accused since 1997. Sections 714.1 and 714.2 have permitted appearances by witnesses by video conference since 1999. Bill C-75, which was passed by this House in 2019, modernized and facilitated some appearances by audio or video conferences of all persons involved in criminal cases, including judges, under certain circumstances. Rather than overhauling criminal procedure, Bill S4 continues to permit proceedings by remote appearance. This bill picks up where Bill C-75 left off, in light of the experience that was gained and the questions that arose with use of technology in the criminal courts during the pandemic. Now, Mr. Speaker, I'd like to personalize this for a bit, if I may. Before entering this House, my work was centered on supporting youth at risk in the education system. From time to time, students would find themselves interacting with the justice system. I had the opportunity to help them navigate these public institutions, understand their rights, and when the circumstances permitted, to also pursue justice. I remember a particularly frustrating time in which unnecessary delays prolonged the personal suffering of a survivor of sexual assault, adding to their trauma. I remember the anger and frustration this evoked, the feelings of helplessness for all involved. Canadians deserve a justice system that is accessible, efficient, and effective and provides true access to justice for all. The pandemic has taught us that technology can be used to help make the justice system work better for all people who come in contact with it. Bill S4 proposes a range of reforms that will make court proceedings more flexible while protecting the rights of participants. The reforms proposed in S4 flow from the important work of the Action Committee on Court Operations in Response to COVID-19, co-chaired by the Minister of Justice and Chief Justice Richard Wagner. They are also informed by important contributions from the provinces and territories, as well as other justice system stakeholders. With S4, we have the opportunity to improve our justice system by making those good ideas permanent. Now, Mr. Speaker, S4 is an example of how we can improve the legal system, but there are other ways we can also discuss pushing things forward. I'd like to mention, if I may, restorative justice, an approach that seeks to repair harm by providing an opportunity for those harmed and those who take responsibility for the harm to communicate about it and address their needs in the aftermath of a crime. To invest in programs and for First Nations and Indigenous courts as well that will create more pathways for healing by including Indigenous knowledge and traditions, restorative justice practices, and elders in the court process. To reform how sexual assault cases are prosecuted in Canada through a feminist and equality lens. To ensure that everyone, regardless of income level, should be able to use the remedies that Canadian laws and the Canadian legal system provide, and then focus on building a system truly built on preventing youth crime by addressing its underlying causes, responding to the needs of young persons, and providing guidance and support. Without continuing our work on multiple fronts, we cannot claim that there will be true justice for anyone who is involved in the legal proceedings. S4 is part of the solution, and we need to continue to build on it to retort confidence in our legal system. Mr. Speaker, in 2022, the National Justice Survey reveals that 49% of Canadians are not confident that the Canadian criminal justice system is fair to all people, and that 39% think it's not accessible to all. For me, these numbers are incredibly alarming, and S14 is a step in the right direction. In conclusion, Bill S4 measures are both practical and necessary. They will assist the provinces and territories who are responsible for the criminal administration of justice by giving criminal courts additional tools to tackle delays. They will also benefit everyday court users, and for these reasons, I urge everyone in this House to support S4. Thank you. Merci, Willie Wynn.
Questions and comments? Question et commentaire. Boy, I don't know. I got two great members to ask a question here. The Honourable Member for Chatham-Kent-Leamington.
Thank you, Mr. Speaker, and I'll pay tribute to my colleague from Tobik-Mactaquac because I'm going to quote a statistic shortly. I want to thank the other member that just spoke from New Brunswick for her intervention, and as has been signaled, Conservatives support the measures that go to modernize our system and decrease the backlog and speed justice. However, we are concerned about the lack of focus on victims. As my colleague from Tobik-Mactaquac illustrated, recidivism is up 25%. An earlier intervention relayed that violent crime is up 32%. The question I would have for the honourable member, why? Why are these things happen when all of us is in all of our best interests to reduce the recidivism and violent crime?
The honourable member for Fredericton.
Thank you, Mr. Speaker, and I thank the honourable member for his question. And I would also like to reiterate, the great work of the member from Tobik-Mactaquac, a fellow New Brunswicker. And it's an issue that should concern us all. We certainly do not want. That's my alarm. We certainly don't want reoffenders to come back into our justice system. We want to be sure that while they're there, we can work on whatever the needs they might be dealing with. We know that many who are incarcerated in federal institutions are experiencing mental health issues, high instances of substance abuse and alcoholism. It's a multifaceted issue, and it's going to take a multifaceted approach. And I really believe that's what government is trying to do with this bill as well. And I think improving access through video conferencing and telecommunications will also help victims. So thank you very much for that question.
Question et commentaire. Questions and comments. The Honourable Member for Edmonton-Strathcona.
Thank you very much. I'd like to thank my colleague for her intervention this afternoon. It was very interesting. And I was particularly struck by her personalized experience with regards to youth incarceration. And she did speak about how we need to do much more to ensure that Indigenous people, BIPOC people, young people are not disproportionately represented within our judicial systems. I'm wondering what steps, what very specific steps she thinks would be next in line for this government to take.
The Honourable Member for Fredericton.
And I thank the honourable member for her question. I mentioned a bit about restorative justice circles. This is something that we're seeing used a lot in community, and I'd love to see this applied broader for more Canadians to access this Indigenous lens, this approach of, again, it's to go towards healing, and I think that's something that really needs to be added into this conversation. The use of elders as well in the courtroom is really important. We see the use of the Gladue principles that have been put in place in court systems to allow judges to use that discretion and take into consideration someone's background and the trauma they might have experienced that led them to interact with the justice system. So these are all really concrete pieces. I'd also like to highlight Bill C-5. I know it's a bit controversial for some of our members on the opposite side, but addressing the discrimination that our justice system has perpetrated upon Indigenous Canadians, members of racialized communities, I think reducing those mandatory minimums and using that judge's discretion is critically important, and it's going to ensure justice for all. Thank you.
Questions and comments? Question et commentaire. The Honourable Member for Tobik-Mactaquac.
See, Mr. Speaker, and thank you to my honourable colleague from New Brunswick and from Fredericton. And I thank her for sharing her experience and working with youth at risk and the youth who are vulnerable such an important field to address these concerns on the front end and make sure that we're doing all that we can to keep as many as possible from entering the criminal justice system. But also, I'd love to have her comments and reflection on the importance and critical importance of effective partnerships with nonprofit, faith-based organizations, indigenous communities on addressing the issue of recidivism and putting in place programs not only on the inside while people are completing their sentences, but also on the back end when they're being released in the community, how we can most effectively work together with them. Appreciate your comments. Yeah.
The honourable member for Fredericton.
Thank you, Mr. Speaker, and again, I thank the honourable member from Tobique-Mactaquac. Absolutely, it's about applying that trauma-informed lens. Those discussions can happen while someone is incarcerated, and certainly hope to set them on the right path, once they're on the outside and rejoining society after they've paid their debt. As I mentioned, some of the staggering statistics, we've got the Mental Health Commission of Canada from 2020 says 73% of men, 79% of women are federally incarcerated have some kind of mental health issue as well. So these are things that we absolutely need to use as a lens when we're discussing these kinds of issues and reforms in the justice system, particularly when it comes to youth, which is, of course, a very deep passion of mine. So thank you very much for that question.
Reprise du débat, continuing debate. The honourable member for Edmonton Strathcona.
Thank you very much, Mr. Speaker. And as always, it is a deep honor that I am allowed to stand in this place and represent the incredible people of Edmonton Strathcona. And particularly speaking about this bill, about S4. This bill is, of course, all about increasing access to justice. It is making sure that all Canadians have the equal right or the equal access to our judicial system, removing barriers to justice, all of the things that I think everyone in this House will be and can support. And I have to start by saying I'm very happy to see this legislation. I commend the government for bringing this legislation forward. This legislation makes sense. Our judicial system has been neglected. We have not modernized our judicial systems to stay up with the times, to stay current, to stay as accessible as it could be. This will make part of our judicial system better. It will increase the use of technology in appropriate ways. It will include increasing audio and video conferencing options, which will vastly improve the ability of people in remote or northern communities to access justice. It will modernize our system. I think I've said that before, but this is an important thing that we need to do as legislators, as parliamentarians. Our role is to continuously look at how we can improve our judicial system, how we can make it more accessible and better for all Canadians. And, the hope, of course, is that this will fundamentally fix the backlogs in our system, the backlogs that we saw during COVID, but that we have seen even before COVID, the backlogs that have meant, in fact, that justice has been denied, because as many have quoted before me today in this House, justice delayed is, in fact, justice denied. So I am happy that the government brought this forward. The New Democrats, of course, will be supporting it. I do have some serious concerns about why it did take the government so long to bring this back. Of course, it was something that was put before us in the last Parliament. An unnecessary election was called, and therefore it did die on the order paper. But, the election was in September in 2021, so it has been 14 months since that time, and we still have not seen this legislation before this. So while I am commending the government for bringing it forward, I would have liked to have seen this come faster. And certainly when I look at this legislation, I have to reflect on what else could be done, what more could be done. We have seen some real challenges and some real questions, both at a provincial level and at a federal level, in the terms of appointing judges, making sure that judges are adequately appointed, making sure that the questions around how judges are appointed is transparent and Canadians can trust that. One area that I'm going to talk a little bit about, because for me it's very, very important, is the failure to support legal aid properly. This is both a federal and a provincial jurisdiction, and as a member of Parliament that represents the citizens of Alberta, I have to say that Alberta is in crisis right now with our legal aid system. I'm gonna quote from a Globe and Mail article that was published earlier this year. Deborah Hatch wrote this article. She's the director of the Canadian Council of Criminal Defence Lawyers, and she's the past president of the Criminal Trials Lawyers Association of Alberta. And she says that as long as the provincial government resists increasing legal aid funding in a substantial and immediate way, individuals in the justice system and ultimately our democracy will suffer. It's quite shocking, Mr. Speaker. Ultimately, our democracy will suffer. You know, it's clear to me that in recent years, with the failures to appoint judges, with the failures to fully support our legal aid system, that in fact Albertans have had less access to legal services. That Albertans, their access, their ability to interact with our legal services have been reduced. And that's something that, while it is happening in Alberta and it is a provincial jurisdiction, that's something that all parliamentarians must be watching. They must be deeply concerned with. You know, the Canadian Bar Association wrote last month that without adequately funded legal aid, our justice system will continue to deteriorate. The Alberta Crown Attorneys Association said that lawyers in the defense bar who represent the accused through legal aid deserve fair and competitive compensation. That's not happening right now in Alberta. And one interesting statistic when I look at legal aid that I find fascinating, there is a quote that independent research has shown that $2.25 million is saved for every $1 million injected into legal aid. So every $1 million that we spend on legal aid, we save $2.5 million. So even my very fiscally minded conservative friends can surely not see that would not be a very, very compelling argument. But I have other concerns with what is happening in Alberta as well. You know, we have a new premier, Danielle Smith, who is proposing a Sovereignty Act.
We have a point of order from the honourable member for Edmonton.
If the honourable member from Edmonton have an ambition to run provincially and to have a role there, her speech today does not relate it by any chance to the subject of S4 today. So I would really appreciate, Mr. Speaker, if you would have point that out to the member.
Thank you for that intervention. We do allow a lot of leeway in members' speeches, and I know we're specifically talking to S4, and I hope that everybody will keep their comments to that. The honourable member for Edmonton Strathcona.
Absolutely. And Mr. Speaker, I would just like to point out that in past parliaments, the Conservatives, when, for example, Rachel Notley was the Premier of the province of Alberta, there was an awful lot of attacks on Rachel Notley. So I think it is reasonable when we are talking about justice, when we are talking about Albertans' access to justice, because S4 is ultimately about Albertans and Canadians' access to justice, that I be able to talk about the particular circumstances that my constituents are encountering with regards to access to justice. And when several of my colleagues from the Conservative Party have talked about gun laws and, you know, a number of different things during their speeches, I did say that, you know, I'm going to give you the benefit of the doubt so that you will, you know, return that favor when I have the opportunity to speak. So I do hope that they will recognize that leeway for me as well, because the next thing I want to talk about is something that's deeply concerning me in Alberta as well, and it is how our current Premier has talked about using the Alberta Human Rights Act to include vaccination status. So again, I have this quote, and it is from a lawyer, so I certainly hope that my Conservative colleagues can see the link there. Lorian Hardcastle, who is the Associate Professor in the Faculty of Law at the University of Calgary, said the vaccination choice is not the same as codifying rights around gender, sexual orientation, race, or religion. So you can see there that I also have some very deep concerns that the access to justice for Albertans is being...
Member for Edmonton, from Edmonton Manning.
I'm respectfully asking you, Mr. Speaker, to really point out to the member that this speech is about S4 and must stick to the point and to the subject. Thank you.
So, see an intervention from the honourable member for Hamilton Centre.
Speaker, sometimes I think my conservative colleagues live in an alternate reality. We've been sitting in this House listening to them go on and on and on about absolutely everything except for this bill, and now we have the honourable member from around the way trying to bring forth a fulsome presentation from the NDP side, and we have these people clutching their pearls. So if we could please just allow the honourable member to finish her speech without interruption, which is another thing, Mr. Speaker, they were going on about, talking about the threats of pulling out and making this thing go all the way to the end. So let's just try to keep the hypocrisy in this House to a minimum.
Any other interventions on this while we're at it? D'autres interventions? L'honorable député de Lac-Saint-Jean.
The honourable member for Lac-Saint-Jean. Mr. Speaker, you are here to help us. And we do want Quebec to be its own parliament and country, but I do want my colleague to be able to continue to go on without interruption. But this just gives us more reason to justify the fact that Quebec should have its own parliament and be independent. Well, I did think the energy in the room was a bit low.
A little low over the last couple of interventions, so it's good that we seem to try to get it out of everybody's systems before, of course, 2 o'clock rolls around when the question period goes. I see the member for South Shore St. Margaret's also has an intervention on this same point of order.
On the same point of order, I just point out that the honourable member for Hamilton was complaining about interrupting as he interrupted.
All right, so I'm going to look around to my honourable members, and do we have it all out of ourselves there for a bit? All right, so we're speaking to S4, and let's try to keep to that before we go to question period in about a whole half hour. The honourable member for Edmonton Strathcona, the floor is yours.
Thank you very much, Mr. Speaker, and what an entertaining time we're having in the House this afternoon. I would like to thank my colleague from the Bloc Québécois, though he's given me a great opportunity to speak about another issue. I'm very, very proud to be Albertan, of course, but very, very proud to be a Canadian as well. And so one of the concerns that I have with our access to judicial access for Albertans is around the current Premier of Alberta, Danielle Smith, and her desire to bring in a Sovereignty Act that she has said means she will not follow the laws of the land. So I do have some concerns with that lack of access for Albertans for judicial. So Mr. Speaker, I will conclude by saying that I support what is in this bill. This bill is long overdue. It should have been brought forward much sooner. We should have been able to debate this in the House much sooner. I hope that the government will move this along very fast. We have the support of all parties in the House, and certainly going forward that the government will consider all those ways the federal government must fight for our judicial system to have better access, to be accessible for all Canadians, including all Albertans. Thank you very much, Mr. Speaker.
Questions and comments? Question Kamal-Thar, the Honourable Parliamentary Secretary to the Government House Leader.
Thank you, Mr. Speaker. Interesting enough, many of the changes to the legislation that we're talking about today originate from the different provinces. So there has been a great deal of consultation with provinces in regards to ensuring that we can help modernize our system. And that is something that's really important to recognize. It's about building confidence. It's about ensuring that Canadians feel that we are keeping up with the times. With technology advancements comes opportunities for us to ensure a better, more solid, confident justice system. And I'm wondering if my colleague could provide her thoughts in regards to why it's so important that we continue to look at advances in society from a technological point of view and how those types of advances can be beneficial to our judicial system, something in which I would suggest to you is looked around the world as one of the best systems in which other countries do come to take a look at Canada's system because of how good it has been.
For Edmonton Strathcona.
Speaker, and I don't have a lot of insight into that, to be perfectly honest. But what I can say is that when I look at our judicial system, when I look at those that have to interact with our judicial system, you know, all technologies that we can use safely, effectively, and appropriately, I think make a lot of sense for us to explore. I think it does make sense for us to try to find ways to, as members of other parties have said, prevent people from entering the judicial system. And if there is technologies that we can use, if there is modernizations that we can make, I think we have an obligation to do that. You know, there is always downsides to technologies. There's always things that we hear about, detriments that happen to society with technologies from time to time, but there are also great benefits. And I think it's incumbent on us to take those and benefit from them. Thank you.
In comments, question commentaire, the Honourable Member for Kenora.
Thank you, Mr. Speaker, and I too wish to touch on the technology aspect of S4. Obviously, with technology, internet is a very important component of that, and I know in Northern Ontario and across many parts of the country, internet access is unaffordable, it's unattainable, it's not reliable for many individuals. So I'm just wondering, given the fact that this Liberal government has been in power for 7 years and that they've made many bold promises on improving internet access with, I would say, very little results in my region and in many other rural and remote regions across the country. I'm wondering if the member opposite has any comments in that regard on what the government should be doing to ensure that internet access is stronger across the country.
Honourable Member for Edmonton Strathcona.
Speaker, and I would like to thank my colleague. You know, I represent an urban riding, but I also, as only one of 2 New Democrats that represent the province of Alberta, I also feel that I often need to think about their needs of progressive voters across Alberta. So I look at these things that, you know, access in remote and rural areas. And so I agree with him that what the government has done is made us promises to make internet available, to make broadband available, and have not delivered on that. They have not delivered on that across the country. And it is something that if this is how we are going to improve our justice system, if S4 is a tool that we are going to use to improve our justice system, but yet we have not put in place the infrastructure to allow that tool to be accessed equally by all Canadians, that is a massive problem. And the government must do more to reduce costs, make things more accessible for all Canadians in all areas of our country.
Comments?
The Honourable Member for Beauport. Thank you, Mr. Speaker. I appreciated my colleague's speech. She talked about the importance of reassessing how we appoint judges in order to avoid any elements of partisanship in the process. What I take from this bill is that we seek to reduce delays which have, in fact, had cases rejected because of the Jordan decision. It's all well and good to use technology, but if there aren't judges there to use them, then the Jordan decision issue will continue to reoccur. Does my colleague have any suggestions for this House that would ensure that problems like those which occurred in the past, problems related to lack of judges, do not reoccur?
Strathcona.
Thank you, Mr. Speaker. It is a massive problem. We see this across the country. I certainly know in Alberta this is a big problem when judges aren't being appointed fast enough, when we don't have enough judges in place. This interferes with justice for Canadians. We've seen it multiple times happening. We've seen cases have to be canceled because there was not that judicial council that could, or the judicial leadership. What I think the government needs to do is have a better process in place, have a more transparent process in place, because another piece of this, of course, is that the public does not believe that our judges are appointed in a fair, transparent, nonpartisan way. So we need to make sure that that is happening at both the federal and the provincial level, and that we are ensuring that we have the adequate level of judges available to make sure that our judicial system can continue to run.
We're out of time, but here's where I will give the reminder that the shorter the questions, the shorter the answers, and the more people that get to participate. Because I see the Honourable Member for Nunavut have been on here for a bit trying to get to ask a question, and we are out of time. So I will remind everyone just to keep their comments and questions as court as possible. Reprise du débat, l'honorable député.
Resuming debate, the Honourable Member for Saint-Jean. Thank you. Thank you very much, Mr. Speaker. And thank you to the excited crowd behind me who are going to make this even more fun than it could have been. Mr. Speaker, I rise today to speak to S4, to speak to the improvements that we can make to the legal system through telecommunications and technology. Now, when we rise to speak, we look at what other intelligent members have said and other intelligent experts have said about the matter. I went to see the opinion of Judge Alphonse, who said that necessity is the mother of all invention, and that's how I'd like to start. Necessity is the mother of invention. I was a lawyer, civil law I worked in, but there are links. So I'd like to tell you about some of the experiences that I had as a legal practitioner. We had a lot of issues that I experienced, and COVID has allowed us to solve some problems. So once with a partner, I started to set up an online divorce service for those who lived far away or for those who wanted to divorce amicably through mediation. But there were oaths that needed to be signed. We tried to intervene through the Minister of Justice of Quebec to make it possible to have these sworn oaths done by video conference. So it wasn't possible. We tried and tried and tried, but we ended up giving up because it was really just too complicated to get that done. Then all of a sudden COVID hit, and now it's possible to do so through video conference. So there's a silver lining in all this. Now, lawyers, sometimes they go to court in the morning. They might have to go from Montreal to Saint-Jérôme. They wait an hour and a half in the hallway. They spend 5 minutes before the judge. Then they go home. They bill legal aid $100. In a pandemic context, though, we managed to get this done by video conference, and it's a lot quicker, more effective. We hope that S4 will have this type of positive impact on the administration of our courts and the operations of our courts. Some courts have put all their documents online or scanned them because sometimes you had to actually move physical paper copy documents from one court to another. Sometimes they were lost. That was an issue. Now, our courts are becoming a lot more technological, and people can access their files online as well. What we hope for S4 is that it will have a lot of positive impacts, but we want to make sure that we avoid good ideas that aren't actually good but seem good. So this bill, it would modify two categories of things. First, it increases the use of remote appearances and also allows for the use of technology in jury selection. The second category of issues that this would fix is expanding the telewarrant system so that peace officers could get more types of warrants and orders via telecommunications. Now, I mentioned juries. We would allow the use of technology in jury selection and sometimes for candidates and applicants, prospective jurors, to participate by video conference. And it would just be in certain situations with safeguards and at the discretion of the court. Sometimes you go to the court and you see a huge group of people in the hallway and you just know that there's a jury selection going on. And that's not healthy in a pandemic context. So this change is very positive. And sometimes there is a draw for juror selection. This will be advantageous, and sometimes jury members, jurors, they gather in the hallway and they try to give each other tips on how to avoid having to do jury duty, which is negative, and we could fix that. This bill also broadens the possibilities for remote appearances in some circumstances for offenders and accused persons. I will come back to possible issues related to that later. This would also expand the power of courts and to set rules to make it such that non-represented individuals and administrative matters related to the non-represented can be handled by court officials. So currently they have to go in person, but it can be done a lot faster through video conference.
Qui sont non représentés, on pourrait utiliser des fonctionnaires de la Cour plutôt que d'utiliser à la fois des salles d'audience et des juges qui pourraient être utilisés à meilleur escient. Donc, il y aurait un gain en efficacité potentiel là-dessus. Le projet de loi permettrait aussi de permettre aux tribunaux d'ordonner la prise des empreintes digitales, là, le fameux bertillonnage, à l'étape de l'enquête sur mise en liberté provisoire ou à toute autre étape dans le processus pour éviter des délais lorsque ça n'a pas pu être fait au bon moment dans des circonstances exceptionnelles. Par exemple, au moment de l'arrestation, un prévenu ne...
Here, we'll just stand and stop. Quelques secondes, puis...
We'll just wait a couple of seconds here. And the member for Nunavut is going to go on mute.
Nunavut. Bon, c'est bien.
Okay, that's good. The honourable member for Saint Jean. 14 minutes remaining. Thank you very much. So I was talking about fingerprinting at any point, because sometimes it's not at the point of arrest that the accused can be fingerprinted. And during the pandemic, it was hard to take someone's fingerprints while maintaining a 2-meter distance. And then there are some provisions about telewarrants to expand the types of situations in which a telewarrant can be issued. It doesn't change the legal test, the threshold for obtaining a warrant. It just frees up judges and lawyers who used to have to meet in person to debate the appropriateness of a warrant. There might be a downside, which is this could be done in writing now. We send our arguments into the judge by writing, and the judge issuing the warrant wouldn't have the opportunity now to ask as many questions or to delve in. So there is a downside in spite of everything. There have already been discussions about this bill. It comes from the Senate, so experts have already been able to express their views and make their recommendations, the Quebec Bar among them. And I'd like to come back to a very specific point, and that is the video conference appearance aspect. The Quebec Bar made some recommendations. The bill will clarify options for accused appearing by video conference in situations except when the evidence is being presented before a jury. When there's a jury trial, the evidence will always be adduced in person in front of the jury. But in some cases, video conferences can hide some of a person's tics or amplify some of their facial expressions. So that could be misinterpreted by a judge or jury. So it can distort our appreciation of body language or nonverbal language. And if a lawyer is passing a note to their client or trying to tell the accused to, not to respond or something, these are gestures that might be missed if the trial is conducted via video conference. And there was a case, in my experience, where the witnesses were in France, and we had to ensure that they were seated alone in the room. And so normally they're kept in separate rooms physically, but when there's a video conference, in this one case, the witness just pulled his wife over and into the screenshot. So clearly the two witnesses had been sitting together in the same room. So that's a potential pitfall of video conferences. Another problem, what if there's an irregularity in a trial? Does it have to start over from scratch? Does there have to be a retrial? Do all the witnesses have to be heard again? So that whole exercise will have to be examined in the future. The other issue is that the parties consent to having witnesses appear by video conference. Well, what happens if along the way, the accused realizes that their constitutional guarantees are being violated, what is the accused supposed to do? Are they supposed to object? So there could be a loss of efficiency if everything has to be started over. If it only becomes something that the accused is aware of midway through the trial, that there's a question of a rights violation. The other thing that the Quebec Bar recommended was to study the long-term impact of S4. We're still in COVID mode here, and we're making these changes a bit on the fly, but we should have a look at the long-term consequences. And the other thing about S4, instead of making remote proceedings the exception, they're making them the rule. So we need to look at that, the impact of that on our justice system. There might also be an impact on the solicitor-client relationship. How does this affect the council's obligations? And so we need to examine those issues too. And then trials are meant to be held in public, but if they're held by video conference, what about access for the public? If the public's interested in following a trial, if people are older people could go physically to the courtroom and sit there and watch trials if they wanted to, and if they don't have internet at home, they might lose an important source of, if nothing else, entertainment if they can't attend these virtual proceedings. Another issue is the right to a fair trial. And I already mentioned the importance of nonverbal communication in a credibility assessment. It could have an impact there. And another problem we can envisage is that there might be a disparity created between major urban centers and rural areas. If it's easier for people who live in remote areas to participate by video conference, but in the big cities, it's easy for witnesses to get around and they can appear in person. So it'll be a bit like a two-tier system, if you will, our criminal justice system. So this is an important issue. Another recommendation from the bar was to delete Section 715 of the Criminal Code, which would allow the court to require a video conference appearance by an accused under certain provisions of the Criminal Code. The bar was of the view that this should never be at the court's discretion. There should always be consent. The parties should always consent to the use of video conferencing. The Quebec Bar also recommended, before this bill enters into force, that there be some clarifications as between represented and unrepresented accused and their ability to communicate with their lawyer. So if a client is getting advice from their lawyer and they're appearing by video conference, they might not have the right to demand their right to counsel if they're unrepresented, whereas if they are appearing physically in a courtroom, they can always demand to have access to counsel. So with this bill, there are two shortfalls that need to be avoided, two pitfalls, and I'd like to talk as I get to the end of my speech about those issues. It's important to keep in mind that there's a balance to be struck between how much easier new technologies make things and the actual gains in efficiency. And I would draw a comparison with the hybrid proceedings here in the House. There's an advantage, but there's also a painful side to hybrid proceedings. The way things happen here, some people complain that they don't have direct access to witnesses. When you're appearing remotely, you don't have the feeling that you're a full participant, that you're aware of everything that's going on. You can't see how various people are reacting to witnesses, and these are things that make it easier for journalists to do their work. And also, if MPs appear remotely, journalists don't have the same access to them, for example, as they would as they leave the room. And for interpreters, we know that in the future center block, the interpreters may be located off-site. And what we're hearing is that it'll make their job much harder, because it's not just a matter of them being able to hear what's going on. They have to see people's emotions. That's important in conveying a message. That includes facial expressions and body language, nonverbal communication. And so the same thing goes for video conference. Another potential pitfall is that although there may be some improvements in delays, this is not a panacea. It's not going to solve all problems. For example, S4 doesn't solve the problem of connectivity, of internet connections all around in various settings, various locations. So the S4 does nothing about the technology in terms of access and connection. It doesn't solve the problem of liberalists being used. It doesn't solve the problem of the public confidence or trust in the justice system. The Justice Minister explained that his role was not to appoint judges, but to make sure that the infrastructure and the administrative side of things worked well, being aware of the statistics and so on, how many cases are being heard every day. But the minister said that he was not responsible for appointing judges. So that's something to keep in mind. Another problem when it comes to appointing judges is when there are various officers that need to be appointed, but there's a delay. There's a other in the provinces and territories, things aren't going so bad, but federally, there's a real shortage of judges. They need to appoint a lot more. So in order to avoid all these problems that I've just raised in the future, this bill has some upsides. It does call for review in 3 and 5 years. So the 3-year review is to be done by an independent committee, and I think that's an excellent thing. The Justice Minister, and this is 67.1 or 68.1 of the bill, says that by 3 years after the entering into force of this legislation, the minister will appoint a committee to do an in-depth review of the bill. And finally, the bill also provides for a parliamentary review of the bill after 5 years, which will, I would like to think, allow for a full review of how things went, and hopefully practitioners will be consulted on this, because when they're not consulted enough, that's often when mistakes are made, and all the good intentions of the bill wind up in a bill that doesn't work very well at all. So this bill comes out of a situation that we certainly hope was temporary. I'm talking about the COVID pandemic. And in 3 and 5 years, when we review this legislation, hopefully the government will have the humility to correct any errors and improve on the bill. So this will hopefully be a helpful exercise, these reviews of the bill, and hopefully it won't be seen as a failure if further changes need to be made. Hopefully it will be seen as a success, as a further improvement on the justice system. And the Jordan case is an example of a solution to some serious problems. Anyway, that's the hope that I have for this bill. Thank you, Mr. Speaker. I think the last time we had a really good, quick little questions and answers session. The honourable member for Nunavut.
I just wanted to comment very quickly that given that most of Nunavut lawyers are legal aid lawyers, I feel that MP for Edmonton Strathcona was perfectly in line when she was intervening on legal aid lawyers. I wanted to thank this member for her great speech and focusing on internet connectivity. Given that this bill will only focus in 3 specific areas for streamlining processes, can the member describe that maybe those concerns are actually not warranted, given that it's only going to be in such few circumstances?
The honourable member for Saint Jean. Well, it's true this bill doesn't deal with everything, and that's one of the other concerns of the Quebec Bar. They would like to have the criminal justice system overhauled comprehensively instead of in a piecemeal fashion. It's always like a patchwork of changes to the criminal code, and so the criminal code has become this gigantic piece of legislation with all kinds of cross-referencing, and it's impossible to make heads or tails of it. So here the issue is a more comprehensive review of the criminal code, and I would be in full support of that. And on the issue of connectivity, that would be a good idea to add more telecommunications, but unfortunately it won't be applicable to everyone. And when it comes to legal aid, that doesn't come under federal jurisdiction, but I think there's always room for discussion of legal aid because there are disparities among provinces. The Honourable Parliamentary Secretary to the Government House Leader.
Of course, the importance of judicial independence. It's important that we recognize that S4 is a reflection of the desire from a lot of provinces in terms of making changes, coming out of the pandemic, taking advantage of the technology that is there today, and is always an option. And that's really what's being provided here. Options for our courts to be able to take advantage of the technology, and I'm wondering if the member would not concur that that is a positive thing and why we should be supporting legislation.
The Honourable Member for Saint Jean. Well, it's no surprise that the Bloc will be supporting this bill. That's already been mentioned. But there are clauses in the bill that would provide that it's not an option to appear by video conference, and the Bar recommended getting rid of that clause because it only gives the impression of being an option because there are problems with distance and access to the courts. So some people say we don't need to solve the problem because we have a sort of a Band-Aid solution that allows us to operate differently. But it will give people the feeling that they have a real choice between in-person and video appearance. It shouldn't be a choice that's imposed on them indirectly. The Honourable Member will have 6 minutes left and 45 seconds when we come back to this matter.
By members, déclaration de député, the Honourable Member for Saanich Gulf Islands.
Thank you, Mr. Speaker. It's such an honor to rise today, knowing that the person about whom I will be speaking is watching from home in my riding. Peter Godwin Chance, war hero, celebrated veteran, was born November 24th, 1920. That's right, today is his 102nd birthday. I invite all my friends to join me in this place so that we will send out to retired Commander of the Canadian Navy, Peter Chance, the kind of thank you and happy birthday that only he could possibly deserve. He was a commander on June 6, 1944, D-Day. He was at that point not commander but navigation officer on board the Skeena. He was there in the thick of it on D-Day, having joined the Navy Volunteer Reserve when he was only 18 years old. He stayed with the Canadian Navy. He received multiple decorations and war tributes, including the French Legion of Honor. So today, thank you, Mr. Speaker, for allowing me to say with all of our colleagues here, happy 102nd birthday, Peter Chance.
It's not allowed, but happy birthday, Mr. Chan.
Bravo.
Brampton, the Honourable Member for Brampton South.
Mr. Speaker, yesterday Canada played their first World Cup game in 36 years. What a game, Mr. Speaker. I think everyone can agree that Canada played stronger. Yesterday, Kyle Larin, Tejun Buchanan, Jonathan Sorio, Ike Ugbo, Junior Oilet, Liam Miller, and team captain Atiba Hutchinson showcased their talent on the field. In our city, they are hometown heroes. They found their passion and now they are running with it. Mr. Speaker, many of Canada's soccer starts their journey with local clubs like Bram United and Brampton Soccer Club. They enrich our communities and help our youth build stronger bonds. On behalf of the residents in Brampton, I want to send the national soccer team our best wishes and good luck at the World Cup. Go Canada, go!
The Honourable Member for Perth Wellington.
Mr. Speaker, the village of Arthur is known as Canada's most patriotic village. It gained this honour not through the words of politicians, but through the service and sacrifice of its citizens. In 1942, the Toronto Daily Star reported that the highest per capita enlistment in the Second World War came from this small community in Wellington County. Among those who would enlist would be John Walsh, who joined the Navy within days of his 18th birthday and served aboard the HMCS Wallaceburg. Like so many of his generation, when John Walsh returned from the war, his service did not end. He continued to serve the community as a pharmacist, a Legion member, and as Arthur's most dedicated historian. Earlier this week, John Walsh passed into history, but the legacy he leaves behind for his family, his community, and his country will long survive. Bravo Zulu, Mr. Walsh, and thank you for your service.
The Honourable Member for Fredericton.
2/3 of women in Canada have experienced physical, sexual, or emotional abuse. Mr. Speaker, November 25th is the International Day for the Elimination of Violence Against Women. Gender-based violence encompasses many types of abuses that are perpetuated towards women, girls, two-spirit, trans, and non-binary people. Only a couple of years before the Montreal massacre, MP Margaret Mitchell got heckled in the House of Commons for raising awareness about domestic abuse. Today, the laughter has faded, the conversation has evolved, but women are still dying. The roots of gender-based violence are entrenched and persist in our society, one that upholds patriarchal ideology. 173 women and girls were killed by violence in 2021 in Canada alone. 1 in 5 women killed was First Nation, Métis, or Inuit. Including femicide in the criminal code is a needed move and one that must be backed by an action plan for change. I am standing in this House today asking each and every one of us to take action. From the words of Susana Chavez Castillo, not one woman less, not one more death.
The Honourable Member for Shefford. Mr. Speaker, from November 25th to December 6th, we have the duty to mark the 12 days of action for the elimination of violence against women. An important time to remember the women who have left us due to violence. So far in 2022, 13 femicides have occurred in Quebec. These tragedies are a terrible reminder of the relevance of this campaign. Collectively, men and women, let's ask ourselves what we can and must do so that there is not one more. This year's theme, Coercive Control, Beyond the Marks, invites us to no longer be silent in the face of this violence, regardless of the type of violence, because the actions might not always be striking, but they always hurt. As elected officials, let's commit to taking concrete action. We must do everything in our power to ensure that violence is excluded from our future. Let's stand together, and at the invitation of women's groups who work daily to help victims, let's wear the white ribbon.
The Honourable Member for Brampton East.
Mr. Speaker, I rise in the House today to cheer on the Canadian men's soccer team competing at the FIFA World Cup. The last time Canada qualified for the FIFA World Cup was 36 years ago, but 2022 has ushered in a new era, pioneering the path forward and highlighting the amazing athletic talent that we have. I am thrilled to see the city of Brampton represented in big numbers on the team, Out of the 26-player roster, 7 come from Brampton. This team's athletic achievements have been record-breaking, putting Canada onto the world stage yet again. It is exciting to see such amazing talent come from this community, which I love and represent here in this house. Brampton native Tajon Buchanan, winner of the 2021 Gold Cup Young Player Award, puts it into perspective for so many of us by saying, "We don't come from a lot, we must show the world and work twice as hard." I have no doubt that these incredibly talented athletes will represent Canada to the fullest. I know everyone in this house sends their best as we cheer on Team Canada. Let's go, Canada!
The Honourable Member for Portneuf, Jacques Cartier. Thank you, Mr. Speaker. As the holiday season approaches, I invite people to visit one of the 22 Christmas markets in the beautiful riding of Portneuf, Jacques Cartier. They offer a wide range of quality products and creations from our talented artisans. You'll make great discoveries and encourage local trade. Moreover, this time of year is a time for sharing. Among the organizations doing this important work in Portneuf, Jacques Cartier, I would like to highlight the involvement and dedication of the St. Vincent de Paul Society. Their volunteer work meets the needs of our community, those most in need. I would like to thank Claudette Hetherington of St. Augustin, Louise Barrette of Saint-Marc-des-Carrières, Yvon Cloutier of Donnacona, Roch Bello of Pont-Rouge, Huguette Dussault of Neuville, Diane Durand of Portneuf, and Doris Tessier of Saint-Brigitte de Laval. I want to thank them. Let's help them help those in need. I want to invite you to be very generous and wish you all a very happy holiday season.
The Honourable Member for Kitchener South Hespeler.
Mr. Speaker, I rise today to share with this House the incredible work being done by Chicopee Tube Park. For nearly 100 years, this local treasure has provided space for winter and summer activities to occur. Like many businesses in the tourism sector, Chicopee was hit hard by COVID-19. Despite the hardships brought on by the pandemic, they used this time not only as an opportunity to rebuild, but to rebuild better. Having won multiple awards for their environmental business practices from the Tourism Association of Ontario, their commitment to operating sustainably has not wavered. They have expanded their drainage system to capture and reuse over 450,000 gallons of stormwater for sustainable snowmaking in the winter. This project will not only conserve water, but will also reduce power consumption by 10%. Chicopee is a shining example of how businesses can adapt to benefit the environment, the economy, and the community. I ask the members of this House to join me in applauding Chicopee Tube Park for their ongoing commitment to environmentally responsible business practices.
The Honourable Member for Buena Vista Burin Trinity.
Mr. Speaker, recently I had the opportunity and the pleasure to meet with President Michael Foote and other wonderful members from the Lions Club International. Mr. Speaker, from the provision of disaster relief grants, both in Canada and abroad, to the establishment of community centres, they are at the heart of many communities in this country. I would like to express a sincere thank you to 1,400 Lions clubs and over 41,000 Lions members, whose tireless volunteerism is the epitome of community service at the local, regional, national, and international levels. One specific charitable service Lions Club provides is guide dogs that help to empower individuals with autism, diabetes, epilepsy, visual impairment, and multiple other conditions. Guide dogs are an important investment to fostering inclusive communities, and without Lions Foundation of Canada guide dogs, the lives of many communities or Canadians would be unquestionably more difficult. I encourage all Canadians to check out how they can support the Lions Foundation's incredible work. Thank you to the Lions.
Well done. The Honourable Member for Selkirk Interlake Eastman.
Saturday marks the 89th anniversary of the Holodomor genocide. In 1932 and 33, Joseph Stalin and his communist Soviet thugs used food as a weapon to starve upwards of 10 million Ukrainians. Stalin's brutal regime was determined to destroy Ukraine's identity, language, and culture. But Stalin's communist dictatorship failed, despite murdering in Ukraine the equivalent of every man, woman, and child in Manitoba, Saskatchewan, Alberta, and BC. Unfortunately, Ukraine's very survival is threatened today by another genocidal maniac, Vladimir Putin. And again, the only crime Ukraine has committed is being patriotic Ukrainians. It has been 274 days since Russia's barbaric invasion, and Ukrainians have been fighting for their sovereignty, their democracy, and their liberty, and the freedom for all of us. Stalin failed to exterminate Ukrainian nationalism, and Putin will also fail. This Saturday, we stand together to remember the victims and honor the survivors of the Holodomor. And we will also remember the Heavenly Hundred from the Maidan and the heroes who are dying today defending Ukraine from Putin's war machine. The Chenaya Paimet, may their memories be eternal.
L'honorable député de Yukon.
Mr. Speaker, another busy summer season has come and gone in Dawson City, Yukon, heart of the Klondike. Now with winter here, people draw close and ward off the dark nights with sports and cultural activities outdoors and in. Les résidents de Dawson City font de leur mieux pour faire face aux prix élevés causés par l'inflation.
To deal with the high price of inflation, but we need to fight climate change.
Scientists and First Nations met in Dawson City to highlight the impact melting permafrost is having on northern communities like those of the Yukon. When permafrost melts, the ground shifts, buildings twist, roads wash away, fires intensify. Landslides bring new meaning to supply chain disruptions when roads are literally blocked. Les résidents de Dawson City.
The residents of Dawson City and Yukon know that climate change are as real as the high prices we are now dealing with.
Government is there to help communities like Dawson City adapt to the climate crisis. We're also there to support those who need it most to cope with high prices, so that Dawson will continue to be the thriving heart of the Klondike for generations to come.
The honourable member for Hastings, Lennox and Addington.
Mr. Speaker, Canadians are broken. Their bank accounts are broken. Their faith in this Liberal NDP government is broken. Instead of helping Canadians, this government is determined to pile on more financial burden with their carbon tax. When struggling Canadians are faced with such great uncertainty, they need their government to help them get ahead, not hold them back. Mr. Speaker, this Liberal government and their NDP backers need to do the right thing. Listen to the millions of struggling Canadians and cancel their planned hike on the cost of living and cancel their punitive carbon tax.
Honourable member for Kamloops, Thompson, Caribou.
Mr. Speaker, in only 7 years, the Liberal government has broken our justice system. Nearly 20 years of decreases in violent crime have evaporated under this government. Canada's homicide rate is now worse than any time since the mid-2000s. There has been a 92% increase in gang-related homicides since 2015, yet this government continues to relax punishments against violent offenders. As we all know, Canada's murder rate is the most reliable indicator that Canadians are experiencing across-the-board surges in violent crime. This past August, Stats Canada recently reported a notable rise in cases of sexual assault and harassment. These appalling statistics are proof that this Liberal government is not taking the safety of Canadians seriously. This is why we need to elect a Conservative government led by the new leader of His Majesty's loyal opposition.
The honourable member for Gatineau. Mr. Speaker, this morning in Gatineau, I had the pleasure of participating in the opening of Gatineau 2, the first net zero carbon archival facility in the Americas. A $330 million building that is on time and on budget. Gatineau 2 is a true leader in the global documentary heritage community. Mr. Speaker, the Gatineau 2 building has already been awarded the Gold Infrastructure Award from the Canadian Council for Public-Private Partnerships, and that's just the beginning. This project is generating substantial economic benefits for a region and is a major source of skilled employment. I invite people to take advantage of the green spaces around this important preservation facility and the upcoming programming. Mr. Speaker, I want to highlight the work of Library and Archives Canada, especially Leslie Weir, Librarian and Archivist of Canada, and Nathalie Etier, Project Director. Once again, Gatineau is distinguishing itself, and I'm very proud of it, Mr. Speaker.
The Honourable Member for South Okanagan, West Kootenay.
Mr. Speaker, off the top, I'd like to send out congratulations to Kimo Linders of Penticton for winning the Small Business of the Year award at the Tourism Industry Association of Canada last night. And also to the amazing Penticton Vs, who just won their 21st game in a row in the BC Hockey League. But I also want to talk about Bill S-222 that will be debated here on Monday morning. This is a small but mighty bill that simply asks the federal government to consider the environmental footprint of building materials when constructing infrastructure. This was my private member's bill in a previous parliament, and I was inspired to bring it forward by the new mass timber technology pioneered by Structurelam in my hometown of Penticton. Mr. Speaker, with new materials such as mass timber, we can build safe and beautiful buildings that will also help us in our fight against climate change. So I hope everyone here will support S-222 to literally help build a better future for Canada.
The Honourable Member for La Prairie. Mr. Speaker, today I would like to recognize the 100th birthday of Françoise Poulain. Originally from the small village of Saint-Prosper de Dorchester, she moved to Quebec City at the age of 18, where she met the father of her 7 children. It's worthy of a movie, Mr. Speaker. Suffering from appendicitis and operated on at Hotel Dieu, she fell in love with her nurse and future husband, Joseph Dutil, and they settled later on in their home in Saint-Hyacinthe, where she still lives today. Living in this house is an opportunity to keep alive the memory of her husband with whom she shared her life for 32 years. Widowed at 55, she redefined herself from a wife and mother to a strong and independent woman, a caring, loving, and devoted woman devoted to her family and friends. She was able to pass on her determination and courage to all her descendants, generous, honest, and hardworking people, real good people. I could talk about her for a long time because her sons, Richard, Alain, and Danny, are 3 of my good friends, great men. So I wish you the very happiest of birthday, Mrs. Poulain. Thank you, Mr. Speaker.
The Honourable Member for Barrie Innisfil.
Last weekend, I attended a church Christmas bazaar, and I stood behind a senior who was putting 5 for $3 raffle tickets in a cup for a $50 grocery store gift card. She turned to me and she said, "I hope I win because I can't afford groceries anymore." What a sad indictment on how these Liberals and this Prime Minister, helped by the NDP, have broken this country in so many ways. Inflation is at a 40-year high. 1.5 million Canadians relied on food banks in September. Housing affordability and rental costs are out of control. Young Canadians feel that they've been lied to and let down by this Prime Minister and are despondent about their futures. The problems that exist are structural. They're self-inflicted wounds created by a government so blinded by their ideology that it's impossible for them to come up with the solutions needed, and one-time bribe payments won't solve anything. The only solution is a change in government to give Canadians control of their lives, to restore their hopes, to restore their dreams, and restore the dignity of that senior who stood in front of me last weekend.
The Honourable Member for Cloverdale Langley City.
Mr. Speaker, with December just around the corner, I'd like to highlight some events that are happening in Cloverdale Langley City this holiday season. The City of Langley's Magic of Christmas Festival is taking place December 3rd and 4th. This event happens at the Timms Community Centre, provides fun for the whole family, and features a holiday artisan market. On December 4th, the Cloverdale Business Improvement Association is hosting the Surrey Santa Parade of Lights, where I will accompany a decorated vintage truck. The event collects donations and unwrapped toys for local food banks. On December 7th, the Cloverdale Chamber of Commerce presents the December Charity Luncheon. This event raises money for Cloverdale Community Kitchen to provide Christmas hampers for those in need. The Langley Christmas Bureau, with more than 100 volunteers, will assemble toy bundles and accept donations to purchase gift cards for families in need. This year, the Bureau is located in Langley City Hall and will receive donations until December 15th. Thank you to everyone who volunteer in our community who works so hard to make sure all residents of Cloverdale Langley City will have a wonderful holiday season. Mr. Speaker, from my family to yours, to my colleagues in this chamber, and to all residents of Cloverdale Langley City, season's greetings, Merry Christmas, Happy Hanukkah, and best wishes for a Happy New Year. Thank you, Mr. Speaker.
And the Before we go to the questions, I just want to remind the honourable members that Standing Order 31 allows individuals to give a little bit of a report back from what's going on in their riding, and they last 60 seconds. That's all they allot, and I notice a few of them going over. They're great stories, and I don't want to cut them off, but I just want to ask members to try to keep them into those 60-second parameters. Oral questions, question orale, the Honourable Leader of the Opposition.
Thank you, Mr. Speaker. The Governor of the Bank of Canada confirmed yesterday that if the government had reduced its deficits, we would have lower inflation. But because of the exorbitant deficit we have today, inflation will be costing $3,500 more for each and every Canadian. Now that the Prime Minister has had it confirmed that his deficits are causing inflation, will he turn things around so that Canadians can pay their own bills? The Right Honourable Prime Minister. Mr. Speaker, during the pandemic, we chose to be there for Canadians. We helped families, we helped workers, we helped small businesses, community centers, and nonprofits. We were there to support people so we could all get through the pandemic as best as possible. And not only was the pandemic a less severe health crisis than in many other places in the world, but our return to a thriving economy was faster than among many of our neighboring countries. My opponent across the way wanted to cut. We want to deliver.
Top Newfoundland and Labrador minister said that he's, quote, sick and tired of people complaining about heating their homes in the cold winter. Well, no wonder they're complaining. According to the CBC, the Prime Minister's favorite media outlet, and I quote, the federal carbon tax could leave seniors out in the cold. One seniors advocate said that her members are feeling, quote, extreme difficulty with the cost of living. Instead of telling Atlantic Canadians to pay up and shut up, why doesn't this government reverse its costly carbon tax on home heat?
The Right Honourable Prime Minister.
Mr. Speaker, instead of mischaracterizing what members on this side of the House says, the Leader of the official opposition should actually take a look at what, for example, the Parliamentary Budget Officer says in regards to our price on pollution, which actually returns more money to the vast majority of Canadians in areas where it's imposed. The price on pollution not only fights climate change, but it also supports hardworking families where they most need it. We're pleased that families in Atlantic Canada are now going to be getting the carbon incentive rebate regularly, and we're going to continue to fight climate change and support Canadians while we do it.
The Leader of the Opposition.
Well, if the Prime Minister says I should take a look at the Parliamentary Budget Officer's report, I think I just might. I have it right here, a distributional analysis of the federal carbon pricing. And I go to page 13. The net cost to Albertans, net, $2,282. Saskatchewan, $1,464. Manitoba, $1,145. Ontario, $1,461. This is the excessive cost above and beyond the rebates that people will get. That's what the Parliamentary Budget Officer says. The Prime Minister won't believe it. So the question for you, Mr. Speaker, will you send over a page so that the page can deliver this report and he can believe his own eyes?
I'm not here to answer questions, so I'll let the Right Honourable Prime Minister answer the question. Order. The Right Honourable Prime Minister.
Mr. Speaker, remarkably buried in that rhetorical attack was something that was quite important, and perhaps the first time the member of the official opposition has finally recognized that there is a rebate associated with the price on pollution, that we give back more money every year than average families pay related to the price on pollution. We are actually there to support Canadians even as we fight climate change. Now, the Leader of the Official Opposition doesn't much care for the fight against climate change, but he should care about putting more money in people's pockets. That's why he should support our price on pollution.
The Leader of the Opposition.
Well, no one's ever denied that there's a tiny rebate. What we have said is that the rebate doesn't come anywhere near paying the cost that people have to pay for higher...
I'm going to interrupt the Honourable Leader of the Opposition. When you're reading from something, it's not a problem, but when you're holding it up, it becomes a prop, and it's not really his part. I'm sure the Honourable Member knows that. He probably just forgot. I'll let him continue. Please.
Mr. Speaker, I'm sorry that some consider a report from the Parliamentary Budget Officer to be a prop. I consider it to be firm evidence that the size of these rebates is smaller than the cost that people pay in higher taxes. This is definitive proof, and it shows that Canadians will pay more and more the higher the tax get for a policy that has failed to deliver a single solitary climate change target. It has failed. It costs too much. Will the government cancel it?
Right Honourable Prime Minister.
Mr. Speaker, maybe to the Leader of the Opposition, hundreds of dollars in Canadians' pockets is a tiny amount, but I know it matters to Canadians. Hardworking families receiving support for the carbon price that they're paying is making a huge difference, as well as $500 top-up to the Canada rental benefit or delivering on rental care. All those things are not things that the Leader of the Opposition thinks Canadians should get, and he voted against it. Instead, he moves on recommending that they invest in Bitcoin to avoid inflation. Well, that would have destroyed half their savings. Mr. Speaker, we will continue to deliver support for Canadians while he plays rhetorical games.
The Honourable Leader of the Opposition.
Mr. Speaker, those rebates would not be enough to pay for 2 hours in the Prime Minister's favorite London hotel, where he pays $6,000 a night. Let me look at the costs here of this tax. $2,282 for the average Albertan when fully implemented. $1,464 for the average Saskatchewanian. Similar costs for people right across the country. These are net costs above and beyond the tiny rebates that he's offered. Now that he has the evidence, now that it's right here in one of the reports from an officer that he appointed, will he believe the facts and cancel the tax?
The Right Honourable Prime Minister.
Mr. Speaker, in that very same report that the Leader of the Opposition is touting, it spells out that indeed the price on pollution is compensated for by a larger rebate than the average family pays out in a given year. The average family of 4, including families in his riding of Carleton, do better off with our carbon price incentive. That's because we know that fighting climate change is important to Canadian families, and making ends meet is as well. That's why we continue to step up on support for families, but why he continues to nickel and dime them.
L'honorable député de La Prairie.
The Honourable Member for La Prairie. Mr. Speaker, the Prime Minister showed a lack of seriousness in this House about Chinese interference in funding election candidates. But he found it serious enough to ask his intelligence service to get to the bottom of the situation, and he was right in that. China is interfering more and more in our democracy. The Prime Minister even spoke to the Chinese president about it at the G20. What the global report showed is at the very least flagrant weaknesses in the political financing system. The Prime Minister can fix this right away. It's simple. Will he bring back public financing for political parties? The Right Honourable Prime Minister. Mr. Speaker, our political financing system at the federal level is one of the most transparent, accountable, and robust of any level of government. If the Bloc Québécois has a hard time getting money from Canadians, that's the Bloc's problem. But we will continue to follow the rules. We will continue to fundraise publicly. And we will continue to place trust in the system that we have, instead of wanting to create new systems to help the Bloc Québécois. The Honourable Member, the Prime Minister should be ashamed of what he said. It's incredible. Political parties' dependence on donations creates unhealthy conditions favoring undue influence. We already know this. The Prime Minister should know. He spent his first term in trouble because he was leveraging his presence at fancy cocktail parties with business people at $1,500 a head. The global report showed that this same weakness can be exploited by foreign powers who want to influence our democracy, and China is probably already doing that. The Prime Minister should apply the precautionary principle. I know he's not too familiar with that, but he needs to become so. When will he bring back public funding for political parties? The Right Honourable Prime Minister. Mr. Speaker, political financing in Canada is a robust and transparent system. Perhaps indeed the Bloc has trouble raising money. But the reality is that all political parties engage with Canadians, and the Liberal Party is doing so in an open and transparent manner. The media are invited to all my fundraising events. And I would encourage the leaders of the Bloc Québécois and the Conservative Party to do the same. We will always be open and transparent about our fundraising, because Canadians need to be able to trust our democracy.
South. Mothers, grandmothers, and leaders in our community wrote a scathing letter indicting this government and this Prime Minister's lack of action in dealing with the healthcare crisis, particularly as it refers to children. Children can't breathe. They're ending up in emergency rooms that are full, waiting hours and hours to get care. And the Prime Minister hasn't shown up and shown leadership. For parents, the health of their kids is the #1 priority. Why isn't it for the Prime Minister?
Hear, hear. Honourable Prime Minister.
Mr. Speaker, I think it's beneath anyone in this House to suggest that there's any one of us who doesn't care about the well-being of children in this country. I know we all do, and I know we're all working very hard for it. As a government, we invested over $70 billion more over the past few years into our healthcare system to support provinces deliver during the pandemic, and we're sitting down with provinces right now to create better outcomes and better results from healthcare, which Canadians, and yes, Canadian families, and particularly Canadian kids need and deserve. We will continue to be there to support healthcare systems across the country. We will continue to work with all members in this House who, all of us, care about the children.
Member for Burnaby South.
Mr. Speaker, this government's lack of leadership is opening the door to privatizing our healthcare system. Conservative premiers throughout the country are attacking our healthcare system, and the Prime Minister is not showing appropriate leadership in response. What will it take for this Prime Minister to act and defend our healthcare system? The Right Honourable Prime Minister. Mr. Speaker, as my colleague knows very well, we are actively engaged in discussions with the provinces and territories on health care investment, but we are ensuring that we will deliver concrete results. We are indeed concerned by the trend toward privatization that we see in some parts of the country. That is why we are standing up for the principles of the Canada Health Act. We will be there to help the provinces deliver, and we will be there to ensure that the results actually help Canadians and families that need it.
Mr. Speaker, yesterday, the Governor of the Bank of Canada confirmed getting rid of the carbon tax will reduce inflation. This is the same carbon tax that's driven up the costs on gas, groceries, and home heating. This is the same carbon tax that hasn't helped the Liberals meet a single emission reduction target. The more they keep charging for it, the more emissions keep going up. So why won't the Liberals stop forcing their failed carbon tax scheme on Canadians?
The Honourable Parliamentary Secretary to the Minister of the Environment.
Well, thank you, Mr. Speaker. And the Governor of the Bank of Canada estimated that the price on pollution would add marginally to the impact on inflation, perhaps 0.1%, Mr. Speaker. That's 1 cent for every $10. On the other hand, Mr. Speaker, according to the Parliamentary Budget Officer, 8 out of 10 families will get more money back than they pay at the pumps. This helps with affordability and inflation, Mr. Speaker. And unfortunately, Mr. Speaker, the opposition wants to take this climate action incentive away.
Honourable member for Calgary, Forest Lawn.
Well, Mr. Speaker, that's a job well filled by this government. They haven't been able to fix the environment or the economy. They keep making things worse, driving more families into food banks. 1.5 million Canadians having to use food banks. 1 out of 5 Canadians having to skip meals. This is their plan. They don't have an environmental plan. It's a tax plan. It's not working. When will they axe the tax and give Canadians a break?
The Honourable Minister for Families.
Mr. Speaker, 450,000 children have been lifted out of poverty since we took office in 2015. Mr. Speaker, we have brought in early learning and childcare agreements across the country, and by the end of this year, families from coast to coast to coast will receive reduced childcare fees by up to 50%. Mr. Speaker, we have several measures that we have put forward, whether it's the Canada Dental Benefit, the Canada Child Benefit, the Canada Rental Benefit, that have seriously helped families in need. We know these are tough times, Mr. Speaker. We're there for families. We just don't understand why Conservatives are not. Thank you, Mr. Speaker.
Honourable member for Peterborough, Kawartha.
Under these Liberals, credit card use is the highest in Canadian history. Food bank usage, the highest in Canadian history. Many Canadians are just $200 away from insolvency. Among 38 rich countries, Canada ranks 35th in teen mental health and suicide. It appears these Liberals have forgotten who they work for. Perhaps they should stop listening to themselves and start listening to Canadians who are struggling to survive. Will the Liberals show compassion and leadership and stop forcing their failed carbon tax on Canadian families?
The Honourable Minister for Families.
Mr. Speaker, I really do believe it's the Conservatives that need to look within and find some compassion, because they have voted against measure after measure that has been there to support our lowest income Canadians and families and seniors that have been struggling. In fact, 450,000 children have been lifted out of poverty. We know there's more work to do, Mr. Speaker, but that's why in the fall economic statement we also enhanced the Canada's Workers' Benefit. It's why we doubled the GST tax credit for the next 6 months, because we know these are difficult times, Mr. Speaker. Mr. Speaker, the Conservatives have every opportunity to be there to support Canadians alongside us. They have just chosen not to. Thank you, Mr. Speaker.
For Peterborough, Kawartha.
Mr. Speaker, what's sad is that Christmas is just 31 days away. And instead of worrying about buying Christmas presents, Canadians are trying to figure out how they're going to pay for their home heating, their propane bill that they rely on, that has went from $4,000 to $12,000. That is triple the cost, Mr. Speaker. So again, I will ask, is there any leadership, any ability to listen to Canadians who are struggling to survive? This is not a luxury. This is a necessity. Axe the tax and face the facts.
The Honourable Minister of Tourism.
Mr. Speaker, I'm pretty sure that the Conservatives don't want to face the facts of their disastrous time in government for almost 10 years. 2 million fewer people are out of poverty, including 400,000 senior women. We raised almost 1 million kids out of poverty, Mr. Speaker. But, Mr. Speaker, do you hear what I hear in the spirit of Christmas? I'm not entirely sure which is the real Conservative Party on the other side. Those who are asking us to spend more, or those who are asking us to spend less? Fortunately, Mr. Speaker, I got the answer. It's the fall economic statement. Invest in those Canadians who need it the most, grow the economy, and position for a great future for Canada.
The Honourable Member for Bellechasse-les-Échemins-Lévis. Thank you, Mr. Speaker. Not knowing how to pay for groceries at the end of the week, or how to pay the heating bill, being a student who has to sleep in a shelter, or a worker who needs to go to food banks, where 1.5 million Canadians have had to turn in a single month. Can this Liberal government look Canadians in the eye and tell them sincerely that the carbon tax is good for them? The Honourable Minister. Mr. Speaker, with my hand on my heart, I can say that every time the Conservatives have had a chance to vote to reduce taxes, they always voted against it. With 10 years in power, they made Canadians poorer. Mr. Speaker, we will be eliminating interest on student loans. We will help people buy a house. We will be doubling the GST credit. The Conservatives have no plan except for crypto, but we do. The Honourable Member for Bellechasse-les-Échemins-Lévis. Mr. Speaker, the carbon tax just makes Canadians poorer, but it doesn't work. The Liberals know that Canadians are suffering due to inflation, but the government stubbornly continues to want to increase the carbon tax. Like the leader of my party, like all Conservative members in this place, will this government stop with its plan to increase taxes on Canadians, yes or no? The Honourable Minister. The Honourable Minister of Canadian Heritage. Mr. Speaker, the Conservatives on the one hand put their hand on their heart to say they care about Canadians, but they have scissors in the other hand, scissors to cut with, because they think we're investing too much in Canadians. The Conservatives should be more consistent. They are the party of cuts and austerity. They want to make cuts in services for seniors, youth, childcare. They should have the courage to come out and say so, Mr. Speaker. The Honourable Member for Pierre Boucher, Les Patriotes Verts. Mr. Speaker, the federal government unilaterally decided to move forward the deadline for submitting infrastructure projects for towns in Quebec. Otherwise, it will keep $2.7 billion. Yesterday, the former president of Quebec's Union of Municipalities, Éric Forêt, explained what the consequences will be. It will put a lot of pressure on Quebec for it to choose projects as a function of their size rather than merit in order to respect the deadline. That means that projects in small municipalities will fall through the cracks. It's not smart or fair. Does the government agree with that, or will it hear reason? Will it back down on this and listen to the mayors? The Honourable Minister. Mr. Speaker, you will not be surprised to hear that we do not agree with our colleague. He says we are not being fair towards Quebec municipalities. He won't like to hear this, but I had a very positive discussion with Quebec's infrastructure minister, my counterpart, the minister responsible for Canadian relations, and I believe we will reach an agreement with the government of Quebec in order to support municipalities and community groups, exactly those that my colleague wants to support. So good news, we too will be supporting them. The Honourable Member. Mr. Speaker, the Liberals don't seem to understand what actually happens on the ground, because their role in projects is just to announce the money and then go to the ribbon-cutting ceremony. But the reality is that the real work is done in our towns. And the Quebec Union of Municipalities has said that March 31st is basically tomorrow, and they will be severely penalized. All sorts of projects are being threatened, like shoreline erosion projects, sports and cultural centers, wastewater treatment facilities, and more. What are Quebec Liberals going to say to mayors when these mayors see that there's no more money for their projects, despite the fact that an agreement was signed? The Minister of Intergovernmental Affairs. Once again, Mr. Speaker, good news for my colleague. We will not be in that situation because, unlike what my colleague said, we will work with the government of Quebec in partnership with municipalities, as well as transit services. I had a very constructive and positive discussion with the mayor of Quebec City. For example, there is a cost-sharing agreement for the tramway project in Quebec City. We have projects throughout Quebec, and we are looking forward to carrying them out in partnership with the Quebec government and municipalities. The Honourable Member for Jonquière. Well, it doesn't seem to have been clear. Perhaps the interpretation was better, but to move the deadline forward by 2 years and threatening to keep the money if towns are unable to turn on a dime is almost blackmail. The federal government wants the money to be used quickly. Yes, we agree, but it should also be used in a smart and fair manner for the best possible projects for all municipalities, small or large. The government should collaborate instead of threatening our towns, which are doing their best. The government should back down on this. Can it promise that every cent that is not spent by March 31st will be transferred to Quebec and not into the government coffers? The Honourable Minister, I do not share the pessimism that my Bloc colleague is showing. We know that the Bloc Québécois is constantly looking to pick fights, but we, Mr. Speaker, good news, we are looking to work collaboratively. And in the 9 other provinces of Canada, we have found a way to invest this money in partnership with the provinces, and that's exactly what we're going to do with the Quebec government. I'm looking forward to visiting Quebec with my colleagues to share that good news with Quebecers.
Member for Brantford de Brant.
Mr. Speaker, Canadians are terrified. Last year, we witnessed the largest number of murders in Canadian history. 15 Canadians are being murdered every single week. Since the Prime Minister took office, gang-related killings have doubled. Instead of fighting crime with tougher punishment, the Liberals are making it easier for criminals to get back on our streets to re-offend. Will this Liberal government stop their soft-on-crime agenda?
Hear, hear.
The Honourable Minister of Justice.
Mr. Speaker, nothing could be further from the truth. What this party is doing, Mr. Speaker, what we're doing in a variety of our policies, is focusing our judicial and our police resources on serious crime, Mr. Speaker, with anti-gang measures, with tougher laws on guns, and, Mr. Speaker, by eliminating certain minimum mandatory penalties and allowing for conditional sentence orders in cases where there is no threat to public security, such that we can actually use those resources on serious crime. Mr. Speaker, serious crime will always carry with it serious consequences. That's a more just and equitable solution.
Member for Brantford de Brant.
Mr. Speaker, our Justice Minister is tone deaf. Despite their arbitrary bans and complicated buyback program, gun crime has gone up steadily every year since the Liberals were elected. Gun smugglers, drug traffickers, drive-by shooters, and kidnappers can thank this Liberal government because now they can serve their sentence in the comfort of their own homes. Once again, will these Liberals stop its soft-on-crime policy and focus on making our streets safer?
Hear, hear. Hear, hear.
The Honourable Minister for Public Safety.
Well, Mr. Speaker, it's somewhat surprising to hear from that colleague from the Conservative Party take issue with the $137 million that we've just invested in the CBSA to further tackle illegal smuggling, which the Conservatives voted against. So let's stack their record against the record of this side of the House, Mr. Speaker, which is one that will continue to equip CBSA with the tools they need to tackle gun smuggling, which is one that will raise maximum sentences against hardened criminals who traffic and terrorize our communities with guns, Mr. Speaker, and one that will also address root causes of gun crime. $250 million for the Building Safer Communities Fund. Mr. Speaker, it's time for the Conservatives to get on the right side of this issue, and that's now.
The Honourable Member, l'Honourable Député de Charlebourg.
The Honourable Member for Charlebourg, Haute-Saint-Charles. Mr. Speaker, Laval Police has just launched a major inquiry on armed violence with 150 officers, including officers from the Sûreté de Québec, the RCMP, and other services. Everyone is working together to fight armed violence, except this Prime Minister. His strategy of being lenient on criminals has caused an increase of 32% in violent crime throughout the country. Does the Prime Minister realize that he's contradicting all police services when he says that a member of organized crime firing an illegal weapon is not a serious crime? The Honourable Minister. Mr. Speaker, that is exactly why we brought in Bill C-21. And that is a bill where the Conservatives keep creating problems and getting it through. We need to get it passed to target these organized crime groups and bring in more severe, targeted sentences on criminals. It also offers new tools for our police services. We will continue to bring in common sense pieces of legislation to increase.
The Honourable Member for Rosemont, La Petite Patrie. Mr. Speaker, at the current rate of global warming, part of the planet is going to become uninhabitable, and natural disasters will get worse and worse here in Canada. And it's the most vulnerable who will suffer the most. And what was the Environment Minister's mandate at COP27? To do nothing. Status quo. Save the furniture and keep the oil companies happy. An environmental policy expert has said that what happened over 2 weeks at COP just highlighted the dissonance of the Canadian position. That means it's a contradiction. Canada has the worst record on the planet for GHG emissions per capita. The worst. Is the Minister of the Environment proud of being the worst?
The Honourable Parliamentary Secretary.
Thank you, Mr. Speaker. I beg to differ with the Honourable Member. We received praise coming out of COP27, Mr. Speaker, for our climate finance measures, for setting up a fund for developing nations to adapt to climate change, and, Mr. Speaker, to commit to eliminating coal, eliminating fossil fuel subsidies, to capping oil and gas emissions, and very, very importantly, Mr. Speaker, investing in the clean economy, $9.1 billion in our emissions reduction plan. Mr. Speaker, we will ensure that our emissions come down and that we build the economy of tomorrow. Thank you, Mr. Speaker.
Member for Vancouver Kingsway.
Conservative premiers want to take us back to the dark days of private health care. Ontario's Doug Ford openly talks about privatizing services. Heather Stephenson in Manitoba included it in her throne speech. And now Danielle Smith in Alberta wants patients to fundraise for their care. This is wrong. They threaten the very basis of universal public health care and make access depend on wealth and privilege. Will this health minister condemn these measures, enforce the Canada Health Act, and protect patients across our country?
The Honourable Minister of Health.
Thank you, Mr. Speaker. I'm very pleased to hear that question, and to acknowledge the very severe pressure that healthcare workers throughout our country are going through. Second, the patients, with backlogs in surgeries and backlogs in diagnostics. And third, Mr. Speaker, we are also very concerned with the pressures and the ambition that we see across Canada around privatization of our healthcare system. We want to maintain accessibility, universality, fairness in our healthcare system across our country.
Honourable Member for Etobicoke Lakeshore.
Mr. Speaker, speaking truth to power is not always easy, but it is necessary. Canadians take inspiration from human rights defenders and leaders like Svetlana Tikhanovskaya, who have the courage to speak up for what is right. Her actions, as well as those of Ukrainians, serve as a reminder that we must work together to create the world we want to live in. Can the Minister of Foreign Affairs update this House on the visit of the Belarusian opposition leader in Canada this week and measures our government is taking to hold Lukashenko's regimes accountable?
Good question. The Honourable Minister of Foreign Affairs.
Speaker, and thank you for my colleague for his important question. This week I had the pleasure of seeing my good friend from Belarus, Svetlana. We had the chance to discuss our new sanctions against Lukashenko's regime in its complicity in Russia's war of choice. We also talked about the brutal disregard of human rights by the Lukashenko's regime. And, of course, we want to do more, and we will do more to amplify democratic voices within Belarus. Mr. Speaker, impunity is not an option for those who commit human rights violations. There must be accountability, and Canada will see to it.
The Honourable Member for Thornhill.
Do the Liberals believe that it's acceptable for Iranian Canadians to drive to a location far away from their homes to speak to their MP with a blurred background about their fear of reprisal for protesting Iran's brutal regime? That's what's happening in Canada. And we know that Canada's spy agency is investigating credible death threats from the same regime against our citizens. They are begging for this government to keep them safe. What more do they need to act? When will they finally use the criminal code, list the IRGC as a terrorist organization, and shut down their operations in Canada?
The Honourable Minister for Public Safety.
Mr. Speaker, I want to be unequivocally clear that on this side of the House, we stand with the women in Iran who are marching for their rights, Mr. Speaker. That's why we designated the entirety of the Iranian regime using a sparingly used power under IRPA. Mr. Speaker, this will allow us to go after those who are most responsible, the senior echelons and the architects of these transgressions of human rights, Mr. Speaker, including the members of the IRGC that my honourable colleague continues to underline here. And we will give police enforcement all of the tools that they need to make sure that Canada is never a safe haven for any support for that regime, Mr. Speaker. Thank you.
Member for Wellington, Halton Hills.
Mr. Speaker, our questions are not about the overall integrity of the 2019 and 2021 elections, nor questioning that overall our elections are free and fair. We're asking about who knew what when about Beijing's interference in our elections. The Prime Minister, in response to questions, said, quote, "I do not have any information, nor have I been briefed on any federal candidates receiving any money from China," end quote. The government is parsing its words and is obfuscating. So let me ask the government this question, Mr. Speaker. Has the government received any information about election interference by Beijing.
Good job. The Honourable Minister for Public Safety.
Mr. Speaker, I would begin by echoing the concerns that my colleague raises in this House when it comes to allegations of foreign interference. And that's why we want to work together with all members in this House to assure Canadians that we will do whatever it takes to protect the integrity of our elections, Mr. Speaker. And my colleague knows that we've had independent reviews of both the 2019 and the 2020 election, which have confirmed that the integrity of those elections were free and fair, Mr. Speaker. And we will continue to make sure that our national security apparatus has all the tools that they need to make sure that Canadians have their voices represented in this chamber. Thank you.
The Honourable Member for St. Albert, Edmonton.
Mr. Speaker, the Prime Minister told the media that he has directed his security officials to share all the information they can with PROC about Beijing's election interference. Yet at PROC, the Liberals gutted our Conservative motion for the production of documents by removing expressed mention of the PMO. So, will the Prime Minister assure this House that his office will hand over all relevant documents, or does he have something to hide?
Here. The Honourable Minister.
Mr. Speaker, once again, I want to assure my colleague and all Canadians that we are equipping our national security apparatus with all of the tools that they need to ensure that elections are free and fair. We are cracking down on foreign funding through the introduction of Bill C-76. We are providing additional resources, quite frankly, to backstop the cuts that were made when the Conservatives were last in government, Mr. Speaker, and we will do what is ever is necessary to continue to have a system that is transparent, that is accountable, and yes, that means also working with the independent bodies within Parliament so that we can have elections that are free and fair. Thank you.
The Honourable Member for Mégantic-l'Érable. Mr. Speaker, the Prime Minister has quoted the Chief Electoral Officer several times when to support his refusal to give documents to this House about foreign interference. But, Mr. Speaker, I would quote the CEO. He said, "We don't know what happened and in which writings it happened. We don't know if money was given to candidates for their campaigns or their personal purposes. We're talking about potentially very serious violations of the law that would indeed taint the election in a significant way. Will the Prime Minister be transparent and provide the committee all the relevant documents, or is he going to keep hiding the truth?" The Honourable Minister. Yes, Mr. Speaker, as the Prime Minister has already said, we are going to work with the Parliamentary Committee, but I would like to highlight that there are two independent, nonpartisan reviews which have confirmed the results of the 2019 elections and even the 2021 elections, and confirmed that they were free and fair, and that's what's most important. But yes, there are threats of interference, of foreign interference, and that's why we are going to make all the necessary investments to protect our national security apparatus, and we will continue to work with all members in this House. Thank you. The Honourable Member for Shefford. Mr. Speaker, yesterday, the Liberals opposed an independent commission of inquiry into toxic culture in sports organizations. I'm flabbergasted. After the scandals at Hockey Canada, after gymnasts have testified in committee about the sexual abuses that they have suffered, after Global Athlete warned us about abuse in soccer, skiing, swimming, figure skating, and, I could keep going until tomorrow morning with that list. Are they serious? What's it going to take for the government to launch an independent commission of inquiry into abuse in all sports? The Honourable Minister of Sports. Mr. Speaker, first I would like to salute the courage of athletes who have shared their stories and who have spoken out about the abuse they've suffered in sports. I hear them, I see them, and I believe them. At the national level, we've created the Office for Integrity in Sports, which can investigate cases of abuse, but which can also investigate culture in certain sports. And I'm working with my colleagues in the provinces and territories to make sure that all athletes, whatever level they're at in sports, whether it be local, provincial, national, know where to turn when there are cases of abuse and mistreatment. The Honourable Member for Shefford. Mr. Speaker, that's not what they want. The truth is that victims have lost confidence in this system, and they're losing confidence in this government. They are the ones who are calling for further action and for an independent commission of inquiry. These women want all sports to be cleaned up. We already have an inquiry into Hockey Canada, and now gymnastics is under the microscope at committee. We can't go through all the sports one by one as new abuse cases make the news. We need wide-ranging recommendations to counter the widespread toxic culture in sport. When will we have an independent commission of inquiry? The Honourable Minister. Mr. Speaker, the stories we're hearing from athletes, including those from gymnasts, are heartbreaking. And I stand with those people, and I will continue to do that every day. Sport has to be a place that's positive for mental health and for physical health, and all levels of the Canadian sports system have to do better, and that's why I continue to work with all of our partners to make sure that everyone is taking this situation seriously and that everyone is doing everything they can to completely eradicate abuse and mistreatment in sport. The Honourable Member for Portneuf, Jacques Cartier. Thank you, Mr. Speaker. This Liberal government speaks out of both sides of its mouth when it comes to English-French bilingualism. It appointed a Governor-General who does not speak French. They chose a unilingual English lieutenant governor for the only bilingual province in Canada. It blocks Francophone immigration, and the list goes on, Mr. Speaker. Now, the NDP Liberal coalition is muzzling the Official Languages Committee and preventing us from improving their ineffective Bill C-13. What hypocrisy! Will the Prime Minister give instructions now to immediately stop all measures that are threatening French? The Honourable Minister of Official Languages. Thank you very much, Mr. Speaker. Mr. Speaker, what's important is that the Bloc Québécois and the Conservatives stop blocking our bill. We have heard from people from across the country who tell us that right now it's time to move forward. People are telling us that they want to see Bill C-13 passed because they want to be able to start working on regulations. The Bloc and the Conservatives are continuing to play political games, and Mr. Speaker, that's completely unacceptable.
The Honourable Member for Charleswood St. James, Assiniboia, Headingley.
Mr. Speaker, since 2015, this Prime Minister has doubled our national debt to $1.2 trillion. Over $100 billion of that was even prior to the pandemic. He's incurred more debt than all other Prime Ministers combined. Just yesterday, the Governor of the Bank of Canada told me that but for this massive spending, inflation would have been less. And so this is a very important question, Mr. Speaker. Will the Prime Minister finally admit that his failed fiscal policy is costing Canadians more for everything?
Honourable Minister of Tourism.
Mr. Speaker, I would like to remind the opposite side of this House and Canadians that Conservatives voted with us to support Canadians during the pandemic. If they're having heartache over that now, that's on their conscience, not on ours, because we did the right thing to support Canadians. Mr. Speaker, Canadians and people around the world are facing a crisis when it comes to cost of living. But, Mr. Speaker, while we have the lowest debt-to-GDP ratio, the lowest deficit in the G7, while we have among the lowest inflation in the world, Mr. Speaker, that's not good enough. That's why we're helping those Canadians who need it the most when they need it the most, investing in the economy so that it can grow, and investing in our fiscal position so that we can meet the challenges of the future.
Honourable Member for Charleswood St. James, Assiniboia, Headingley.
Well, Mr. Speaker, the reality is that 40% of spending that took place during the pandemic, according to the government's own appointed parliamentary budget officer, had absolutely zero to do with the pandemic. So the member's response is cold comfort for those who can't afford to heat their homes because of carbon tax, or can't afford to stay in their homes because of interest rates, or can't afford groceries because of inflation. So, Mr. Speaker, the fact of the matter is that the bank governor has now confirmed what we all feared. Excessive government spending is the cause of made-in-Canada inflation. Will the Prime Minister stop this problem, stop the spending, and get inflation under control?
Honourable Minister.
Speaker, moms and dads who use the CERB to stay home and take care of their kids, did not cause inflation. Businesses who wanted to keep their doors open so they could serve Canadians in 2022 for the Christmas season did not create inflation. This government took the steps it needed to support Canadians, to support businesses, to support provinces, and Mr. Speaker, I can tell you what we have done in the fall economic statement is support the economy so that it can grow, make sure that our fiscal position is strong, and what are we doing, Mr. Speaker? Responding to the needs of those Canadians who need help when they need it now. What are they doing? Suggesting to people to invest in crypto. That's irresponsible.
The Honourable Member for Dorval-Lachine-LaSalle. Mr. Speaker, it's very clear that not only have the unnecessarily harsh and ineffective policies of previous governments failed to protect our communities, but they have contributed to the overrepresentation of Aboriginal people and racialized and marginalized Canadians in our justice system. Can the Minister of Justice please inform the House of the concrete steps our government is taking to move away from these policies? Thank you. The Honourable Minister of Justice. Mr. Speaker, I'd like to thank the member for Dorval-Lachine-LaSalle, my neighbour, for her important question and her excellent work for our community. Mr. Speaker, with Bill C-5, for the first time in the history of Canada, we have repealed mandatory minimum sentences, giving judges the flexibility to impose sentences that fit the crime. That means that prosecutors and police can spend more time and resources fighting serious crime. We have repealed the mandatory minimum sentences that contributed most to the over-incarceration of Indigenous people, Black people, and racialized Canadians. With C-5, we have acted.
For Calgary, Midnapore.
Mr. Speaker, everyone agrees that this government is failing. Even the Governor of the Bank of Canada said yesterday that this government has been spending too much for too long. Even the Parliamentary Budget Officer said that Albertans will spend $2,000 more on the carbon tax than they will get back in rebates. So when will this government do the right thing and cancel their plan to triple the tax on gas, groceries, and home heating?
The Honourable Parliamentary Secretary to the Minister of the Environment.
Speaker, and as usual, the Conservatives are spreading misinformation. And let's look at the Conservative record for a moment, Mr. Speaker. They cut $350 million from the Environment and Climate Change budget. They withdrew from the Kyoto Accord. And, Mr. Speaker, for 10 long years, they did absolutely nothing on climate change. And for that, Mr. Speaker, at all the international meetings they went to, they won Fossil of the Day Award, the Fossil of the Year Award. And, Mr. Speaker, they won the granddaddy of them all in 2013, the Lifetime Unachievement Fossil Award.
The Honourable I'm going to wait till his entourage calms down before I let the Honourable Member speak. No, on this side. We're done? Very good. The Honourable Member for Selkirk, Interlake Eastman.
Inflation is stuck at 40-year highs, and the cost of groceries is up 11%. Rural Manitoba seniors like Suzanne are skipping meals so often that she's actually not eating 2 or 3 days each week. She's wearing her winter jacket in her home. She doesn't have to turn up her heat. And Suzanne is struggling to put gas in her car to drive an hour and a half to Winnipeg to see her doctor. So when will these Liberals stop hurting our seniors and axe the carbon tax increase on heating and eating?
The Honourable Minister for Seniors.
Mr. Speaker, I think it's important to look at the facts. And the fact is, Mr. Speaker, when the Conservative Party was in power, their plan for seniors was to raise the age of retirement to 67, Mr. Speaker. Mr. Speaker, the fact is the first thing that we did, we reversed that back to 65. The fact is, Mr. Speaker, the party opposite opposed every single measure that we put forward to support seniors, including the increase to the guaranteed income supplement, including increase to the old age security by 10% for those 75 and over, including our enhancements to the CPP, Mr. Speaker. I won't take any lesson from the party opposite in supporting seniors. We're going to continue to be here for them.
The Honourable Member for Regina Louvain.
Mr. Speaker, if you want to talk about just the facts, here's some facts. For 7 years, taxes have gone up on all Canadians. For 7 years, emissions have gone up. We had a better record on emissions than this government ever has. And those are the facts. Here's some more facts. 1.5 million Canadians rely on food banks, but food on their tables. Universities are sending out fundraising letters to let kids eat before they go to bed now at our universities in Canada. This is the Canada these Liberals have made. So when will they get it together and stop forcing their carbon tax, their failed carbon tax, on all Canadians?
The Honourable Minister.
I am so delighted to get this opportunity right now to be able to tell a family of 4 in Newfoundland and Labrador that they will be getting $1,312 in their bank account every year, 4 times a year, cash in the bank, $328 in July, next July, $328 in October, just when they're getting ready for the winter, again in January, again in April. I welcome another question from the other side so I can talk about how we are bringing more money back into the hands of Newfoundlanders and Labradorians, Mr. Speaker.
The Honourable Member for Calgary Skyview.
Mr. Speaker, this past Tuesday marked National Housing Day, and I'm proud to say that it was this government that legislated the recognition of housing as a human right. Since its launch, the National Housing Strategy has invested upwards of...
I'm going to have to interrupt. I'm having a hard time hearing the question. Now, I just want to say, we take turns, and it's his turn now, and shouting questions, it doesn't work that way. The Honourable Member, from the top so we can hear the full question, please.
Mr. Speaker, this past Tuesday marked National Housing Day, and I am proud to say that it was this government that legislated the recognition of housing as a human right. Since its launch, the National Housing Strategy has invested upwards of $72 billion to ensure that every Canadian has a roof over their head. Could the Minister of Housing and Diversity and Inclusion tell this House about the work that our government has and continues to do for Canadians from coast to coast to coast?
Of Housing.
Thank you, Mr. Speaker. I want to thank the Honourable Member for his really important question and strong advocacy on this issue. Since coming into office, we've had historic investments to create and repair over 440,000 homes across the country. But we're not stopping there, Mr. Speaker. Earlier this month, I launched the 3rd round of the Rapid Housing Initiative, which will ensure an additional 4,500 deeply affordable homes for the most vulnerable across the country. We believe on this side of the House that housing is a human right, and we will not rest until each and every Canadian has access to a safe and affordable place to call home.
The Honourable Member for North Island Powell River.
Mr. Speaker, the Liberals have been failing veterans for years. The minister has refused to hire permanent staff to support veterans, suspended services for over a month, and is now delegating tasks to a private company owned by Loblaws for hundreds of millions of dollars. Meanwhile, VAC is delayed the contract rollout because workers haven't been properly trained. This is a crisis. Veterans deserve so much better. Why is the minister putting profits ahead of care for our veterans and their families, and will he stop this botched contract?
The Honourable Parliamentary Secretary.
Thank you, Mr. Speaker, and I want to thank my colleague for a question, but I do want to explain to the House that this is totally unacceptable and irresponsible question, because this new contract, Mr. Speaker, will give access to 14,000 veterans, that will have access to 9,000 medical service staff, and it will have 600 offices available to them. Mr. Speaker, this will also allow our case managers to reduce their administrative time and have more time to spend with our veterans. Thank you.
The Honourable Member for Saanich Gulf Islands.
Thank you, Mr. Speaker. For years, the residents of Saanich Gulf Islands have had their pristine environment where we live on the shores of the Salish Sea, contaminated by polluting commercial anchorages, essentially free parking for freighters. This last month, the Port of Vancouver has been holding what they call public consultation. The constituents of Saanich Gulf Islands don't feel consulted. They once again feel ignored as the Port of Vancouver tells them that these anchorages are essential to the Port of Vancouver instead of figuring out how to make the Port of Vancouver efficient.
The Honourable Minister of Transport.
Mr. Speaker,
Over the last couple of years, we've seen global supply disruptions that have impacted here our own supply chains at home. And because of that, we've seen congestions at our ports and increased vessels that are anchored next to our coast. Mr. Speaker, I've been listening to constituents on the coast, particularly where the honourable colleague is raising the point. I want to assure her that we're putting together an action plan to address this. We tabled Bill C-33 just 2 weeks ago that will introduce new tools to help mitigate the traffic of the vessels, Mr. Speaker. We will work with her and constituents to make sure that we manage this adequately, Mr. Speaker.
Good job. I'm afraid that's all the time we have for question period today. C'est tout le temps.
That's all the time we have today for question period. We'll take a little breather before we continue.
Okay, I'm going to ask everyone to maybe just take a deep breath, and if they've got a conversation, they can take it into the lobby. In the meantime, I believe the Honourable Opposition House Leader has a question today.
Yes, Mr. Speaker, it's the best part of Thursdays. It's the Thursday question where the... Oh, wow. I just wanted to ask the government House Leader if he can inform the members as to the business for the rest of this week and for next week as well. And I would like to take the opportunity to make a couple of suggestions for the government business. We had the Bank of Canada Governor admit at committee that deficits fuel inflation. So I was wondering if there'd be an opportunity for the government to introduce another fall economic update where they would lower their deficits. Also, Mr. Speaker, I was wondering if the government might schedule a take-note debate at some point next week so that the House can really study the Parliamentary Budget Officer's report that concludes, based on numbers that the government has provided, that the vast majority of Canadians pay far more in the carbon tax than anything they hope to receive in the form of a rebate.
Before we go, I may be wrong on this, but I understand it's the Thursday question, not the Thursday statement. But I'll let the Honourable Government House Leader respond.
Well, thank you, Mr. Speaker, and far be it for me to ruin the best part of Thursday, although the Opposition House Leader and I may be alone in that opinion that this is the best part of Thursday. I will say, Mr. Speaker, that I'm beginning to think, and I could be wrong in this supposition, that the Honourable Opposition House Leader is making statements and not asking questions, but in the event that it is a question, I'd be happy to respond. First, it is not enough, of course, Mr. Speaker, when we take a look down the list, whether or not it is the Netherlands or it is Belgium or it is Sweden, or it is Austria, or it is Denmark, or it is the entire Eurozone, or it is Iceland, or it is Spain, or it is Italy, or the United Kingdom, or Mexico, or the United States, or Ireland, and I could go on and on. It doesn't matter that we have lower inflation rates than all of those countries. It doesn't matter that we have one of the lowest inflation rates in the world. That is cold comfort to somebody who's working hard and trying to pay the bills, and that's why, no, Mr. Speaker, we're not going to stop the supports that we have for Canadians. In fact, I would suggest to the member opposite that making sure that our most vulnerable are protected is critical, and that's why we have a number of things that we're going to be doing in that regard that I'll illuminate in a moment. As to the other question that was put, I do seriously want to say that if the opposition, the Conservative opposition, is in opposition to action on the climate, that have they reflected about what those costs are? these are not costs that will be borne for a year or two, but for all time. So, Mr. Speaker, something to reflect on in the questions that were posed to me. But I can say, Mr. Speaker, that I'm pleased that this afternoon we're going to complete the second reading debate of Bill S4, an act to amend the Criminal Code, and the Identification of Criminals Act, and to make related amendments to other acts. Tomorrow we will go back to second reading debate of C20 concerning the Public Complaints and Review Commission Act. On Monday we will resume second reading debate of Bill C27, the Digital Charter Implementation Act 2022. For Tuesday and Wednesday we will call Bill C29, an act to provide for the establishment of a National Council for Reconciliation, which was reported with amendments from committee earlier this week. And Mr. Speaker, I see you moving in your chair, so you'd be happy to know that I'm saying finally for next Thursday our plan is to commence second reading debate of Bill C26, the Critical Cyber Systems Protection Act. Thank you, Mr. Speaker.
I was squirming in my chair both when House leaders were up, and I just want to remind, I know both of them have a little bit of knowledge on procedure in the House, and the Thursday question is a Thursday question, not a statement, and not on either side. I just want to remind them of that. I know they didn't do it on, well, I'll let the jury out on that. But anyways, I just want to point that out again before we proceed to the point of order being put forward by the Honourable Member for Perth Wellington. Please.
Thank you very much, Mr. Speaker. And I would just draw your attention to the article, It Being Thursday, the weekly business statement in minority and majority parliaments, which does a great job, I might say, of outlining the evolution of the Thursday question, and frankly, the wonderful statement that the minister, or the member from Regina Capel did. And frankly, if we go back in history to the Liberals when they were last in power, you would find that actually it was a time where the Liberals used it as a partisan shenanigan, and it was actually the Conservatives who were able to rein that in and have an excellent way of making statements, as the member from Regina Capel did earlier today.
I'm sure the honourable member is not arguing for shenanigans to continue. I mean, I wouldn't want that, and I would just want the question asked and find out what's going to happen on both sides so that we can get on. And the honourable member for Saint-Jean, l'honorable député, a des questions qui lui viennent. Elle a 6 minutes.
The honourable member for Saint-Jean has 6 minutes for questions.
Of the day first.
Government orders, Government Bills Senate. Resuming debate at second reading of Bill S4, an act to amend the Criminal Code and the Identification of Criminals Act, and to make related amendments for other acts, COVID-19 response and other measures.
Alors nous allons continuer avec l'honorable député de...
Very well. The honourable member for Saint-Jean has 6 minutes and 45 seconds. Questions and comments. The honourable member for Beauce. Thank you, Mr. Speaker. I greatly appreciated my colleague's speech earlier. I have a simple question for her. We talk a lot about improving technology. Now, I'd like to hear from her on audio conferencing. Of course, video conferencing is important too, but what does she think of audio conferencing? The honourable member for Saint-Jean. Well, that was something that was raised in the Barr report when the bill was originally debated, because audio conferences can sometimes be used when it's not possible to have a video component, but the interpretation will be restricted. And that's why I'm glad that the legislation will be reviewed in 3 and 5 years to see if things are really working and whether procedural guardrails are being maintained. And so things may evolve a bit when it comes to procedural guarantees and fairness. Perhaps that will be one of the parts of the bill that will ultimately disappear at that point.
Questions and comments. The honourable member for Skeena-Bulkley Valley.
Thank you, Mr. Speaker. I wonder through you to my honourable colleague if she feels, like I do, that reducing court backlogs is so important that this bill should have been introduced much earlier in this parliamentary sitting, and whether she could share her thoughts with the House as to why that wasn't the case.
Honorable député de Saint-Jean.
The honourable member for Saint-Jean. I'd like to thank my colleague for Skeena Bulkley-Valley. Yes, indeed, of course. We've come back to this so many times. We know that this government triggered elections and all sorts of good legislation died on the order paper. We know that elections are expensive. And they're even more expensive when they're just triggered in a willy-nilly manner and all the good work ends up going for nothing. But specifically when it comes to backlogs in the justice system, I do not think that this bill is a silver bullet. We need to remember that. This is only one part of the work. We shouldn't think that just because we have S4 that we don't need to work hard in other areas of the legal system or other parts of the application of the criminal code to reduce backlogs. There is a great deal of work to do, and S4 doesn't cover everything.
Comments, questions et commentaires? L'honorable député de...
The honorable member for Joliette. Thank you, Madam Speaker. I'd like to thank my colleague for her speech. If we want to improve the entire legal system, well, here we're talking about connectivity, but I'd like to hear from my colleague on issues on the parole board, on the appointment of judges, and also on the existence and use of the liberalist system. Thank you. I'd like to thank my colleague for his question. I did mention that in my speech, but with regard to connectivity, one of the risks I see here is that a disparity may be created between different regions. That some people may have to show up in person to a court because they don't have good connectivity when you live in certain areas. Or conversely, in some areas, it may be easier to use audio conference and that some people may be pressured to use that tool or video conference when they could appear in person. So there might be a disparity in the treatment of people living in different areas, and that's something that the House and the Independent Commission could look at.
Questions et commentaires. Questions and comments, the Honourable Parliamentary Secretary to the Government House.
Yes, thank you, Madam Speaker. In the member's comments earlier, before question period, she made reference to facial expressions and things that would be lost upon if, in fact, it went virtual. Would you not agree that those type of considerations would be taken into account in situations that might be of concern to whether it's a defense lawyer or the attorney itself, the Crown?
Honorable député de Saint-Jean.
The honourable member. Madam Speaker, one cannot take into consideration something that one is not aware of. And just like we see here when we use video conference in the House, we don't have a full understanding of what's going on around. It's not just someone's facial expression. It could be the fact that someone's fidgeting with their feet, that they're passing a note to their lawyer, or the reaction in the room. We could maybe see a witness's reaction to another witness's remarks and how they react to what's happening in the courthouse. So the frame that we see on a screen doesn't give us all of the information. There are other factors, and some information could be lost, and that needs to be considered when this legislation is reviewed. There may be a risk that lawyers may agree between themselves at the beginning to use video conference, and then during the case, they realize that something is getting lost and that things need to return to in person, and that will actually reduce efficiency rather than increase it. So I hope that this matter will be considered when the bill is reviewed. What happens when the parties no longer consent to use video conference?
Reprise du débat, the Honourable Member for Sherwood Park for Saskatchewan.
Thank you, Madam Speaker. I'm going to take the unprecedented step of sharing my time with the member for Vaughan Woodbridge. I hope that's some encouragement for him to see the light on some issues. We are co-chairs of the Canada-HoC Parliamentary Friendship Group, and I would invite members of the House to watch their inboxes for upcoming events. My remarks will be a little bit more abbreviated than usual today because of some other commitments. I do want to speak on Bill S4. And the context of S4, the bill we're debating, is some proposals from the government around measures related to digital access to various aspects of our criminal justice system. But the larger context of this is that we have a government right now that so many Canadians are experiencing as a government of delay. Canadians, I think, defining impression of this current Liberal government is significant delays in terms of being able to access vital services that they need. We've had outrageous delays for people trying to access passports, standing in incredibly long, sometimes dangerous lines, needing to be there from early in the morning. We have totally unacceptable delays in our immigration system. People waiting to sponsor vulnerable refugees who have to wait, in some cases, 3 years or more before they can bring vulnerable refugees to this country, waiting to be reunited with spouses, to have employees come to the country. So we have delays when it comes to passports, delays when it comes to immigration, delays when it comes to accessing benefits. It's delay, delay, delay that reflects this government's poor management of so many files. And in particular, in the context of this bill, we are seeing delays and challenges in terms of accessing the justice system in a timely way. And that's particularly dangerous because when there are significant delays in terms of getting to a hearing, getting to adjudication of issues, people who have actually committed crimes may be not charged or have their charges not proceed on the basis of delays that have occurred, which is a grievous injustice for victims. And there are a number of steps I think the government needs to take when it comes to addressing these issues of delays in our justice system. Of course, one of the things that is driving further delays and strains on our justice systems is the increase in crime. We're seeing a dramatic increase in crime under this government, especially violent crime, and the government's strategies reducing sentencing are not working, but they're also adding to the burden on communities, on police, and also our justice system. So we are seeing in a variety of areas increasing demand for services driven by the increase in violent crime this government has presided over, and resources have not been available to match, and we're seeing significant delays. Of course, there have been challenges through the pandemic period that relate to the adjudication of hearings, but the fundamental reality underlying that is that we're seeing an increase in crime, increasing demands on our justice system, and significant delays in court hearings and across the spectrum of different services that this government provides. So what we are calling on this government to do is to focus on the hard work of actually running the country, to find ways of delivering services better, more efficiently, more effectively. It is not enough to tell people about your aspirations, your hopes, and your intentions. Good intentions are not enough. What Canadians want to see is an ability by the government to deliver results, which means delivering services that people need in a timely way. And they're not seeing that. They're seeing platitudes about good intentions from these Liberals, but a failure to actually deliver on services. Ironically, we have a government here that wants to ever expand their control, say we're going to offer more and more and more and more, and yet they cannot deliver the core services of government efficiently and effectively. We need a government that's going to focus on delivering the core responsibilities of government well, effectively, and in a timely way. So with that, I'll conclude my remarks, Madam Speaker, and I look forward to questions.
Questions and comments. Questions et commentaires. The Honourable Parliamentary Secretary to the Government House Leader.
So thank you, Madam Speaker. The legislation itself is, in a very real way, a reflection in terms of what it is that provinces were looking at seeing some changes on. It also takes into consideration some of the things that we've witnessed through the pandemic. In other words, a modernization to a certain extent of recognizing the importance of technological several advances, Madam Speaker. And my question to the member is, I understand that the Conservatives are supporting the legislation, which is a really good thing, but at the end of the day, providing this opportunity, I believe, is healthy for our judicial system, which is in fact independent, but there seems to be a fairly good ground support to see this legislation pass. And if he can provide his thoughts in terms of the importance of the legislative legislation itself.
The Honourable Member for Sherwood Park for Saskatchewan.
Well, thank you, Madam Speaker. I support the legislation. I think the mechanisms that it provides for are worthwhile, at least at this stage. I think we need it to be looked at further at committee, and I think our party will be coming forward with some constructive proposals for strengthening it. But fundamentally, it's also important to acknowledge the context that Canadians are seeing, for a variety of reasons across the board, delays in delivering vital services. That includes delays in terms of the judicial system. And I don't think COVID is the only factor that's contributing to that. We're also seeing under this government a rise in crime, a significant rise in violent crime, and a failure to acknowledge that and respond to the circumstances that are creating that rise in crime. So this legislation, yes, but there's more work to do.
L'honorable député de Pierre Boucher, les Patriotes Verchères.
The Honourable Member for Pierre Boucher, les Patriotes Verchères. Thank you, Madam Speaker. I appreciated what my colleague said on several points, especially what he said about the delays in service delivery because of this government in many cases. We often find ourselves asking whether this government is simply broken. But getting back to S4 specifically, because he talked about delays, but we're talking here about S4, delays in the justice system. And in fact, delays in the justice system are particularly long, which makes it very hard to have an effective system. So I'd like to ask my colleague if he's satisfied with this bill and if he feels it will make a significant difference in delays in the justice system, and if not, if other changes could be made to improve the situation.
For Sherwood Park for Saskatchewan.
Thank you, Madam Speaker. And I agree with the sentiment of my colleague that this government is broken. We have significant problems and delays in the justice system. And I think from the Bloc, he'll particularly appreciate this point, that it is the government that has presided over a significant increase in crime, and yet it is the provinces that are left holding the bag in terms of paying the resources that are required when it comes to the administration of justice at the local level. So what the government, I think, needs to do, in addition to moving this bill forward, is to come up with real solutions that address crime. And so far, their only solution to crime is to target people who don't break the law, to add additional red tape for law-abiding citizens who happen to own firearms. We see last-minute proposals at the committee stage from this government to ban hunting rifles. That's not a solution to the crime that we see at all. That's merely harassing law-abiding citizens with in some cases, red tape, in some cases, outright bans. And that's not going to address the problem that we're seeing. This government has presided over a significant increase in serious violent crime. They need to take stock of that problem. Look, there's lots of strategies we can talk about for reducing delays and backlogs in our court system. One great way to do it, though, would be to actually reduce crime.
Questions and comments? The Honourable Member for Langley Aldergrove, a short question.
Good, thank you. I have a very short question for my colleague, and that is if video conferencing is going to become more prevalent in our court systems, what is the state of our internet, particularly in rural areas? And is that going to be able to service the judicial system adequately?
Sherwood Park, Fort Saskatchewan, a very brief answer.
Well, thank you, Madam Speaker. I think it's a great question, and I think it is a problem. My riding is kind of a mixed suburban, rural riding, relatively close to the city of Edmonton compared to some areas. But there are still some issues in terms of coverage in my riding, and it is very important. I think for a whole host of reasons: access to justice, access to government services, ability to participate in the digital economy that we address.
And we have to resume debate. The Honourable Member for Vaughan Woodbridge.
Thank you, Madam Speaker. It's wonderful to be here this afternoon and rise to speak on Bill S4. a bill that, again, demonstrates cooperation on a jurisdictional basis with the province and with the provinces, I should say, and a bill that, again, moves our justice system forward so that Canadians know that our justice system is accessible, efficient, and effective, and, again, provides true justice, true access to justice for all Canadians from coast to coast to coast. So it's with much pleasure that I rise to speak on this bill, Madam Speaker. I'm pleased to be here to have the opportunity to provide an overview of some of the key areas of reform proposed in Bill S4, an act to amend the Criminal Code and the Identification of Criminals Act, and to make related amendments to other acts. Informed by federal, provincial, and territorial dialogue and key stakeholder input, the proposed amendments are intended to mitigate the impact of court delays on accused persons and on victims by supporting the efficient and effective operation of the criminal courts during and in the aftermath of the pandemic. They are designed to enhance the court's ability to ensure that their operations respect both public health concerns for all participants in the criminal justice system, as well as their charter right of an accused persons to be tried within a reasonable time so as to maintain public confidence in our justice system, Madam Speaker. The proposed amendments are based on the following criteria. They, 1, were critical to increasing the efficiency of the criminal justice system during the conditions of the pandemic. 2, address the current impediments to efficiency in the criminal code. And 3, would have little or no prejudicial impact on accused persons. And 4, are likely to receive broad-based parliamentary support. And 5, would result in amendments to the criminal code that would continue to provide efficiencies post-pandemic. The pandemic significantly impacted the operation of the criminal courts in Canada, Madam Speaker, as we all know, with courts either temporarily closing or severely restricting their operations due to public health orders. Furthermore, the pandemic exposed weaknesses of our criminal court system that can be fixed, Madam Speaker, by providing remote access to proceedings under special circumstances. Bill S4 will go beyond correcting for issues discovered during the pandemic. It will make the justice process in Canada more efficient and accessible. Bill S4 addresses issues that the COVID-19 pandemic has brought to light regarding the ways in which criminal trials are conducted in this country. It also builds on past government initiatives, including former Bill C-75, which came into force in 2019 and made significant progress in modernizing our criminal justice system, including by facilitating the appearance of accused persons, lawyers, and judges by audio or video conference throughout the criminal justice process. Criminal justice is an area of shared jurisdiction, Madam Speaker, and cooperation with provincial and territorial partners is key. Parliament has exclusive authority to enact criminal law, including criminal procedure. Provinces and territories have jurisdiction over the administration of justice, including criminal courts. While the courts and criminal justice professionals are, for the most part, managing to maintain essential services in the criminal justice process during the pandemic, accused persons, offenders, victims, and witnesses are nonetheless being impacted by delays. While many challenges facing the criminal courts have been operational in nature, some have arisen due to legislative impediments in the criminal code. Consequently, the pandemic has revealed the need for a number of amendments to the criminal code to provide clarity to the courts on issues that have arisen and to make criminal process more efficient and effective, Madam Speaker, by expanding the permissible use of technology during the pandemic for the recuperation period and beyond. These proposed reforms are for the benefit of all participants in the criminal justice system. Bill S4 modernizes our criminal justice system by employing video conference and audio conference technology to accommodate for pandemic-era challenges. We equip our courts to handle similar challenges that may arise in the future. Furthermore, we improve all Canadians' access to justice. This bill will not change the principle that all persons involved in the criminal justice process must physically appear in person unless otherwise authorized under the criminal code. Madam Speaker, I think maybe one of the soccer games is on. Courts will still have discretion in this area. This bill ensures the judicial process is not unduly stalled by permitting remote conference options under extenuating circumstances. Canadians deserve a justice system that is accessible, efficient, and effective, and yes, provides true access to justice for all. The pandemic has taught us that technology can help make the justice system work better for all people who come into contact with it. Bill S4 proposes a range of reforms that will make court proceedings more flexible while protecting the rights of all participants. The reforms proposed in S4 flow from the important work of the Action Committee on Court Operations in response to COVID-19, co-chaired by the Minister of Justice and Chief Justice Richard Wagner. They are also informed by important contributions from the provinces and territories, as well as other justice system stakeholders. With S4, we have the opportunity to improve our justice system by making those good ideas permanent. Since March 2020, the Minister of Justice and the Attorney General of Canada has engaged regularly on the impacts of the pandemic on criminal courts with provincial and territorial ministers responsible for justice and public safety. The proposed amendments take into consideration input received from provinces and territories and other key stakeholders. In addition, the Minister of Justice and Attorney General of Canada has continued to be kept appraised of the challenges faced by courts across Canada in his role as co-chair of the Action Committee on Court Operations in response to COVID-19. These discussions have all informed the proposed changes introduced in this bill, Madam Speaker. Madam Speaker, a more efficient justice system will benefit all Canadians. I ask that all members of this House support the quick passage of this bill. I believe this bill, S4, helps transform and modernize our criminal justice system while ensuring respect for all persons involved in the criminal court process, including accused persons and prospective jurors. I am confident that Bill S4 and the proposed reforms will improve our criminal justice system while facilitating careful oversight by the courts to ensure that the rights of accused persons and offenders are protected, Madam Speaker. Madam Speaker, as I started off my comments on Bill S4, the gist of this bill, the main purpose, is that Canadians deserve a justice system that is accessible, efficient, and effective, and provides access to justice for all. Thank you, Madam Speaker, for allowing me the time to speak on a very important bill for all Canadians. Thank you.
Questions et commentaires. Questions and comments. The Honourable Member for Langley Eldergrove.
Good. I would like to thank my honourable colleague for a well-informed and researched speech on Bill S4. My question relates to Jordan's principle, the requirement that people in Indigenous communities receive justice in a fair and equitable manner. And I wonder if my colleague could comment on whether S4 adequately addresses that.
For Vaughan Woodbridge.
I thank the honourable member for a very informed question on Jordan's principles with regards to our justice system. I am not a lawyer myself, Madam Speaker, so I will try to answer this question to the best of my ability. What I will say is that the Minister of Justice and Attorney General obviously is working very closely with Indigenous communities and consulting with Indigenous stakeholders to ensure that we have a nation-to-nation relationship when it comes to reforms within our justice system, to move forward with reforms in our justice system, much like we did on Bill C5, that where there are negative impacts on Indigenous individuals, for example, the overrepresentation of Indigenous individuals in the Canadian jails, that measures are taken to correct that, to ensure that there are not systemic barriers within our criminal justice system that impact Indigenous communities here. Thank you, Madam Speaker.
Questions and comments. Questions et commentaires. L'honorable.
The honourable member for Abitibi, Beijing's Nunavut EU. Thank you, Madam Speaker. I'd like to thank my colleague for his speech. I have to say that there are always improvements that can be made to S4. So what does the honourable member think about the issue of connectivity, internet connectivity? We know that this issue was brought up by my colleague earlier. And there's also the question of vacancies on the bench. So I'd like to hear my honourable colleague's solutions to those issues. The honourable member for Vaughan Woodbridge.
Thank you, Madam Speaker. Je vous remercie.
I'd like to thank my colleague for her question. It's a very important question for this bill.
What I would say on the connectivity issue, obviously our government is working in a collaborative fashion with the provinces, putting funds forward to ensure that all Canadians are connected to the internet. And if the opportunity arises via Bill S4 for criminal justice system procedures or cases to occur in a manner where audio conferencing or video conferencing can take place and provides for an effective, efficient, and accessible criminal justice system, that we continue to do that in a very expeditious manner. Thank you, Madam Speaker.
The honourable member for Nanaimo Ladysmith.
Thank you, Madam Speaker, and thank you to the member. I'm happy to see Bill C4 coming forward today to begin the much overdue work of modernizing Canada's judicial system. We know that the government has known about these needs and a much required overhaul since before the Liberals first took office from the previous Harper government. I was speaking to a constituent just yesterday here in my riding of Nanaimo Ladysmith who expressed to me she had to apply to be excused from jury duty due to the costs associated with it. And I'm wondering if the member could clarify why the government had to wait for almost a full year before bringing this legislation forward, which is essentially a carbon copy of a bill first introduced in the last Parliament before the House, maintaining existing systems with backlogs and barriers for jurors.
Honourable member for Vaughan Woodbridge.
I thank the honourable member for Nanaimo Ladysmith for their question with regards to the introduction of this bill. There's obviously a legislative calendar we need to bring forth on the days allotted for that. And I'm glad to see this bill has been brought forth to this Parliament and this House to be debated by all members, and hopefully quickly sent to committee and to follow the regular process so we can enact another piece of legislation that modernizes our criminal justice system here in Canada. We all agree that this needs to occur. We all agree that Canadians need to have access to the criminal justice system, that it has to be accessible, efficient, and effective, and this is another step in that direction. Thank you, Madam Speaker.
Resuming debate, the honourable member for Langley Aldergrove.
Well, thank you, Madam Speaker. To start off, I wish to notify you that I will be sharing my time with my colleague, the member for Haliburton, Kawartha Lakes, and Brock.
That's a good choice.
I got the name right. Thank you. Madam Speaker, the pandemic taught us many things about how viruses spread or how they don't spread, whether asymptomatic victims of a virus can be contagious, whether vaccines prevent us from being infected or only preventing us from being very sick when we are infected. It also taught us what effects isolation has on mental health. The jury is out on many of these issues. People will be writing PhD theses on the lessons we learned or failed to learn from the COVID-19 experience. But it's not just medical and scientific things that we've learned through the COVID-19 years. We also learned that we can do business differently. More and more people are working remotely, and that kept many businesses afloat during the most severe periods of lockdown and restrictions. Admittedly, remote access, working remotely, works better in some sectors than others. In my profession of law, for example, working from home or from the office was completely seamless, or working from the cabin for that matter. My clients didn't typically ask me where I was as long as I was serving them. My clients didn't tell me where they were. I didn't ask, they didn't tell me, it didn't matter in most instances. I remember after a lengthy conversation with a client, one morning I suggested that we meet for lunch that afternoon. He said, well, it's a 5-hour flight from Hawaii where I am, so that would be difficult to do. I didn't know, it didn't matter. Business is seamless in some sectors. Now, this was before the pandemic. The pandemic has just accelerated the need for us to become more and more digital in the way we do business. And that's why we're here today. We're looking at draft legislation that originated in the Senate, Bill S4, an act to amend the criminal code to allow for the use of electronic means to select, for example, to select a jury, and to allow jurors to participate in hearings via video conferencing. It would allow us to expand the availability of remote appearances by video conferences and or audio conference. And it will modify case management rules, fingerprinting procedures, and issuing of warrants, such as search warrants, just for example. It's a long, exhaustive list of what this bill is going to reform in our judicial system. All of this was born out of the pandemic. None of this is novel. Very little of this is controversial. Conservatives have always supported finding new and innovative ways for government operations to be more efficient and more cost-effective. But we must raise some concerns. For video conferencing to be effective, it must be reliable. We've seen even here in the nation's capital, here in Ottawa, where you think that the internet would be world class, that hybrid meetings often get interrupted because a participant in the meeting, perhaps a witness at a committee, gets frozen, or the audio is so bad that our highly qualified professional interpretation teams can't make out what is being said. It's one thing if a parliamentary or a Senate committee is being disrupted because of technological differences, but it is quite another when it is a criminal trial, when a person's rights and freedoms and liberties are at stake. We must get it right. And that brings me to reflect on a big challenge that we have in Canada, particularly in some parts of this vast country, and that is internet connectivity. Canada's Conservatives have been calling for an end to the digital divide between urban and rural areas in our country. Every aspect of our 21st century economy is becoming increasingly dependent on the internet. Therefore, we must ensure that everyone has access to good, reliable broadband. Canada's productivity metrics lag those of our main competitor nations, our trading partners. For every $100, for example, that an American worker pumps into the economy, their Canadian counterpart contributes only $67. That's a big productivity gap. Our Minister of Finance has acknowledged that gap, and on several occasions, she called it our Achilles heel. In the recent fall economic statement, this is what she said. Quote, "We will continue to invest in tackling the productivity challenges that is Canada's Achilles heel." Close quote. Now, earlier in the year, in delivering her budget, the Minister of Finance had this to say about Canada's lagging productivity. Quote, "We are falling behind when it comes to economic productivity. This is a well-known Canadian problem. It is an insidious one. It is time for Canada to tackle it." Close quote. I couldn't agree with that more. It's time for us to tackle our productivity lag. And a good place to start would be to vastly improve our internet accessibility, not only in here in Ottawa, not only in my community of Langley, where it is far from perfect in some areas, but across the country, and particularly in remote areas. Talk to any worker, any tradesperson, any healthcare workers, professionals, truck drivers, teachers. They will all tell you that the best way to improve productivity is to get better tools, and the internet is everyone's tool these days. The legal profession, our criminal justice system, and for our courts. There's nothing special about our courts. They need to conduct business like everyone else. So back to Bill S4, an act to amend the Canadian Criminal Code. To improve efficiency in our courts, we want to make them move them towards greater use of electronic tools in jury selection, in jury participation, in witness appearances, in the appearances of the accused even, when the accused and the Crown both agree. We support these measures, but we must listen to the experts. In her May 2021 report to the Standing Committee, our former federal ombudsman for victims of crime, Miss Heidi Illingworth, had this to say on this specific topic. Many courthouses across the country, she said, have old infrastructure, and implementing video conferencing has been a challenge. For some in remote areas, bandwidth and internet access remains an issue. Now, Ms. Illingworth was saying this in a study being conducted by the Justice Committee on formerly Bill C-23. Bill S-4 is almost a mirror image of it. Bill C-23 had the support of all parties, but it got bogged down because this government called an election that nobody wanted. That wasn't necessary. That's for another day. Ms. Illingworth had this to say in support of increasing the availability of technology. She said, "It is my hope that these measures will help to relieve the pressures on the courts by leveraging video and teleconferencing technologies to help speed up filings and hold hearings in an inclusive and efficient way." Now, she was the ombudsman for victims of crime, and in that capacity, she had this to say in support of victims. Quote, "Ensuring access to internet services across Canada would address concerns regarding access to justice for victims of crime during COVID-19. That's when she was giving this evidence. By ensuring that victims have a means to participate in the process should they so choose." But she also, close quote. Now, she also warned, quote, "Unfortunately, not all Canadians have equal access to the internet," close quote. Now, Speaker, I'm hearing from many people in my home province of British Columbia about how important good access to the internet is for Pacific economic development, something I have a great deal of interest in. But that too is for another day. Today I'm speaking in support of improving access to justice through Bill S3. It is a step in the right direction. We will be supporting it. I look forward to a deeper dive into the details of Bill S4 at committee. And I welcome any questions.
Questions and comments. Questions et commentaires. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Madam Speaker. I appreciate many of the words that the members put on the record with regards to S4. I don't necessarily agree with everything, but some of it anyway. Madam Speaker, S4, and we've had a fairly good discussion on it today, as I believe a vast majority, if not all members, will be voting in favor of the legislation going into committee. And I consistently have made reference to the fact that this is legislation that's here before us today because of provincial input and the fact that we're going through COVID, which really clearly demonstrates the importance of recognizing technological change and how that change can actually assist us in the judicial system. But it is important for us to recognize, and I guess this is where my question would go to, is in regards to the issue of judicial independence. And that's why it's really encouraging when you pass legislation like this, because of the direct impact. It's always good when you get that wherever possible, where you see the unanimous support, as we saw, for example, with Rona Ambrose's private member's bill, which ultimately became a government's bill. And I'm wondering if he could just provide his thoughts in regards to the importance of judicial independence.
For Langley Aldergrove.
Well, judicial independence is core to our judicial system, our Western judicial system. It is core to our whole democratic system. It is core to every part of our society. So, of course, we support it. We need to do everything that we can to make sure that our judiciary remains independent, particularly from Parliament, particularly from politicians. We appoint judges because we trust judges are going to make wise decisions. But there still has to be some oversight. That was not the subject of this bill today, but previous debates in this House just last week or earlier this week was on the Canadian Judicial Council. Judging judges. It needs to be done properly, and there needs to be lay input, but bottom line is politicians, hands off.
Questions and comments. Questions et commentaires. L'honorable.
The Honourable Member for Saint Jean. Thank you, Madam Speaker. I thank my colleague for his speech. I'd like to hear what he would say about a situation that could be the consequence of S4, since there's a lack of judges, but also courtrooms, clerks, public servants, constables. So there could be a point where there's a hearing date that's earlier if you decide to use video conference, when it would take longer to have a hearing date if you chose to go in person. So ultimately that could put pressure on people to do things by video conference, even if they would prefer to have an in-person hearing.
The Honourable Member for Langley Aldergrove.
Well, yeah, that's a great question, Madam Speaker. I believe that that S4, if properly, the reforms under S4, if properly implemented, will have the overall effect of speeding up the judicial system. increasing accessibility to the justice system, particularly for remote communities. And I believe that, all in all, it is a big improvement. But points is well taken that there have been a lot of delays. There's been an increase in crime, unfortunately, as we've heard from other speakers on this topic. So the best way, of course, to speed up the judicial system is to not only have more judges, to improve our technology, but also to bring crime levels down. Not an easy solution to that, of course, but that must be part of the solution.
The honourable member for Victoria.
Thank you, Madam Speaker, and I want to thank the member for his speech. This bill does take a number of positive steps, but I was curious why the government left out the recommendation from the Justice Committee's report on access to justice and legal aid. It called on the federal government to replace the legal aid funds currently included in the Canada Social Transfer with a specific earmarked legal aid fund for provinces administered under the Department of Justice Canada Legal Aid Program. This would help with backlogs and access to justice. So to the member, through you, Madam Speaker, does the member support this recommendation, and does he agree that the government should have included this in S4?
The honourable member for Langley Aldergrove in 15 seconds or less.
Well, that's a great question. I'd like to thank my colleague from Victoria for that question. I don't know the details of that proposal, but I can just tell you generally that I'm very supportive of more funding for legal aid. I was a lawyer in British Columbia where legal aid was underfunded. It is so important to speed up the judicial process and to make sure that justice is accessible by all people. Thank you.
Resuming debate, the honourable member for Haliburton, Kawartha Lakes, Brock.
Thank you, Speaker. I rise today to speak to Bill S4, an act to amend the Criminal Code and the Identification of Criminals Act and to make other related amendments. And while I have much to say on this bill, I want to briefly talk about some of the failures of this government on crime in general and crime specifically. Rural crime, Speaker, is a serious issue and one that has been ignored by this government for far too long. In my area, in Haliburton County, for example, incidents have increased from 526 back in 2017 to now 758 in 2021. Police are now trying to keep up with more people charged than in any of the previous 4 years. The Crime Severity Index, or the CSI, is a measure of police-reported crime in which more serious crimes are given a higher weight in the overall measurement of all crimes. That index provides a picture of regional crime trends. In this case, in Kawartha Lakes, specifically in Lindsay, the picture is not as good. Like Haliburton County, the CSI numbers for Lindsay in 2021 showed a significant increase compared to previous years. Lindsay's overall CSI was 93.1 last year. That's a jump of more than 20% over 2020 and significantly higher than the country's CSI of 73.7 and nearly double the province's CSI of 56.21 for the same period. Kawartha Lakes Police Chief Mark Mitchell described the increase as, quote, death by 1,000 cuts, end quote, referring to the lack of murders, but an overall increase in other nonviolent crimes. He further added, quote, our calls for service were up 20% in 2021. Our criminal charges were up 25%. Break-and-enters, frauds were all significantly higher, and their theft charges were up 80% compared to the year before and the current year. I've spoken with residents, Speaker, who are afraid to walk in their community. They are afraid to basically be inside their own homes. They're frustrated and angry. These concerns came to a boiling point about a year ago at a community meeting I attended that was hosted by the Kawartha Lakes Police Service. At the meeting, residents learned that the Ross Memorial Hospital's mental health program has already received roughly 1,700 referrals just this year. Concerns were raised about the impacts the Central East Correctional Centre is having on the community. The John Howard Society noted the challenge given the number of those who have come to the area to support the incarcerated and those who are released into the community on their own recognizance, bail, or after completing their sentence. The Kawartha Lakes Police Service, Speaker, are doing everything they can, but this government sadly is making their jobs harder. While it was distressing to hear the first-hand stories shared by many in attendance, it was evidence to me that Canada's justice system has failed those law-abiding citizens. Lindsay resident Al Hussey raised concerns about the victims of crime, asking, when does the support start flowing to us? Again, meaning the victims of crime, Speaker. The residents living next to known drug houses, the business and property owners who are being robbed, the people afraid to walk near certain areas of town, end quote. It's true that a small number of people are creating a disproportionate amount of work for our law enforcement agencies, the court system, social services, and not-for-profit organizations. However, those who continually refuse help and continue to reoffend should not be repeatedly returned to the streets in a revolving door justice system. A big part of this is linked to the passage of Bill C-75. You see, in 2017, the Liberal government's legislation watered down penalties for over 100 serious crimes, including the use of date-rape drugs, human trafficking, and impaired driving causing bodily harm. Sadly, Speaker, they severely underestimated the heartbreaking impact this decision would have on individuals, communities, and families. It is unacceptable that taxpayers are once again being forced to pay more while at the same time receiving a lower quality of life. Police officers I speak with say that Bill C-75 is the root of much of the issue regarding the catch and release bail concepts through the latter principle. It's a principle, Speaker, that instructs justice system actors to release the accused at the earliest opportunity under the least restrictive conditions. I firmly believe, Speaker, that serious crimes deserve serious penalties. Most importantly, the law should always put the rights of victims and law-abiding citizens above dangerous or re-offending criminals. It's clear that Bill C-75 has hurt our community. To that end, I recognize that federal lawmakers must make bold changes to our criminal justice system. New methods, such as restorative justice, should be expanded, especially for those that show a desire to be rehabilitated and released as productive members of our society. This brings me to S4, and it may come as no surprise to anyone listening that the first thing I looked at was how far will this impact crime in the communities I represent, and how will this impact those victims of crimes? The impetus for this bill is born from the increasing backlog facing the court system here in Canada, and I believe we all have stories about that. The judicial system has been facing a series of delays in cases proceeding to trial, which has been exacerbated by COVID. This is not lost on us here in the official opposition, who have continuously raised concerns about the delays and the potential for criminals to walk free due to the Supreme Court's Jordan decision, which said no more than 18 months can pass between laying a charge and the end of the trial cases in provincial courts, or 30 months for cases in superior courts. We've raised our concerns in the House and in the media, and it was Conservatives who called for a study into the impacts of COVID-19 on the judicial system at the Standing Committee on Justice and Human Rights. Now, S4 hopes to alleviate this backlog through several initiatives. S4 will amend the process for peace officers to obtain warrants without appearing in person, expands the provisions to fingerprint the accused later should fingerprints not previously have been taken at the time of arrest, and to allow the courts to deal with administrative matters for accused not represented by lawyers. Of these provisions, I have no issue. Anything to move the process along that doesn't diminish the rights of the accused persons or victims or brings justice system into disrepute is a good thing. I expect that these initiatives will be thoroughly examined at committee and perhaps even acted on. However, I do have concerns, perhaps cautions are a better word, with the remaining provisions in the legislation, particularly around the expansion of the accused's ability to appear remotely by audio or video conference and to allow the participation of prospective jurors in the jury selection process by video conference. I would caution the members at committee to pay particular attention to the rights of victims and those citizens who are doing their duty as jurors. We must ensure that the anonymity of anonymity of jurors is protected, if I could get my tongue untied. Technology has come a long way, and the risk that recognition software might compromise jurors and the risk to the integrity of the trial is a real concern. We must also take into consideration the impact of expansion of telecommunication options, particularly allowing the accused persons to call in using a phone that may impact the healing process for victims and their families. The bill will permit an offender to appear remotely for sentencing purposes. This measure would require the consent of the criminal and prosecutor. The courts would also weigh the rights of the offender to have a fair public hearing. Nowhere, Speaker, is the victim asked or required to consent to the offender being allowed to call in for his or her sentence. The balance of rights in the court process is already heavily weighted in favor of the accused, and I'm afraid S4 tips the scales even further, which actually reminds me of another failure of this government, the delay in the filling of long vacancies, such as the federal ombudsman for victims of crime. Without that person in place, S4 will not be critically analyzed by a key advocate for victims to advise on how this bill will impact victims of crime. Conservatives remain steadfast in our commitment to victims of crime and ensure that legislation like S4 helps victims and their families in their pursuit of justice. We will stand up, Speaker, for law-abiding Canadians to ensure communities remain safe places to live and that delays in the court process do not allow criminals to walk free. And with that, Speaker, I look forward to the questions from my colleagues. Thank you.
Questions and comments. The Honourable Parliamentary Secretary to the Government House Leader.
Madam Speaker, if I can give a quick example. A number of Conservatives actually stood up and talked about the issue of the crime stats. And, it brought me back to the day in which I was inside the Manitoba legislature, and I raised the question, and Stephen Harper was the Prime Minister at the time, in terms of just record numbers of car thefts. Manitoba is way above every other province in the country. I think it was a normal year you had to get like 3,000. This particular year it was at 14,000. Huge increase. And what we found out is that it is a relatively small number of youth that was actually stealing a whole lot of cars. And what ended up happening is we recognized that the judicial independence is important, but it's also something that's shared in terms of responsibilities between province and the federal government, and our municipal governments also play a role. So the question is just to recognize that in dealing with crime on that particular issue, once the province and the city got together and they developed a plan, they were able to, along with MPI, Manitoba Public Insurance, they were able to drive down the number of car thefts for the following years. Proved to be very effective. I'm wondering if he could provide his thoughts in terms of when you talk about criminal stats, you have to incorporate other jurisdictions in order to deal with it.
The Honourable Member for Haliburton, Kawartha Lakes Brock.
Thank you very much, Speaker, and I appreciate the question from the member opposite. And yes, I do accept the fact that there are a number of contributing factors. I also agree with the member that in most cases, especially in the cases I laid out in my speech in my community, it is definitely a small amount of people doing a disproportionate amount of these crimes. And I think at the end of the day, whether you're a victim of crime, whether you're just a law-abiding citizen that likes to feel safe in your community, we do like to see that those people, those repeat offenders, especially those repeat violent offenders, are not continually rotated back into our community, causing this kind of frustration, like I said in my speech about that community meeting, where people were sick and tired of being re-victimized over and over again. So I think there are ways organizations can work together. The member opposite laid out a few. I have a few instances in my community where not-for-profits come together, work together to try to help people and rehabilitate those that want the help. But also we do need to look at all facets of it, and I urge the committee that's going to study S4 to do that.
The Honourable Member for Saint Jean. Thank you, Madam Speaker. Thank you. Our colleague talked about increasing efficiency of the courts, being able to deal with more cases, but a question that often comes up in the House is mandatory minimums, and there were more of them in the past. So the Crown and the defense, sometimes they don't reach an agreement because the suggestion would be below a mandatory minimum, which forces the parties to go to trial and increases congestion of the courts. Is that a reality? My colleague accepts that there's also that contributes to clogging up the courts.
Member for Halliburton, Kawartha Lakes Brook.
Thank you very much, Madam Speaker. I appreciate the question from my Bloc colleague. I know she is a lawyer in the previous life, and I appreciate her input in the discussion today. I think looking at as many ways as possible to speed up the judicial system for victims, for those awaiting trial to either be convicted or cleared, and a whole bunch of other cases in between, I think is something that should be examined. And I think we have seen massive backlogs, as I mentioned in my speech, COVID being a major contributor, but even before COVID, the backlog in the court system was quite significant, and issues has been raised about that. So I think there is an opportunity here to have that conversation about what can be done to speed it up, and I look forward to that discussion in the, I guess, weeks ahead.
Questions and comments? The Honourable Member for Churchill, Kawatinukasky.
Thank you very much. And I just want to recognize that those of us that represent rural and northern areas, the ability for people to access the justice system as well as other systems remotely is a very serious matter. And I'm wondering, do the Conservatives agree that Canadians living in remote and rural areas should have access to the same availability of serving jury remotely as urban Canadians do to make jury selection? How important is it for them? How important is it, period, in their view, to make jury selection and access as fair as possible, and particularly for rural and remote communities?
The Honourable Member for Halliburton, Kawartha Lakes Brock, a very short answer.
Thank you very much, Speaker. I appreciate the question from my NDP colleague. I think there are a number of challenges with rural communities. I live in one, and I represent a rural community, and I know the challenges. There are challenges related to connectivity, but as I mentioned in my speech, there needs to be protection for those applying to be a juror. There are concerns around hacking or facial recognition software that can be used to identify. So all those considerations need to be taken into effect. Thank you, Speaker.
Resuming debate, the Honourable Member for Renfrew, Nipissing, Pembroke.
Madam Speaker, and I'll be splitting my time with the member for Edmonton Manning. I begin my comments regarding Bill S4 by acknowledging the hardworking and law-abiding citizens of my riding in Renfrew, Nipissing, Pembroke. During these challenging economic times and the troubling revelations Canadians are hearing every day in testimony from the Emergencies Act trial, Canadians in my riding and across the country know I'll always defend whomever the target for this week's 2 minutes of hate from a Prime Minister who likes to make fun of other cultures by mocking them in their native attire and wearing blackface. Why is it that whenever the Liberal Party brings forth legislation to change criminal laws or the administration of justice, it's always about protecting criminals, never about the victims or their families? It's failing victims. The system is failing everyone. It's failing victims, it's failing the accused, it's failing everyone who's working in it. We have a situation where the public lacks faith in the justice system, and that's what we're beginning to see happen. There's even a call for the Liberal-appointed head of the RCMP to resign. People have lost trust in our public institutions. Everything our government touches, it breaks. Everything is broken. S4 is about technology. Knowing how this government thinks, could Judge Dredd be far behind? The fact is, technology is not a quick fix for what ails the criminal justice system in Canada. The government has all the wrong priorities. For once, this government needs to think about the victims of criminal justice. Someone has to speak for the victims. Earlier this year, a coroner's inquest was concluded into one of the worst cases of multiple partner violence in Canadian history. Basil Borutsky murdered Anastasia Kuzik, Natalie Wormerdam, and Carol Culleton in separate incidents on the morning of September 22, 2015 in Renfrew County. Baruski was well known to all of his victims and to police for a long history of violence. He was a dangerous serial offender with a history of beating women. The three grieving families and our entire community relived the horror of that event through the inquest. Baruski went on a violent rampage in the Ottawa Valley on that day, and he murdered three women: Carol Culleton, Natalie Warmerdam, and Anastasia Kuzyk. In their verdict, the jurors determined that Culleton, Warmerdam, and Kuzyk all died by homicide. Carol Culleton's death was upper airway obstruction, which is a polite way of saying she was choked to death, while Anastasia Kuzyk and Natalie Warmerdam both died of shotgun wounds to the chest and neck. And the violence didn't happen without a warning. All the women were former intimate partners of Baruski, and the murders were a culmination of abusive behavior that had been happening for over 40 years. He was sentenced to life in prison with no eligibility of parole for 70 years. Multiple sentences to be served concurrently for the multiple murders he committed. So prior to the law passed by our Conservative government, the maximum sentence for first-degree murder, even when multiple victims were killed, was a life term with no chance of parole for 25 years. The Conservative government law that I was pleased to vote in favor of allowed for parole terms to be stacked on top of one another in cases involving multiple victims. Serial mass murders like Basil Baruski is an example of a sentence that takes into consideration the severity of the crime. The Supreme Court has since ruled no more multiple sentences. On Alexander Bissonnette, the Quebec City mosque shooter, who was initially sentenced to 40 years for the murder of 6 people, had that sentence struck down on appeal. The Supreme Court upheld the appeal and ruled that sentences of that length are cruel and unusual and violate the Charter of Rights and Freedoms. Now, unless the Liberal government brings in new legislation, the court's ruling will mean the maximum sentence for a person can receive for first-degree murder, even in cases of multiple murders, is life with no chance of parole for 25 years. When women are killed because they are women, that's different than first-degree murder, second-degree murder, manslaughter, or the general term homicide. It sends the wrong message to the courts. In the case of serial killer Basil Baruski, a violent offender who openly ignored orders that were part of his probation, he was released anyhow. Bill C-5 is a slap in the face to every woman in Canada by a prime minister who's consumed by his own toxic masculinity. By reducing or eliminating mandatory minimum sentences, a downward pressure on all sentences is exerted, especially in circumstances in which supposedly determinate periods of imprisonment are routinely reduced, halved, or more by early release. If a man such as Baruski is released early after a triple murder, what sentence will a mere murder receive? So what's all this mean to the people of Renfrew, Nipissing, Pembroke? In the case of C5, which was brought to the House instead of the Senate, like S4, Bill C5 is a radical left-wing bill that would eliminate mandatory minimum penalties. It sends the wrong message to the community and the families of Carol Culleton, Natalie Warmerdam, and Anastasia Kuzyk, and women who live in fear of domestic violence.
Well, member for Kitchener Centre on a point of order.
Madam Speaker, I've been listening attentively to the speech from the member. I'm hearing her talk of Bill C5, mandatory minimum penalties. I don't believe any of that is relevant to Bill S4. And I'm wondering your thoughts on the relevancy of the speech. Thank you.
The member well knows that there is quite a bit of latitude on how the member has made some references to S4. I will hope that in the 3.5 minutes left of her speech, the member will come back to the subject at hand. Thank you.
So there's a recommendation from the inquest to the federal government to explore adding the term femicide to the criminal code. So what did Canadians get? C5 and S4, okay? And S4 was so important to this government that it's come before us several times, and they just let it lapse on the order paper. Barutsky, the Eastern Ontario man who was sentenced to life with no chance of parole for 70 years for killing 3 women in 2015, can now challenge his sentence due to the Supreme Court ruling. S4 isn't going to fix that. Even if he's not granted parole, his victims and families are forced to relive the crime and loss of their loved ones at regular parole hearings after the 25-year mark. Real justice calls for changes that would prevent such a tragedy from happening again. And tinkering with the system by allowing Zoom into a courtroom is no joke to the victims' families, and that's what S4 is doing. The coroner's inquest into the deaths of Carol Culleton, Natalie Warmerdam, and Anastasia Kuzik wrapped up after hearing extensive testimony from victims' families, their counsel, domestic violence experts, and advocates. And the jury made 86 recommendations based on the inquest, and it's important to know about them, since part of the accountability is awareness. Our awareness and demanding that our public institutions do the right thing to prevent intimate partner violence, IPV, and S4 tinkers with the administration of the court system. It's time to be more cognizant of what is causing the problems. And the first set of recommendations address the need for oversight and accountability. And these initial recommendations recognize the importance of listening to and learning from victims, survivors, and emphasize the need to follow up on implementation and create a survivor advocate position. Understanding that domestic violence victims' experiences with police and the justice system can be really difficult. And the jury recommended having a survivor advocate to advocate on behalf of survivors when they interact with the justice system. They wanted to establish an independent partner violence commission. The jury wants a commission to be established like the one in the UK that can be a voice for survivors and the victims' families. Local activists agree that an independent commission would help ensure the inquest recommendations are followed through and engage in meaningful consultation by speaking with intimate partner violence survivors, victims, their families, experts in the fields. These consultations would determine the responsibilities and direction of the IPV Commission and evaluate the effectiveness of existing community supports and prevention strategies, including program funding. So I will conclude my remarks by thanking all of those who were involved in the inquest process, including the witnesses who gave so generously of their time, along with the women from the anti-violence community in Renfrew County and beyond. Thank you, Madam Speaker.
Questions and comments. L'honorable député de Saint-Jean.
Thank you very much, Madam Speaker. I sit with my colleague on the National Defense Committee. She spoke about victims, and she spoke about the fact that they are often witnesses. But one of the good things in S4 means that delays might go down before trials are heard, which means that victims might not have to wait as long before there's a result in their case. Would she recognize that at least that is a step in the right direction for victims?
For Pembroke, Nipissing,
Thank you. Thank you, Madam Speaker, and I appreciate the question from my colleague. But the courts are clogged up because the Liberal-appointed activist judges keep letting murderers and rapists, pedophiles out early, if they even get sentenced to prison at all. That's the reason for the backlogs.
The Honourable Member for Skeena Buckley Valley.
Well, thank you, Madam Speaker. I share my colleague across the way's dismay at how little of that speech we just heard dealt with the actual content of Bill S4. But perhaps I'll ask a question about one of the opening statements, which was, it's always about protecting criminals, never victims. And this is particularly ironic because resolving backlogs and ensuring the timely carriage of justice, the topic of Bill S4, is very much in the interest of the victims of crime that the member seems so concerned about. Would she not agree? And perhaps she could take 30 seconds to just breeze through where she stands on the content of this bill. Thank you.
Honourable Member for Renfrew-Nipissing Pembroke.
Right. Well, the content of the bill isn't going to do anything for the victims of crime. And it's the constant revolving door of the criminals through the justice system, the repeat offenders who come in time after time, and then the government coming down and cracking down on lawful people, like lawful firearms owners. Every time there's another mass shooting or even one shooting, when really we find out that statistically, since they've been cracking down on lawful firearms owners, murders, shootings actually have gone up. And there was a Stats Canada report on this huge increase in shootings the very day they announced another crackdown on lawful firearms owners.
And comments, questions et commentaires. The Honourable Member for Kelowna Lake Country.
Thank you, Madam Speaker, and I thank my honourable colleague for her intervention today. She spoke a lot about the revolving door situation in our criminal justice system, and of course I have my private member's bill, which is called End the Revolving Door Act, which has to do with getting people who are sentenced in federal penitentiaries, addiction treatment and recovery. And I'm wondering if she can maybe speak on that, just how that is one piece that might be helpful to people to help end the revolving door.
Well, Member for Renfrew-Nipissing Pembroke.
Well, actually, Madam Speaker, I do know of people who want to have drug treatment but who can't get into a treatment facility, who actually commit crimes because that's the only way they can get access to the treatment. So instead of funneling tons of money to these harm reduction centers, we need to find a way to get more treatment to people who aren't breaking the law. And I must say that the bill my honourable colleague has put forth through private members' business is certainly more meaningful and will have more impact on people's lives and prevent the crimes from happening in the first place if they receive the treatment. And it's certainly more effective than S4. So I wish that came first.
Order. It is my duty pursuant to Standing Order 38 to inform the House that the questions to be raised tonight at the time of adjournment are as follows. The Honourable Member for Haldimand Norfolk, Infrastructure, the Honourable Member for Calgary Centre, Taxation, and the Honourable Member for Bruce Grey Owen Sound, Taxation. Resuming debate, the Honourable Member for Edmonton Manning.
Thank you. Thanks, Madam Speaker. Madam Speaker, I'm pleased to rise today to speak on the Bill C4, an act to amend the Criminal Code and the Identification of Criminals Act and to make related amendments to other acts such as COVID-19 response and other measures. The judicial system has been facing a series of delays in cases proceeding to trial, which has been made worse by the COVID-19 pandemic. Conservatives have raised concerns about the delays in the potential for criminals to walk free due to the Supreme Court Jordan's decision, which said no more than 18 months can pass between the laying of a charge and the end of a trial cases in provincial courts, or 30 months for cases in superior courts. We have raised our concerns over the delays in the judicial system a number of times over the pandemic in this House and through the media. So, it is good that the Liberals are finally listening. I understand that sometimes they have different priorities. The court system scrambled to adapt and learn how to function during the pandemic, and it was obvious changes were needed. I could have made this speech at the height of the pandemic, when the need was very, very urgent. The government recognized the need then and introduced Bill C-23, but it obviously wasn't a priority. That bill died on order paper when the House was dissolved, if by the Liberals for their unnecessary election. However, as with many efforts by this government, I suppose we can consider it to be better late than ever, though it seems sometimes that on truly pressing issues such as inflation, for the Liberals to do anything, it is more never than late. It is indeed important to support the courts in the technological transition that has been simulated by the COVID-19 pandemic. It is also important to be as prepared as possible for future pandemic or similar disruptions. In the past 2 years, we have all discovered new ways of doing business. Some of those ways have been beneficial, others arguably not as much. So too with this bill. For justice to be truly done, it must be seen to be done. Any citizens have the right to attend court and observe the proceedings. In the past, that has naturally been a right that could be limited by the physical space of the courtroom. Allowing virtual proceedings changes that limitation, while bringing with the issue of controlling the dissemination of images from the proceedings. We have gone from cameras not being allowed into the courtroom to everyone having the ability to take screenshots or even videos of the proceedings. There is no doubt that COVID-19 pandemic has been felt throughout our criminal justice system. Problems that perhaps we didn't realize have been brought into focus. Modernization of system is long overdue. The pandemic has shown us that action is very necessary now. With the technological tools that now available to us, it makes sense as this bill does, to allow peace officers to apply for and obtain a warrant using telecommunications rather than having to appear in person before a judge. This doesn't take away from the necessity of the officer to answer any questions as to whether the warrant is really necessary. The legal necessities don't change, but there is a savings to the taxpayer and the environment in the officer not having to drive to appear before a judge. We are all aware that the criminal justice system has been subject to delays in proceedings, sometimes, or something that has been exacerbated by the pandemic. While justice delayed is justice denied. No one wants to see a criminal walk free because the system couldn't bring them to trial fast enough. The reforms suggested in this bill are small but incremental. It is important to remember that the fundamentals of justice are still being observed. That increased use of teleconferencing in the courts does not take away from an accused their fundamental rights to appear in person. But many, given the choice, might prefer to appear by video conference, which incidentally could reduce their legal fees since their lawyer won't have to be with them at the courthouse waiting for their case to be called. One thing that does concern me with these reforms is the issue of fairness, and I'm not sure how the government can address that. Appearing by video in court proceedings required access to technology that at this point is not available to every Canadian. Not everyone has the financial resources to own computers. Not everyone has high-speed internet access available to them. Certainly, this government doesn't have the resources to provide that. At the same time, I recognize that there are other different burdens that come with having to make a court appearance in person. That can bring with it the expense and hardship of travel. I'm not certain how we can provide equal access to the justice system for all Canadians, but I know we have to try to keep improving the system until we get it right. One area in which I have serious concerns is the proposal in this bill that would allow the jury selection process to be done by video conference in some circumstances. While this would certainly make it less onerous for prospective jurors who could take part in the selection process from their homes or workplaces, it does raise some privacy concerns. While technology makes remote appearances possible, Technology could also be used to subvert the process. Not to mention the right of an accused to see those who are to pass judgment on his or her case. In Canada, an accused has a right to be tried by a jury of his or her peers, but there are times when, for security reasons, the jurors are anonymous. With the availability of facial recognition software, it is easy to imagine that a prospective juror appearing by video conference could be easily identified. This could leave them open to harassment or attempts to influence the jury's decision. That may sound unlikely, but if we are concerned for the administration of justice, it must be considered, has the government considered how to deal with this issue. This bill is not perfect, but neither is our justice system. The question we are, as parliamentarians, must ask ourselves is, does the legislation make positive improvements to the administration of justice in our country, even if it's not perfect? If so, then we should probably support it. Thank you, Madam Speaker.
Questions and comments. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Madam Speaker. You know, in looking at the legislation, and I've made reference to this in the past, it is very much recognizing the advancement of technology and why it is that we can actually make our judicial system better by providing this type of enabling legislation that will allow in a very formal way, video conferencing of sorts. And by doing that, one would like to think that we're providing an option, a very viable option that will no doubt get well utilized. And I'm wondering if my colleague could provide his thoughts or further thoughts, because he made reference to technological advancements in terms of court proceedings being televised and so forth, that this is all a step forward in the right direction, and that's one of the reasons why it's so important to pass the bill so we can get it into committee to hear stakeholders.
The Honourable Member for Edmonton Manning.
Thank you for the Honourable Member for his question. I refer to the Justice in a way that hopefully all Canadians have the equal opportunities to use technologies, and that must be provided, especially in rural areas. So that is the level, thanks to technology that is available, that could probably make this bill in specific for better use for Canadians. And to make the justice, we need to be more technologically fit, we need more internet, especially in rural areas.
Questions et commentaires? Questions and comments? The Honourable Member for Skeena-Buckley Valley.
Thank you, Madam Speaker. I want to thank my friend down the way for his speech, for his thoughtful reflections on this bill, and for the insights that he shared with the House. I'm wondering that he had some reservations about the use of video conferencing or teleconferencing for the selection of jurors, and I'm not sure I quite understood what his reservations were. Could my friend elaborate a little bit more on what those concerns might be?
The Honourable Member for Edmonton Manning.
Thanks for the Honourable Member for his questions. I think we've spoken earlier about the cybersecurity. I think that's a bill that's going to be discussed too. And anytime you use technology, there's that risk of someone breaking through to see the selection of juror, which is it has to be anonymous for the protection of the people that get selected to be juror. So that is the reservation. I hope that such bill like this will be equipped with the proper tools, will be on a high-tech level of protection, that when a juror gets selected or people get selected to testify or to witness or to judge, at least they'll have that protection needed, because I think that is in the heart of our judicial system.
Questions and comments? The Honourable Member for Kelowna Lake Country.
Thank you, Madam Speaker, and I thank my honourable colleague for his speech and intervention today. Early on in his speech, he spoke about the delays in the courts and in the justice system, and just how that is playing out and can actually affect communities, you know, while people are waiting, and and so there's a lot of delays, and in fact there might be deadlines that might not be met. So I'm wondering if you can just speak a little bit more about that, just how he has saw that, especially during the time of the pandemic, and if in fact a lot of that has been caught up as the courts got back up and moving again. Thank you.
Honourable Member for Edmonton Manning.
Thank you very much. I think we've heard a lot of stories. In my constituency office, I was approached by several people that they have the same concern over the timing. And I think, again, it's the job of the government and the lawmakers to really provide all the tools needed so we don't face or end up facing these circumstances. And as I said earlier, the justice should be in the justice system itself. That's why it's going to be always demanding to provide the proper tools to make sure that everyone, as I said, get the same equal opportunity. Thanks for the question.
Resuming debate. Is the House ready for the question? La question est la suivante.
The question is as follows. Mr. Lebetti, seconded by Ms. Tassi, moved that Bill S-4, an act to amend the Criminal Code and the Identification of Criminals Act, and to make related amendments to other acts, COVID-19 response and other measures, be now read a second time and referred to the Standing Committee on Justice and Human Rights.
If a member of a recognized present in the House wishes that the motion be carried or carried on division, or wishes to request a recorded division, I would invite them to rise and indicate it to the chair. On division? I therefore declare the motion carried on division. Ordre du jour. Oh, no, sorry, the Honourable Parliamentary Secretary on
Yes, point of order, Madam Speaker.
Yes.
Yes, I suspect if you were to canvass the House at this time, you might find unanimous consent to call it 5:30 so that we could begin private members' hour.
Agreed? So agreed. Orders of the day.
Private members' business, resuming consideration at second reading of Bill S-219, National Ribbon Skirt Day Act, standing in the name of Mrs. Atwin.
Resuming debate, l'honorable député.
The Honourable Member for Abitibi, Bay James, Nunavik, EU.
Oh my God.
Merci, Madame la.
Thank you, Madam Speaker. I am pleased to speak this afternoon on Bill S-219, an act respecting a National Ribbon Skirt Day. This bill was introduced in the last Parliament by the same critic, Alberta's unaffiliated Senator, Mary Jane McCollum. At that time, it was known as Bill S-227. As we know, that bill died on the order paper when the 2021 election was called. The adoption of this bill would therefore create, Madam Speaker, a National Ribbon Skirt Day, which would be held every year on January 4th and which would not be a statutory holiday. The Bloc Québécois is in favour of Bill S-219 because this bill is in line with the general position of the Bloc Québécois, as the Bloc Québécois is committed to being an ally of First Nations, in particular by favouring a nation-to-nation dialogue, and because it's part of the process of reconciliation with Indigenous peoples. In addition, it also respects Quebec's areas of jurisdiction. So to give you a bit of context, Madam Speaker, the ribbon skirt is a highly symbolic garment, something like the orange shirt for the recognition of residential school survivors. The ribbon skirt is a long skirt with colored ribbons at the bottom. The colors used and the design of these pieces varies according to the codes of belonging to different nations, but invariably they show an unshakable pride. So, for example, in Scotland, the kilt, has different colors depending on different groups, and it's the same thing here. For centuries, the ribbon skirt has been a spiritual symbol of femininity, of identity, of adaptation and survival, and it's a way for women to honor themselves and to honor their culture. It also represents a direct connection with Mother Earth and her sacred medicines. So this day would pay special tribute to Indigenous women as life givers who use traditional inherited knowledge to care for their families, their communities, and the environment. The celebration of this symbol would recognize that Indigenous culture, tradition, and ceremonies, including their connection to languages in the land, are critical to the vitality and the well-being of Canada's First Peoples. During debate on this bill in the other place, Madam Speaker, the sponsor of S219 was generous enough to share statements that her office received. And I think it's important that these words be allowed to resonate here as well in the House of Commons, and that's why I will read some of them to you. The first statement comes from a young 10-year-old girl from Saskatchewan, and it goes as follows. My name is Isabella Suzanne Kulak, and I would like to begin by explaining what the ribbon skirt means to me. It symbolizes strength, resilience, cultural identity, and femininity. When I wear my ribbon skirt, I feel confident and proud to be an Indigenous girl. When I was 8 years old, my aunt, Farah Sanderson, gave me my own ribbon skirt as a gift. I wore it with pride and honor at traditional ceremonies and powwows. On December 18th, 2020, a dress-up day was held at my school, Kamzak Comprehensive Institute. I chose to wear my ribbon skirt, as did my older sister Jerry. When I arrived at school, an assistant said that my skirt didn't even match, and on the next dress-up day, I might need to wear another outfit, like one that she pointed out that another girl was wearing. Imagine that, Madam Speaker. Because of those words, I felt like I was being pushed to be somebody that I was not. And this young girl ended up taking off her ribbon skirt because she felt humiliated. And she added, "Now, today, I'm not ashamed. I feel proud and strong enough to move mountains because I know that there are people all over the world who support me. I am so grateful to be Canadian, to be Indigenous, and to represent my people by proudly wearing my ribbon skirt. I thank Senator McCollum and all the people who have supported me around the world, in Canada, and in all the First Nations of all countries." The chief of the Cote First Nation, of which Isabella Kulak is a member, also sent a statement to the Senator's office. It reads as follows. On behalf of Cote First Nation, we are honored to be able to celebrate National Ribbon Skirt Day on January 4th across our great country. Bella Kulak has demonstrated the importance of sharing our culture with other nations. First Nations, Métis, and Inuit women symbolize the gift of life, and their resilience in caring for their homes gives us the strength to persevere. We thank Senator McCollum for bringing forward this form of recognition, and we encourage all parliamentarians to support this bill in this year of truth and reconciliation. We say miigwech on behalf of the Saulteaux First Nations of Treaty 4 territory. So, Madam Speaker, these words confirm that the bill deals with a very important issue for many Indigenous peoples and communities. And so, as the sponsor of the bill said, this bill is about ensuring social justice for Bella and other Indigenous youth who face racism, colonialism, and gender-based violence on a daily basis. Respecting the framework inspired and proposed by the Cote First Nation to establish this National Day of Recognition ensures that family and community tradition and intergenerational knowledge are preserved in the context of the modern struggles facing Indigenous women. This bill would help debunk the colonial image of Indigenous women, girls, and transgendered people. The acts of resistance by women, including mothers, aunts, grandmothers, sisters, and friends, against ongoing violence and colonialism are very important, because these are models that young Indigenous girls can follow. They are gestures that denounce cultural genocide. Mothers and daughters are no longer willing to leave their spirits at the door. They're ready to take the struggle to a different level by integrating ceremony into daily life, not only at home, but also in the public sphere. Madam Speaker, the Bloc Québécois has reiterated on a number of occasions its commitment to be an ally of First Nations. That's why the Bloc Québécois will vote for the principles of this bill, because, among other things, it responds to Article 15.1 of the United Nations Declaration on the Rights of Indigenous Peoples, and it partially responds to the call for justice 15.2 in the final report of the National Inquiry into Missing and Murdered Aboriginal Women and Girls. So, Madam Speaker, I'd like to say that in my riding of Abitibi Bay James Nunavik EU, when I travel from town to town, and when I go, for example, to Val d'Or, I'll often see signs indicating that there are young Indigenous girls who have disappeared, and it's inconceivable. And, you know, what we need to do is protect these young girls. We also see that on social media. It's completely incomprehensible to see the pictures of those who have disappeared. Families are looking for their daughters. It's inconceivable that this is still happening today, particularly to young Indigenous women and girls. And these two articles are consistent with what the Bloc Québécois has been calling for years. We're advocating for reconciliation. Reconciliation is defined as the establishment of a renewed relationship with Indigenous peoples based on the recognition of rights, respect, cooperation, and partnership. In addition, S219 refers to Call for Justice 2.1 of the final report of the National Inquiry into Missing and Murdered Indigenous Women and Girls. And this call for justice calls on all governments to recognize the rights of Indigenous peoples to their cultures and languages as inherent and constitutionally protected rights under Section 35 of the Constitution Act 1982, and to provide for that protection. By supporting the creation of National Ribbon Skirt Day, the Bloc Québécois once again confirms its position as an ally of First Nations, as this day will highlight a distinctive element of Canada's Indigenous culture and ensure greater dialogue on national history amongst the general population. Thank you, Madam Speaker.
Resuming debate, the Honourable Member for Churchill, Coatineau-Kaskiyeh.
Thank you, Madam Speaker. And it is my honor to rise today in support of Bill S219, an act respecting a National Ribbon Skirt Day. I want to echo messages shared by NDP colleagues, including the MP for Nunavut, who said in this House that this is an important opportunity to recognize Indigenous cultures and the prominence of Indigenous women. I also want to make clear that while we in the NDP support this bill, we also are keen to put forward amendments to further improve it. And that's something I will get to in a few moments. It's important to recognize that ribbon skirts are a symbol of strength, pride, and hope. They symbolize a direct connection to Mother Earth and her sacred medicines. Ribbon skirts have become a symbol, not just of Indigenous women's empowerment, but also the struggle for justice for missing and murdered Indigenous women. I think of the many young women, young Indigenous women, First Nations and Métis here across our region in Manitoba that make their own ribbon skirts, that gift ribbon skirts, that sell ribbon skirts, and wear them to ceremony, wear them to powwows, and wear them as a symbol of pride, and I would say resilience, but also reclaiming culture and traditions that were forcibly taken away by colonizers. It is important to recognize the empowering elements of the ribbon skirt symbol and find ways to make sure that it is a formal part of our national narrative. But we also need to be clear that if we're going to talk about reconciliation, yes, we need to be looking at symbols, but we need to go far further than that. And as we talk about the importance of female empowerment and Indigenous female empowerment, we must also act in concrete ways to support Indigenous women across Canada. I have the honor of representing 41 First Nations. I have the honor of working with Indigenous women leaders, activists, advocates, elders, young people, Indigenous women that hold up their communities, that hold up our region, that day in and day out, in the face of immense challenges, do everything they can to keep their communities moving forward. But in order for them to continue to do that work and to do that work effectively, to meet the needs in their communities, there's no question that we need a federal government that's willing to step up and support that work. And unfortunately, we don't have that in this current Liberal government. Let's take one of the biggest crises that Indigenous women, Indigenous communities, and I would say Canada faces, that of missing and murdered Indigenous women. Truly a national tragedy. There is not one community, First Nations, Métis, or urban here in our region that hasn't been devastated by the loss of an Indigenous woman or girl. As others have said, it is unconscionable that in a country as wealthy as Canada, that on a regular basis, we see notices on social media and in our communities of yet another Indigenous woman or girl that's missing or that's been taken. We know that somewhere between 1,600 and 4,000 Indigenous women and girls have been lost in this country in the last 20 years. But we also know that this didn't just happen. And the historic inquiry into missing and murdered Indigenous women uncovered many of the contributing factors. And thankfully, it also made very clear what we need to be doing to put an end to the tragedy that is missing and murdered Indigenous women through their 231 calls to justice. And I want to speak to some of those key areas that we need to be pursuing if we're going to talk about ending violence against Indigenous women and empowering Indigenous women. We need to put an end to the housing crisis that exists in First Nations and urban centers that Indigenous women face disproportionately. On reserve here in our region, it takes the form of third world housing conditions. I've spoken in the House about women and their families that live in remote First Nations here in northern Manitoba, in homes held together in a way by tarps in the middle of winter. I've talked about homes that are overcrowded, mold infested, homes that are making people sick, homes that have devastating mental, physical, emotional impacts. And we know impacts that are disproportionately felt by women. We also know that housing insecurity can contribute greatly to gender-based violence and can prevent women from leaving abusive relationships, even though they would like to. We need to get serious about dealing with the housing crisis that exists in First Nations and Indigenous communities across the country. And this Liberal government is not doing that. We also need to be very clear about the fact that Indigenous women face disproportionate levels of poverty. And I acknowledge the important work of my colleague, the MP from Winnipeg Centre, who's called for a basic annual income, not only for Indigenous women, of course, but for Canadians who are on the margins. But we know that Indigenous women, many Indigenous women, are disproportionately facing poverty in our communities. There are many ways that we can empower Indigenous women and Indigenous communities economically. But right now, we're not taking that seriously. And I would say the investments that are necessary to create jobs and create opportunities in Indigenous communities across our region are simply not being taken advantage of, despite the fact that many First Nations are very clear about the ideas that they would like to bring forward to create jobs and opportunities in their communities. There are also other areas where the federal government is woefully inadequate in terms of action. The addressing addictions and the need for treatment and healing supports for Indigenous women and Indigenous communities. Just some time ago, I was in touch with the minister about yet another First Nation in our region, God's Lake Narrows, that issued a state of emergency, calling for federal action to deal with the addictions crisis, the suicide crisis in their community. A few weeks before that, I spoke out on behalf of Red Sucker Lake First Nation that also called a state of emergency because of the suicide crisis that they are facing. Red Sucker Lake is a First Nation that for some time now, along with other First Nations in its region, the Island Lake region, has been calling for a treatment center that the federal government, while it acknowledged, has done nothing to actually make happen. Red Sucker Lake is also part of the Island Lake region, a region of over 13,000 people, a remote region accessible only by plane throughout the year, that also doesn't have a hospital, forcing people to go out for relatively basic medical care. Again, we know that that reality has a disproportionate impact on women. And if we're speaking about infrastructure, a clear way to empower Indigenous women is to make sure that they have access to the services and the kind of infrastructure that many take for granted outside of Indigenous communities. Proper schools, post-secondary opportunities closer to home, proper hospitals and health centers that can provide the services that are required. And looking beyond that, I would say tracking with the reality that many First Nations are disproportionately now impacted by climate change, further isolating First Nations, rendering crisis situations more and more serious. I've worked with First Nations that have been rocked by wildfires and flooding, clear results of the climate emergency that we are facing. These are communities that have little capacity, if any, to deal with the climate crisis. And we know from, as research has pointed out, this has a disproportionate impact on Indigenous women as well. It's clear that the federal government needs to move beyond symbols and actually commit to action when it comes to reconciliation and empowering Indigenous women. I briefly want to share that we are keen to make amendments indicating that we must not be that Indigenous women not be put in a generalized category, recognizing that First Nations, Métis, and Inuit women have different ways of affirming each other's strength. And also, very importantly, this bill needs to include Indigenous persons whose identities are outside the gender binary and who choose to symbolize the importance of wearing ribbon skirts. Inclusion and creating a safe space for gender discussions for Indigenous peoples must be a priority. And I point to the work of Dr. Alex Wilson, a professor at the UNIVAS who's devoted her career to understanding Two-Spirit identity. There is much work to be done to recognize the strength of Indigenous women, but certainly concrete action is necessary to truly respect Indigenous women and empower them as they are pursuing.
Parliamentary Secretary to the Government House Leader.
Yes, thank you, Madam Speaker. If I may just at the very onset recognize Senator McCollum and our colleague, the member from Fredericton from the House of Commons, who have ensured that today we're actually debating a piece of legislation, Madam Speaker, that I would suggest to you should be receiving unanimous support of the House, and I'm anticipating that it will. I think that, you know, as I was listening to the former speaker, I like to think that it doesn't matter what political party one is from, that they'll understand and appreciate the true value and the meaning of the legislation that is before us, that there is no political party, whether it's the Conservatives, the Liberals, or, in fact, the NDP, that have not conducted themselves purely over the years when it comes to Indigenous issues. And at the end of the day, I think that when we have legislation that we have before us, that it provides us the opportunity to come together and recognize the true value in terms of what is being proposed. recognizing National Ribbon Skirt Day on January the 4th of every year is a very powerful thing to do. It is for a number of reasons, Madam Speaker. We often recognize special days in the year, and we talk about the benefits of doing so. This is something that is very tangible. It's tangible because we all 338 members of the House of Commons, talk about the issue of reconciliation. And a part of reconciliation is recognizing the truth. It is recognizing at the end of the day that mistakes were in fact made. And there are things that we can do to make life better, to make our society better. And when I think of what we have before us today, National Ribbon Skirt Day, I see it as an opportunity for us to rectify, at least in part, many have suggested in a symbolic way, a grave injustice. You know, I wanted just to very briefly read in terms of Senator McCollum, and this is what I was provided, was inspired to sponsor this bill after hearing about an experience of Isabella Susan Kulak from the Cote First Nation, Saskatchewan. On December 18, 2020, which is not that long ago, Madam Speaker, when she was but 10 years old, Susan went to an elementary school wearing her ribbon skirt to a formal day, but was told by the teacher's assistant that her skirt was not formal or appropriate for the day. Madam Speaker, out of that particular incident, a great deal of courage and an understanding by many, we now have before us legislation that recognizes the meaning of a ribbon skirt. You know, it wasn't that long ago at the House we passed a piece of legislation through Truth and Reconciliation to recognize a statutory day of Truth and Reconciliation. And when we did that, Madam Speaker, it highlighted an annual event. Now there's been two, and on both occasions, you know, the first year I was actually in a walk from the Forks downtown Winnipeg to St. John's Park along Main Street. This year it was from downtown again to the Convention Center. And for those that were to take a look or participate in those walks, as I did, you will know that there were many women that were actually wearing a ribbon skirt. The ribbon skirt is more than just a symbol. It is something that is a reflection of life in many ways, intergenerational. From what I was told, Madam Speaker, or from my understanding, you might see, for example, something on the dress with respect to a red ribbon, which is a reflection on the murdered and missing women. You know, and we need to recognize, you know, even though we actually have a red dress day, Madam Speaker, where you will see dresses in Manitoba, red dresses, hanging in trees or in windows of homes, or obviously being worn. Madam Speaker, these are opportunities. And I suspect it's only a question of time before we will see some form of programming that will be taking place. Whether it's in our schools, our community centers, in the workplace, where there's going to be opportunities for individuals to become more aware of why the red skirts are so important. I love the fact, as one time it was explained to me in terms of how a red skirt can be very meaningful in different ways. As I've been able to even do a little bit of research this afternoon and anticipating that there was going to be the opportunity to see this bill actually pass, Madam Speaker. And I recognize, very much so,
that at the end of the day, statutory holidays matter, days of recognition also matter. In fact, Madam Speaker, I would suggest to you that when we recognize those days where there's no statutory holiday, it affords another type of opportunity that might not necessarily be there during a statutory holiday. It's what the community wants to make of it, Madam Speaker. I fully believe that what we will see is opportunities for Indigenous and non-Indigenous people, for people of all backgrounds, Madam Speaker, be engaged and participate, whether it's directly or indirectly, with regards to National Skirt Day. We see that with regards to the National Red Dress Day, Madam Speaker. In fact, there is a lot of residual that carries over. I know of at least a couple of places where I still see the red dresses virtually year-round, Madam Speaker, and there is a message that is there. You know, I had an interesting discussion with a group of young ladies in regards to the red dress and the issue of murdered and missing girls and women. And they indicated that, and I don't know to what degree people really appreciate the fact, but there are still Indigenous girls and women that are disappearing, that are being murdered. Just like we have Orange Shirt Day, Madam Speaker, which somewhat coincides with the statutory holiday. And it talks about residential schools and literally the thousands, I believe it's well over 100,000 students over the years that were taken out of their homes and put into residential schools, and the impact that that had. Culture and heritage means everything. We're very proud of our Canadian heritage, and our Canadian heritage grows virtually every day. And our Indigenous heritage, our First Nation, Métis, Inuit heritage is what enables all of us to be a diverse country that adds to the value second to no other community, Madam Speaker, because it is our first community. We all have a responsibility to understand and have an appreciation. And that's why I think, you know, the idea of the National Ribbon Skirt Day is a positive thing. And I would like to compliment all of those that were involved in making this legislation possible, and a very, very strong shout out to that young person, Susan Kulik, for having the courage to do what she did. Thank you, Madam Speaker.
Resuming debate, the Honourable Member for Lethbridge.
Madam Speaker, and it's truly a pleasure to have the opportunity to stand in this place and to speak to Bill S219. As mentioned, this bill calls for National Ribbon Skirt Day to be declared as a part of our commemorative activity on January 4th of each year. It's an opportunity for so much more than just giving importance to a piece of clothing. It's what that piece of clothing or that article points to. It's what it symbolizes. It's what it represents. It's the power within. And so it's that I wish to speak to today. The ribbon skirt. I believe that to gain an appreciation for this bill, we really have to understand a little bit of history. There's a recent past, there's a distant past, and then of course there's today and a way forward. And so if you'll bear with me, I'd like to just go through a few of my reflections on those items. A few years ago, there was a young girl by the name of Isabella Kulak. She was a young girl from the Cote First Nation, which is in Saskatchewan, and she was a riveting a riveting young woman and continues to be. And she wore a ribbon skirt to school one day. And unfortunately, an educator commented negatively and told this young woman that it was an inappropriate item to wear on what was called, quote, formal day. And so this girl, who was about 8 years old at the time, I believe, was berated and shamed in front of her peers and her teachers. Which is devastating for a young girl to experience, especially not just the action of the beratement and the shame, but the fact that it was so deeply attached to her culture and her history, her way of life. And so the fact that she would be attacked on that, of course, had an impact on this little girl's heart. Her parents very bravely took this story and with courage shared it on social media. And from there, it spurred a movement. It actually captured the attention not just of a few within her city or within her neighborhood, but it actually managed to capture the attention of a country, a nation. And what is so powerful and why I perhaps am brought to tears a little bit in this story is because this young girl demonstrated courage. And supported by her parents, she was able to draw attention to something that is so important in our country right now. And that is the disadvantage that Indigenous folks find themselves in, and the fact that there are still these persisting inequalities within Canadian society. And so as much as it is a ribbon skirt, it is so much more that we would be commemorating through this bill and its call for January 4th to be declared National Ribbon Skirt Day. I wish to share the words of Isabella with the House today and with the Canadian public. She wrote a letter to the senator that with whom this bill originated, or from whom this bill originated. Isabella wrote this. She said, "My name is Isabella Suzanne Kulak, and I would like to start off by telling you what the ribbon skirt means to me. The ribbon skirt represents strength, resiliency, cultural identity, and womanhood. When I wear my ribbon skirt, I feel confident and proud to be a young Indigenous girl. When I was 8 years old, I was gifted my very own ribbon skirt from my auntie. I wore it with pride and honor to my traditional ceremonies and powwows. On December 18th, 2020, it was formal day at Kamsack Comprehensive Institute, where I attend school. So I chose to wear my ribbon skirt just like my older sister Jerry. When I got to school, a teacher assistant commented on it and said it didn't even match my shirt, and maybe next formal day I should wear something else like another girl was wearing, and pointed at her. Those words made me feel pressured to be someone I am not. I eventually took off my skirt as I felt shamed. Today, I no longer feel shamed, and I feel proud and powerful enough to move mountains because I know that people from around the world are standing with me. I am very grateful to be Canadian, to be Indian, and to represent my people wearing my ribbon skirt proudly. Thank you to Senator McCollum and to all the people who supported me from around the world, from Canada, and from all the First Nations across the nations of the earth. Sincerely, Isabella." It's so important to read her words into the record because I could stand here and I could talk about the importance of this day or the significance of the skirt, and I will comment on that to some extent. But what is so much more important is actually the words of this girl who initiated the movement. To Isabella and to many, many, many Indigenous women across this country, the ribbon skirt serves as a powerful declaration of what it is to be female, what it is to hold a feminine spirit, the strength, the power, the beauty, the resilience, the ability to give and maintain life. These are all parts of what it celebrates. The ribbon skirt is about Indigenous culture and tradition, history, and a way of life. The skirt's meaning, yes, it does vary from person to person, and of course, the way that it's put together and the colors that are used also vary from person to person. It's meant to be just as unique as the individual who wears it. Because of Isabella, other young girls and women of all ages are now once again able to wear the skirt as a declaration of their power, their resilience, and their cultural identity. And that is something that is incredibly, incredibly powerful. I would like to talk about the more distant past. And it is again with some sorrow that I do. Because Isabella's actions are particularly powerful when considered against the backdrop of what has happened in this country. In 1885, the Portlack ban was put in place. It actually prevented Indigenous folks from being able to wear ribbon skirts. And so the fact that now this 8-year-old girl bravely put one on and wore it to school is profound. It's profound. Ribbon skirts, along with ceremonial items, were outlawed in that original ban. And so for us as a culture to once again be able to embrace that and to be able to say with a united heart, we accept you, we celebrate you, is so important. Today, while National Ribbon Skirt Day is an important opportunity to celebrate Indigenous women and their incredible strength in the face of colonialism, more has to be done. It is one thing to be able to commemorate culture and history and a way of life and the power that is within women. It's another thing to actually take action, concrete action. In this place, we've heard the government talk a lot about missing and murdered Indigenous women. And in fact, 3 years ago, a report was done. It's significant. We're missing an integral part of our population in this country. What action has been taken? Further to that, we have folks in this country who are living without potable water. And the members opposite enjoy talking about throwing money at the problem, but actually getting it resolved. That hasn't happened. We have a housing issue in this country. Up north, we have 15 people living in a household. We have mold growing up walls. We have conditions that are not okay. What are we doing about that? Furthermore, we have so many mental health concerns that have been expressed by Indigenous communities. They are asking for assistance. They are asking for treatment with regard to addiction. These folks are also asking for a commitment to moving forward in reconciliation. And it takes so much more than just promising funding or delivering good talking points. And so as much as this bill is about the ribbon skirt, as much as it is about the courage of Isabella, as much as it is about celebrating culture and history and identity, it is about also calling this place to a way forward that allows for economic prosperity among Indigenous folks in Canada and allows us to move forward truly reconciled, truly united toward a vibrant future.
The Honourable Member for Fredericton on her right to reply.
Thank you so much, Madam Speaker. I want to first recognize the unceded Anishinaabe territory that we are gathered on this evening, because for the Anishinaabe people, everything is interconnected, and it's a good reminder that the work we are doing in this House also has a ripple effect outside these walls on the lives of every Canadian. And I am proud today and every day because of our collective commitment to making Canada more inclusive and culturally safe. I want to thank everyone who took part in this debate, shared their thoughts, and most importantly told Isabella that we are listening, that her advocacy matters, and that she has the full support of the people of this House. It is indeed a positive message for all Indigenous women from coast to coast to coast. I want to also recognize the member for London West for joint seconding this bill, for seconding it. I forgot to recognize that the first time I was able to speak to this legislation, and I'm essentially grateful for that. I want to celebrate the member for Halifax West for her intervention on this debate and the personal commitment she has made in her own riding. To the member for Manicouagan for her passion and grace. The member for Haliburton, Kawartha Lakes, Brock. The member for Desnay, Mississippi, Churchill River for their support and excellent work in the Indigenous and Northern Affairs Committee, and look forward to further studying this bill there. The member for Lethbridge, who just gave a very emotional address and asking for better for Indigenous people across this country, and I want to echo that. The member for Nunavut for her leadership and collaboration. The member for Churchill, Kiiwetinoong, Aski for speaking about missing and murdered Indigenous women and wanting to put forward amendments, which I'm certainly open to discussing. The member for Abitibi Bay, James Nunavut EU for her meaningful intervention this evening as well. The members for Kitchener Centre and Saanich Gulf Islands for their support and friendship. This is truly a team effort, and these are the good days that we get to be united on something that's so very important and so meaningful. I want to thank once again, of course, Senator McCullum for giving me the honor of being the voice of this bill in the House of Commons. She's an inspiration, and I'm forever grateful for the privilege of bringing forward her work. I look forward to studying this bill in committee and seeing if there is any way for it to be improved, of course. And a final note again to Isabella. Miigwech, you are an inspiration. Look what you've done. Look what you've accomplished. I think you should be so, so proud. And again, it's an honor to carry your voice in this amazing place. So January 4th is just around the corner, Madam Speaker, and I'm hoping that this day will be enacted in time to celebrate it for the first time in 2023. Willie Wynn.
La Chambre est-elle prête à se prononcer?
Is the House ready for the question?
La question est la suivante. Mrs. Atwin.
The question is the following.
Kayabaga moved that Bill S-219, an act respecting a National Ribbon Skirt Day, be now read a second time and referred to the Standing Committee on Indigenous and Northern Affairs. Si un député d'un parti reconnu présent en chambre.
If a member of a recognized party present in the House wishes to request a recorded division or that the motion be adopted on division, I would invite them to rise and indicate it to the chair.
On division, je déclare la motion adoptée.
The motion is adopted on division.
This bill, deuxième lecture de ce projet de loi.
Order. In accordance with Standing Order 38, a motion to adjourn the House is deemed to have been made and seconded at this time. Therefore, the question is that this House do now adjourn. The Honourable Member for Haldimand Norfolk.
Thank you, Madam Speaker. I'm here tonight to ask the government for transparency on one of their government signature policies, the Canada Infrastructure Bank. The bank was celebrated with much fanfare by the government in 2016. The Liberals claimed for every $1 that would be invested, it would yield a return of 4 private sector dollars. Then they even anticipated that with investments from the municipalities and the provinces, that would yield a multiplier effect of 11 to 1. But that was 6 years ago, Madam Speaker, and that has not happened. Now what we see is, sadly, a version of corporate welfare. The taxpayers subsidizing industry products that can be funded themselves. The Infrastructure Bank has failed by almost every standard. Not only has it failed to deliver private sector investments that it promised, but it has never, ever even completed one project. And now we find that a $1.7 billion partnership with Fortis Inc., a North American utilities company that rakes in billions of dollars of revenues every year, that project has also failed. The bank promised $655 million to the U.S.-based ITC Holdings, which is a subsidiary of Fortis, for the Lake Erie Connector Project. The canceled project now was going to be a underwater 117-kilometer long power cable under Lake Erie. It would have also brought in $33 million to the Six Nations Reserved. In fact, Madam Speaker, this line would have run between Pennsylvania and Haldimand County, which is the community that I represent. When the agreement was first announced 1.5 years ago, the government gushed about how it would bring in, it would deliver tons of low-carbon energy, billions in GDP, and hundreds of Canadian jobs. Now that the project has flatlined, this government needs to answer for the millions that they committed. It is completely unacceptable that at a time when Canadians are struggling to put food on the table, this government cannot account for $655 million that it loaned to a multi-billion-dollar corporation. A project that ironically, according to the media reports, failed due to inflation caused by the Liberals. What's worse is that there has been no transparency. It is a statutory requirement that this bank operates with transparency and reports to the public. We only know from local media reports that the project was cancelled back in July. To this day, there's still no information on the bank's website or on government websites about the real status of the project. So where did the money go? Is the money still in the infrastructure bank? Is it with Fortis, the company? Is the money gone? We just don't know. In fact, the bank's corporate plan was tabled in this very House, Madam Speaker, and still lists the deal as an active project and says, final due diligence in progress. This, Madam Speaker, is misinformation. To have the
Honourable Parliamentary Secretary to the Deputy Prime Minister and Minister of Finance.
Well, thank you, Madam Speaker. The Canada Infrastructure Bank was established to ensure Canadians benefit from modern and sustainable infrastructure through partnerships with governments and with the private sector. The bank helps public dollars to go further by investing in revenue-generating infrastructure projects in the public interest and by developing innovative financial tools. Now, with regards to the Lake Erie Connector, which was the subject of much of my friend opposite's speech, it is our understanding from the bank that discussions on the Lake Erie Connector project led by ITC Holdings were suspended at this time. The project itself was planned to improve the reliability and security of Ontario's energy grid and allow access to the largest electricity market in North America. The 117-kilometer underwater transmission line was projected to cost $1.7 billion, with the Infrastructure Bank contributing $655 million. No funding has been provided, but regular and minor administrative costs would have been incurred during the due diligence period. I hope that answers my friend opposite's question. While this project is not proceeding at this time, it is these kinds of ambitious projects that the Infrastructure Bank is pursuing across the country, literally transforming how infrastructure is planned, funded, and delivered in Canada. To date, the bank has advanced over 40 signature projects, committing $8.3 million in capital from the bank, while attracting $7.8 billion in private and institutional investment. The bank is connecting Canadians, creating good jobs, and advancing complex and transformative projects. And by focusing on key priorities such as public transit, green infrastructure, broadband, clean power, and trade and transportation, the bank is supporting a recovery that is greener and more resilient, as well as more inclusive. It is doing all this while empowering private partners to envision quality, high-value projects for Canadians while reducing the financial burden on taxpayers. Budget 2022 reaffirmed the government's support for this innovative financing model, broadening the bank's vital role by including investment in private sector-led infrastructure projects that will accelerate Canada's transition to a low-carbon economy. The bank is also helping to close the Indigenous infrastructure gap through its Indigenous Community Infrastructure Initiative, which provides low-cost and long-term debt financing for Indigenous community-based projects, including the first Indigenous-owned and operated railway in Canada. Madam Speaker, the Government of Canada, together with its partners, is building a better future for Canadians. The Canada Infrastructure Bank is playing a key role in that effort, delivering vital infrastructure to Canadians while creating good-paying jobs and growing our economy. I look forward to working with my friend opposite so that we can identify and deliver more innovative and transformative infrastructure projects for all Canadians. Thank you, Madam Speaker.
Honourable Member for Haliman North.
I thank my friend for that informative answer, and I'm glad that we're finally getting some answers, Madam Speaker, even if we've had to extract it from them, from the Liberals. The bank keeps failing Canadians, Madam Speaker, and it's missing the mark. During these economic times, Canadians cannot afford to be on the hook for bad investments. Conservatives warned from the beginning that the infrastructure bank was not capable of completing this project. We asked reasonable questions early on at committee, such as why does a multi-billion-dollar corporation need government subsidy in order to build this project? Moreover, we asked simple questions like what are the terms of the loan? These questions were all ignored, Madam Speaker. Conservatives will continue to call on the government to respect the only recommendation made by the Standing Committee on Transportation, Infrastructure and Communities, and that is to abolish the failed Liberal Bank and create a winnable
Parliamentary Secretary.
Thank you again, Madam Speaker. The Canada Infrastructure Bank is making significant progress in advancing its goals of attracting private and institutional investments to projects while using innovative financing tools to get more infrastructure projects built for Canadians. To date, the bank has advanced over 40 signature projects, committing $8.3 billion in capital while attracting $7.8 billion in private and institutional investment. The bank is working with all orders of government to deliver more infrastructure for Canadians while reducing the overall financial burden for taxpayers. We're helping to expand Canada's economy while meeting our net zero emission goals through investments in zero emission buses, energy efficient building retrofits, and clean power transmission, generation, and storage. And we're doing this alongside our public, our private, and our Indigenous partners. Thank you, Madam Speaker.
The Honourable Member for Calgary Centre.
Well, thank you, Madam Speaker, and honored to be here in the House today to ask a question that I initially asked back in June again about inflation. And you'll notice that inflation has not abated as much as the government thinks it would have. In June, we were actually at 7.7%, and the latest number is 6.9%. So if you think we're moving down, we're still sticking around that 7%. But one thing about inflation in Canada, where the government trumpets that it's less than the rest of the world, it's because of the way we measure inflation in Canada versus the rest of the world. And I'll ask Canadians, I'll ask my colleagues on the other side of the House, if they actually believe inflation is less here than elsewhere and why they think that would be. Well, the answer is because we measure it differently. We don't count as much for housing in Canada. We use a thing called owner equivalent rent, which has consistently over 30 years underestimated what the inflationary effects of housing are in Canada. But 7.7%, and it continues to go up, 6.9% now. The minister wants to drop taxes on fuel. We hope the minister will drop taxes on fuel. I know a lot of the members in this House say that the issue around petroleum is that the actual companies that produce petroleum are earning excess profits. Well, they're earning profits for the first time in 7 years because the commodity has actually gone up in price. But the last time the commodity cost this much on world markets, gas in my province was worth $1.40 a litre. Now it's worth $2.10 a litre. So there is a disconnect here. Where's that extra 70 cents per litre, that extra 50% uptick in gas? And I'll answer right now, it is of course on the extra taxes and the extra regulatory costs that this government has imposed upon Canadians in order to get the fuel they need to actually get to work, to actually fuel their homes and actually get things done, because energy is essential to getting everything done in Canada, especially our food. Now, 7 years ago was a long time, but Canadians need to ask, why are things getting so much more expensive when the actual cost of them in the world market is the same as it was 7 years ago? Again, taxes. Taxes, taxes, taxes. Now, these are inflationary effects, and I know this government has a number of taxation measures that it builds into gasoline now, which includes the clean fuel standard. The new clean electricity standard is going to actually add more cost for Canadians. But the big one here, of course, is the carbon tax. 7 years ago, what was a carbon tax? Well, I'll tell you, zero. Then it went to $20 a ton. In the last election in 2019, pardon me, the second last election, Madam Speaker, it was, the Prime Minister said we weren't going to increase it past $20 a ton, and then immediately moved it to $50 a ton, and it's going to move up to $170 a ton. But this won't be inflationary, of course. Well, let me give a quick education here. Inflationary taxes are designed to be inflationary. They raise the cost of everything, and that means that things are going to go up in price, and consumers are going to feel it, no matter what this government says. I know they'll say, we give a whole bunch of it back to Canadians anyway. You give a little bit of it back. Yes, there are some Canadians that actually get some of the money they spend back. And think about that churn and burn the government goes through in order to this. Well, let me ask the government to actually think about this and and I'm going to preempt
my respondent here, Madam Speaker, to get past the double think that'll be part of his notes here and saying that we can have our cake and eat it too, because I heard the minister say that in the House here the other day again, that we're going to actually raise taxes on all things Canadians consume, and we won't make it financially punitive to Canadians. That is hogwash, absolute hogwash. When you're going to increase the taxes on Canadians, you're going to make things inflationary. Things are going to go up in price, and therefore you're causing a problem where they're going to pay more for everything they have to buy in Canada, and that is a fact. You can't get over it. Madam Speaker, I've got a lot more to say on inflation, but I know my time is out, and I know my colleague across the way has some kind of response to give to me on this, so thank you very much.
Honourable Parliamentary Secretary.
Thank you, Madam Speaker. And I take a lot of time writing my notes, but to get off of it for a second at the request of my colleague, there was, in fact, a carbon price 7 years ago, just not in his home province of Alberta, but in my home province in BC, there absolutely was a price on carbon. And guess what? During that period, British Columbia had the fastest growing economy in the country at the same time that we had a carbon price. So just some food for thought before I get into my extensive notes. Our government understands, Madam Speaker, that many Canadians are worried about our country's economy and that we are facing a global slowdown due to global challenges of high inflation and higher interest rates. However, it is important to remember that inflation is in fact a global phenomenon. Indeed, it is a lingering result of the COVID pandemic, Putin's illegal war in Ukraine, and the snarled supply chains that are affecting so many people and businesses right around the world. The good news, though, Madam Speaker, is that there is no country better placed than Canada to weather the coming global economic slowdown and thrive in the years ahead. Canada's inflation rate is less severe at 6.9% than that of our peers, like the United States at 7.7, the United Kingdom at 11.1, and Germany at 10.4, and we'll rely on Stats Canada to do those calculations. Also, our country has a AAA credit rating and has the strongest economic growth in the G7 so far this year. That's alongside the lowest deficit and net debt to GDP ratios in the G7. In fact, we've strengthened that advantage over the course of the pandemic, Madam Speaker. Our unemployment rate is also near its record low, and 500,000 more Canadians are working today than before the pandemic. We do appreciate, though, that this is a difficult time for families, friends, and of course our neighbors. That is why we are now moving forward with targeted measures, including new ones introduced in the Fall Economic Statement. For example, Bill C-32 would make the federal portion of all Canada student loans and Canada apprentice loans permanently become interest-free, including those that are currently being repaid. We are also continuing to implement our government's affordability plan, which includes targeted measures worth $12.1 billion. For example, Madam Speaker, with Bill C-31 having recently received royal assent, we are moving forward with the creation of the Canada Dental Benefit for children under 12 in families with annual incomes less than $90,000 who do not have access to a private dental plan. Also, individuals and families receiving the GST credit started receiving an additional $2.5 billion in support earlier this month, and I thank my friend opposite for supporting that measure. These are targeted measures that helps make life more affordable for Canadians who need it the most, while being careful not to add fuel to the inflationary fire. Now, when it comes to pollution pricing, we know that a national price on pollution is the most effective and least costly way of reducing greenhouse gas emissions while putting more money back into the pockets of most Canadians. Climate action is no longer a theoretical political debate, it is an economic necessity. Earlier this month, the Parliamentary Budget Officer published an analysis showing that climate change has and will continue to negatively impact the Canadian economy. Conservatives regularly conflate the increased cost in global commodity prices with the price on pollution, but this is a fundamental error in practice. In BC, for example, the carbon price has increased by only 2 cents per litre over the last 3 years, while the price of gas has increased by over $1. That means Conservatives are regularly ignoring 98% of the real problem. They also ignore the fact that the federal carbon price is revenue neutral and that it actually makes life more affordable for 8 out of 10 Canadian families through the Climate Action Rebate. Thank you, Madam Speaker.
Honourable Member for Calgary Centre.
Well, I know that the first thing I asked for in this debate was for my colleague across the way to pull his head out of his Liberal notes and actually do some thinking on this, because a bunch of what he said is a bunch of, well, am I allowed to say malarkey in this House, Madam Speaker? In any event, let's go through the actual numbers and some of them that I'll have a few minutes to talk about. He talked about the G7. He talked about where Canada performs on a net debt basis. His numbers his government's numbers, his speaking point narratives are far different than any other body in the world that actually measures we are economically in the world, including the IMF, who've just recently come out and ranked Canada far lower than his vaunted expectation of where this country is. And that's because some people know how to count. I don't think anybody on that side of the bench knows how to actually do the math on this. But I mean, if the G7 countries he talks about, Canada is the only G7 country that has not either reduced their carbon taxes because of inflation or done away with them completely. How does he respond to that? Thank you.
Honourable Parliamentary Secretary.
Madam Speaker, you didn't hear it because I said it while he was speaking, but I take a lot of time writing these speeches, so I hope he likes all the effort that goes into this. Madam Speaker, our government has continued to reduce our debt to GDP ratio and has created over 500,000 new jobs since the pandemic. Our fiscally responsible plan has maintained our AAA credit rating and allows us to invest in Canadians while we fight global inflation. Those are independent ratings, Madam Speaker, done by independent experts, and I'll rely on those independent experts as opposed to some of the opinions by the member opposite, although I do respect his opinion. We're going to continue to focus on making life more affordable and growing an economy that works for everyone. It's not just the right thing to do, it's the smart thing to do, and will ensure that Canadians remain in the best place in the world to live, to work, and to thrive. We're going to make sure that we make life better for future generations while we grow the economy and fight climate change at the same time. In fact, it's crucial that we do both, Madam Speaker.
The Honourable Member for Bruce Grey Owen Sound.
Thanks, Madam Speaker. I'm here tonight to follow up on a question I asked the Minister of Seniors a few weeks ago, and I make a note that I actually represent one of the oldest ridings in Ontario demographically, and so here's the question I asked the Minister of Seniors. I'm looking forward to her response tonight. Massive Liberal deficits have caused 40-year high inflation, resulting in major increases in the cost of living. I have many seniors in my riding, like Kathy, who at 68 years of age has had to go back to work in order to pay for utilities, food, and make her mortgage payments. As well, a disabled constituent emailed me a few weeks ago indicating she's down to 1 meal per day due to inflation and gas prices, and in her words, is contemplating applying for assisted death instead of starving to death. So my question to the Minister tonight, Madam Speaker, is what is the government doing for seniors 65 to 74, and will the Liberals stop punishing them and cancel all tax increases on gas, groceries, and home heating? Unfortunately, when the Minister replied to me a few weeks ago, Madam Speaker, she focused more on attacking the previous government. She seemed to have forgot that the Liberals have been in power for 7 years, going on the better part of a decade, and that my question is about specifically what actions they're taking now and moving into the future. So it's just simple. I want to understand what the Liberal government's doing for those seniors 65 to 74 and give me a list of concrete measures that support those in that demographic. And secondly, will the government stop punishing seniors, especially those living with disabilities, by committing to no new tax increases on gas, groceries, and home heating? But let me just use, not my words, Madam Speaker, but the words of my constituents. Here's some of the emails that I've received over the last 6 months or so. Back in June, quote, once again, the Finance Minister has forgot about seniors 65 to 74. Do they want us to go back to work? Unquote. Another email in June, in an email that was sent to the Prime Minister and a number of cabinet ministers. Quote, it appears now that I am a member of the second-class Senior Citizens Club, as I am in the age group of 65 to 74. Not 75, age 75 and older are going to get a 10% increase in their OAS. I am not. Why are we in the 65 to 74 age group being discriminated based on age and not getting this 10% increase? Unquote. Another email in September, and this is actually part of an official from the Minister's Seniors Department reply to one of these seniors asking the government directly, replying to a senior. Quote, in July of 2022, the maximum OAS pension increased by a whole $18.16, unquote. My constituent replied to the official with this, quote, it does, however, provide little solace to the many Canadian seniors who are struggling with high rates of inflation. I was hoping for some concrete new measures to be brought forward to assist the seniors who I know that continually struggle with their finances in light of the recent increases in inflation, unquote. Another email in October. Quote, ages 75 plus received an increase. Why us, age 65 and older, received zero? Why are we being neglected? We face high cost of living and expenses also. We appear to have been forgotten about, neglected, and are treated as unimportant by the Liberal government. This is unfair, unquote. And finally, just in November, we as seniors on fixed income are feeling the pinch with extra costs for pretty much everything, unquote. Madam Speaker, food bank increases across this country are up for seniors. We got seniors having to refinance or remortgage their houses and their property in order to pay and live in this country, and it's unacceptable. So in conclusion, Madam Speaker, what is the Liberal government doing to help seniors, especially those 65 to 74 and those living with disabilities, to eat, heat, and live so that they're not turning to medical assistance and dying as a solution? Thank you, Madam Speaker.
The Honourable Parliamentary Secretary.
Thank you, Madam Speaker. I'm glad to be addressing a large variety of topics this evening. Our government understands that elevated global inflation we are experiencing is a major issue for all Canadians, including seniors, and that many are struggling to make ends meet. There are higher food and energy costs due to the Russian invasion in Ukraine, as well as longer-lasting impacts from supply chain disruptions due to the pandemic. That said, I'm sure the member for Bruce Grey Owen Sound has noted that inflation is decelerating in Canada. It was 8.1% in June. It is now at 6.9%. This is lower than the United States at 7.7%, the United Kingdom at 11.1%, and the Euro area at 10.6%. Still, inflation at 6.9% in Canada is high, and we know that Canadians are experiencing higher costs of living when they go to the grocery store, when they fill their tanks, and when they pay their rent. This is why our government is supporting Canadians who are affected the most by inflation. For example, we doubled the GST credit for 6 months, and I thank my friend opposite who gave the speech for supporting that particular measure. This will deliver $2.5 billion in additional targeted support for roughly 11 million households, and interestingly enough, over 50% of our seniors in Canada, those that need it the most, will benefit from this particular measure. I'm certain my friend opposite will agree with me when I say that Canada owes our seniors a great deal, which is why our government takes retirement security so seriously. It is also why I get nervous when the Conservative Party of Canada repeatedly asks for us to reduce costs of government by shrinking the future pension benefits for seniors. It is simply not a responsible policy. On the other hand, we think it is very important that the Canada Pension Plan, the Old Age Security Pension, and the Guaranteed Income Supplement continues to be indexed to the Consumer Price Index. This means that seniors do not have to worry about the value of their benefits keeping pace with inflation, because as costs increase, so will their benefits. This is very helpful for seniors, especially if they are on a fixed income. Small changes in income can make a big difference. That is why the Conservative plan to increase the age of eligibility for OAS and GIS from 65 to 67 was so harmful. It literally took thousands and thousands of dollars away from seniors right when they needed it the most. Fortunately, our government reversed these measures that were introduced by the Conservatives, and Canadians can count on receiving their benefits at 65 as previously promised. We also increased the maximum GIS benefit for single seniors aged 65 and more who needed extra help, and we permanently increased the old age security pension by 10% for seniors 75 of age and older, and that will be waiting there for all of us when we get to that age, Madam Speaker. This means increased benefits for more than 3 million seniors and more than $800 in new support for full pensioners over the first year. Madam Speaker, this is in addition to numerous programs that support seniors and our healthcare system right across the country. While there is still more work to do, Canadians should know that there are 25% less seniors living in poverty today than when we took office in 2015. I think that is a trend that we can all support in this House and that every party can support, and I look forward to working with the member opposite to do even more to support our seniors and to further strengthen retirement security for future generations of Canadians. Thank you, Madam Speaker.
The Honourable Member for Bruce Grey Owen Sound.
Thanks, Madam Speaker. The Parliamentary Secretary didn't really answer any of my questions. He talked about a GST rebate that we did support on this side of the House that's going to all Canadians that are in that low-income tax bracket that receive it. But it's not specific to those 65 to 74. And that's really the focus and crux of my question. What is the government doing for that specific demographic, those with disabilities? And as well, I appreciate if the member didn't mislead the House, mislead Canadians talking about Conservatives calling for, gutting the CPP program. That is not the case at all. We've asked to freeze the premium increases. If the member could answer another question, does that money of those premium CPP increases go into the CPP fund or into general coffers? It's one thing if it was being protected, but the fact of the matter is it's going into general coffers being spent on a bunch of other things. He talked about the OAS increases for those 75 and older, $18.16. So again, Madam Speaker, what's the government doing?
Secretary.
Happy to address those particular questions, Madam Speaker. We are focused on making life more affordable, especially for our seniors. I think the point of talking about the GST benefit was pointing out the specific point that while it's going to 11 million households, disproportionately the seniors that need that benefit are getting it. In fact, over 50% of seniors in Canada are getting it. I also talked about how OAS, GIS, and other important benefits are all indexed to inflation. And you get that at whatever age you are when you're collecting that. So as people are dealing with the price of gas going up, the price of food going up at the grocery store, they can trust that those benefits are in fact going up as well. And when it comes to CPP, if you are putting forward a policy that is reducing the benefits that are going into CPP, then you are putting at risk the future benefits that we worked so hard with premiers all across the country to put in place so that we could increase future pensions by up to almost 50%, Madam Speaker.
The motion to adjourn the House is now deemed to have been adopted. Accordingly, this House stands adjourned until tomorrow at 10 a.m. pursuant to Standing Order 24-1.